all set? Okay. Good afternoon, everybody, and welcome to the City Commission Conference Meeting this 18th day of February 2025. We have a number of exciting things to talk about this afternoon, and thank you all for being here. We begin by addressing the communications that were sent to the City Commission. The first one was sent to us by the Beach Business Improvement District Advisory Committee, and the communication that was sent to us was to expand the advisory committee to include all top 10 highest contributing properties as members, and that would include additional hotels. And Ina Lee, are you here on behalf of the committee? You want to come up and talk to us a little bit? Yeah, take your time. And you're still in heels. Boy, you're brave.
Good afternoon, Mayor, and obviously everyone else, Vice Mayor and the commissioners. I'm Ina Lee, and I own Travel Host. I serve on the Beach Business Improvement District, and I've been very deeply involved, I think most of you know, on the redevelopment of beach since 1984. In fact, I was instrumental in the creation of the bid. And for those of you that weren't around back then, it was created because the CRA, which I also chaired back then, was limited in its scope. It could only do capital improvements, and we needed additional marketing out there on the beach so that the beach could thrive. And so the bid was created. And to be clear, this is their money, okay? The way it was set up, obviously you all approve it, but everyone, the businesses on the beach contribute to it, and that's their dollars. So in the beginning, when it was created so 7 of the top 10 contributors served on the board. But things have changed since then. And we, as a board, felt that it was important to include all 10 of the top stakeholders. And what that does for us is open up hotels like the Conrad to be on the board, also the Hotel Marin, Marriott Beach Place, those are the other 3. And it gives us additional scope on the beach. And we felt that was very important. And so this is a unanimous decision recommended to you to expand the scope of it, because also what happened back then in the beginning, there were no term limits put on. So all 7 of the top 10 properties have never gotten off the board. So it doesn't allow anyone else to be on. So we're respectively asking you to approve this so we can expand it and continue to do the marketing. And those of you that don't know, our job is to market the beach. We've also helped supplement the city in terms of cleaning up the beach. We fund events like the Air Show in Tortuga and other major events on the beach. And we have our own advertising campaign to bring business to the beach. So I'm happy to answer any questions. But just so you know, this is something that we all agree on, and we felt it was important.
Okay, anyone have any questions of Ina? So what would be the process going forward on this?
I think I need clarification because I'm hearing the item speaking in terms of expansion of the district, but then when I hear Ms. Ina Lee speak, it's with regards to the actual board composition. So if I can get clarification on...
You don't want to expand the geographical area.
No, this is just expanding. So all 10 of the top contributors
instead of the top 7 of the top 10, all 10 of the top 10 would be members of the board. So we would need an item on the agenda to increase the membership of the bid to include the top 10 hoteliers, not just the top 7 of the 10.
Sure. So it would just be amending the ordinance or resolution that sets up the board composition of the bid.
Exactly. So that would come by way of a resolution, which would have to be done at a city commission meeting, correct?
That's correct. All
right. So maybe not you can either do it as a walk-on tonight, or if you want to just do it next time. Okay, we'll take care of that. Anyone have any questions, any concerns or okay?
I have a question. I'm sorry. Identify the other 3 hotels that will be added to it. You said 3 more.
Well, every year we get a report of who the top 10 are. Mm-hmm. And so these include the 3 that are missing from that. So it's the Conrad, mm-hmm. The Hotel Marin, and the Marriott Beach Place.
Thank you.
So,
Okay.
so for clarification, it's the top 10 contributors. So as you said, historically that hasn't changed, but it may change depending on who those identified individuals are. So the language will continue to state that instead of identifying particular.
Right. So isn't the Marriott Courtyard Marriott Beach Place?
No.
It's different?
Yes.
No, it's a Marriott Beach Place, okay? And it's the Hotel Marin and Conrad. That's for right now. Now, again, every year it could change based on who the top 10 contributors are.
Right.
Okay.
The courtyard's the one further down south by, like, Swimming Hall of Fame. That's the court.
Oh, that one. Okay. All right.
Right.
I'm sorry?
No, I was just telling the mayor because he needs to take a tour of the city. I'm just explaining to him the difference between Marriott Courtyard and Marriott Beach Place Tower.
Okay, got it.
He used to be the district commissioner.
Okay.
It's too rich of an experience
It's-
for me, so I can't.
I know.
You have to
Anytime you want to drive around,
Thank you.
you let me know.
Okay. Okay. Thank you.
Anything good? Okay.
Thank you.
Thank you for your consideration.
Okay, the next communication is from the Northwest CRA, and this motion was sent to us. Let's see. This has to do with extending the CRA and making the recommendation that the city extend it. And I think the commission, during its goal-setting session, had agreed to extend it based on certain parameters. So I think we've kind of responded to that. And there should be no additional action needed to be taken by the commission. And then the Education Advisory Board, the motion was made.
And Mayor, we do have some members of the Education Advisory Board here that
Right.
are ready to present.
Yes, who's here? Hello, Pamela.
Good afternoon, Mayor and City Commissioners. I am Pamela Aiken, representative of the Education Advisory Board. I'm also a Broward County school board member, school board employee as the Brace Advisor, known as High School, College, and Career Counselor. Education is so important. All of us in this room do have a high school diploma. With that being said, we are excited that we're invited to speak with you all regarding scholarships. We have done our research, and Fort Lauderdale is not a part of a high school scholarship, and today we want to propose that. I can name a few cities: Lauderdale Lakes, Parkland, West Park, Deerfield. So today, the program we want to propose is to all the high schools here in the city of Fort Lauderdale. We have qualifications, the board members, we have written those, and we will do a partnership with Broward Education Foundation to match our funding. We're only asking for 2 winners from each high school, and each winner will get $1,000, so that's a total of $12,000 we're asking for. And if you have any questions, I'm here.
So, anyone have any questions on this? Do we have any money?
Yes.
So if the commission gave
That's
us
my first
direction,
question.
if the commission gave us direction, we'd bring back a budget amendment for the $12,000 at the March meeting and get
Okay.
that started.
Anyone have any comments or questions regarding this request? I think it's a wonderful idea. I don't
Thank
know.
you.
It's a small start.
Yes.
Comment.
Yes.
I am in agreement. This is a great suggestion recommendation that we, the commission, asked to move forward on. I was surprised to learn that we, the city, did not offer scholarships to our students, to our scholars, as the word that's being used now. They're calling our students scholars. So I think this is a great opportunity, and we should do whatever we can do to make this happen. So I stand in agreement and support.
Any other comments or questions?
I do, Mayor. Thank you, and thank you to the board for all of the work that you do.
Thank you.
The Education Advisory Board is a very important board for this commission.
Thank you.
I was thrilled when we were able to really beef it up a few years ago. Also hire an education officer. So
Yes,
we're very committed to education.
Thank you.
Let me ask you this though: do we have a commitment from the Broward Education Foundation that they stand willing to match? We know that's a definite.
Yes, we do. Susie, you're in communication with Broward Education Foundation?
Good afternoon, Susan Leon, Chief Education Officer. Thank you so much for having us here today to give you this information. We have been communicating with the Broward Education Foundation. Those of us that have been in the school system are very familiar with their practices. They do a matching program. So they do that through Florida Prepaid. Therefore, if we provide a $1,000 scholarship to students and we partner with the Broward Education Foundation, that scholarship will actually be worth $2,000 because they kick in the other amount in an agreement they have with the Florida Prepaid program.
That's great. Thank you. And how many cities right now are offering scholarships in Broward County?
There are at least 7 others that I'm aware of that already provide scholarships. They're not all through the Broward Education Foundation. Some do it differently. For example, I saw one that does it using parking ticket money. So it just depends on each municipality. But we're a little behind in providing this opportunity.
And is $2,000 roughly the amount that is given as a scholarship per student?
You mean in the other municipalities?
Yes.
It varies. I saw some less. I saw some up to 5,000. It depends.
Okay. Well, thank you. And again, thank you for your work. Thank you, Mayor.
Ben, did you want to say anything?
Yeah, thanks, Mayor. Thank you. This is great. So just some very basic questions. Is this college scholarships?
Thanks for the question.
Yeah.
No. 2-year, 4-year, trade school or technical school.
So all the above, 2 years,
Yes.
4-year. Great.
Yes.
Awesome.
Secondary school, continuing education,
Yes,
post-secondary, continuing education.
Yes.
Great. Is it, so it's awarded to, I'm assuming it's awarded to a high school senior then?
Yes.
Okay.
Graduating high school
These
senior.
will all be 12 high school seniors. Excellent. And so the scholarship would just be available then for their first year? Or can
Yes.
they come back and apply?
We have not agreed as a board yet.
It depends on where they go and the cost of their education. So in some cases, it would pay for 2 semesters. In some cases, it might pay for more.
Right. Got it. But then could they come back as second-year students in college or trade school seeking the scholarship, or is the scholarship just for seniors to apply for?
So currently, what we're putting forth to you today is for high school seniors.
So just be
this
for
time.
seniors, so you'd get it for...
We can always expand it once we get started.
Yeah, great. And is it needs-based, achievement-based, combination of factors?
We did not want to, the board did not want to solely base it on academics. So it is more about the well-rounded student. And it provides, I would say, the more important factor was community service.
Oh, community service will be a determining factor in evaluation.
How is this selection going to be made from the 6 schools? Who is going to make that selection?
The applications will be distributed to the schools, and Claudette of Broward Education Foundation will let us know, and we will take it from there.
No, but I mean, we're only going to be choosing one person in each of the 6 schools, right?
2.
Oh, 2. And who is doing that selection?
So the Broward Education Foundation manages the application process, and once they have eligible applicants, they will send it to the board for the board to choose. The board has identified an application criteria that they've already sent to the Broward Education Foundation in preparation for the process. Okay. Currently, we have not identified a GPA. We need to talk about that at our next board meeting. But we did identify that our main passion was for community service. So the board will choose, unless they would rather have the Broward Education Foundation do it.
Okay, thank you very much.
And we'll be sharing that criteria with the commission when we bring the item back, because we have to bring back an agreement with the Education Foundation. So we'll have that as part of that backup for that CAM.
Thank you all.
Thank you. Any other questions?
Thank you.
There being none, thank you so much.
Thank you.
Thank you.
Okay, we're moving on to business one. This is a police department headquarters project update. Who will be giving that
And
presentation?
Anthony Fajardo is coming up, and he'll have representative from WJE with him as well.
Good afternoon, Mayor, Vice Mayor, members of the Commission. Anthony Fajardo, Assistant City Manager. So I'm going to be giving a presentation that's going to, at the beginning, go through just some of the background history, but we're going to jump right into the peer review section. And then at the end of the presentation, I have an overall general update. Before I get started, I did want to recognize that we do have AECOM and Thornton Tomasetti represented in the room. They're over the back. If you guys could just wave your hands. And then also, I wanted to just put a face to the name, Ron Stein. Ron, if I could just ask you to stand up real quick. So Ron was brought on to help us with the project management. He's been instrumental in keeping us on time and as on budget as we can, and try to keep this thing moving so we can get into the building as soon as possible.
Is he our Doge representative? No, just kidding.
No comment. So just real quick, again, the deflection summary, we'll go over the peer review, the general project status, and if we have any more questions that haven't been answered through the presentation, we can definitely do this at the end. Just a little bit of background. Again, the deflection was identified in March of 2024, so we're getting close to a year with this now. Corrective designs were done that same month and implemented, but in April of 2024, we determined that the deflection issue is not resolved and a stop work order was issued. We brought in our first third party for peer review and co-development of rectifications with LYE, and they provide their initial report in May of 24. In June of 24, temporary shoring was installed and additional designs for instructional enhancements were under development. In July, supplemental recommendations were submitted to the Building Services Department for review. And in August, AECOM, Thornton Tomasetti, and LA submitted those designs for permit review. We also started interviewing other firms for additional peer review at the request of the City Commission. So we interviewed 4 firms. We were asked to look for national firms that had experience in this. And we landed on Weiss, Janney, and Elster Associates, WJE. In September, we started coordinating with WJE. In October, their contract was signed and they officially started phase 1 of the project. And I'll get into the phases in just a minute. The WJE phase 1 report was completed at the end of December, and the peer review for phase 2 began in January of this year. So a little bit about WJE. They were founded 65 years ago. They're an international firm, and they live in the space of investigation, analysis, and testing and design of structural repairs and retrofit solutions. They've conducted over 175,000 investigations worldwide, and some of the selected relevant projects are on the screen. The closest ones to us would be the FIU Bridge and the Champlain Towers. However, they've been involved in several high-profile reviews and analysis. And records. Yes, sorry, I didn't mention that. Much closer, yes. So phase 1. Phase 1 was just the deflection area, which I'll have a slide on the screen in just a second. But the report addressed the scope, the findings, the project background, document review, site visits, structural design, measures that were implemented and measures that are planned to be implemented, a discussion of findings, and additional comments and recommendations for consideration. Just to orient you, the top of the screen is north. The kind of orange-yellow line with the arrows represents approximately where the deflection occurred and the direction it occurred. Phase 1 is only that section. However, phase 2 will include the remainder of the building. So right now, I'd like to ask Brent to come up and he can start talking about the summary of findings, and if there's any questions, we'll be happy to answer them during the presentation.
Thank you, Anthony.
Thank you for that introduction, Anthony. Appreciate that. And thank you to the city for placing your trust in us to do this review. Our findings are briefly summarized here, and they're broken down into what we would call the roof beams, third floor beams, and then third story columns and first story columns and foundation. And so these findings are basically from our report, And for the roof beams, we would concur with findings of others that the roof cantilever beams were not fully code compliant in the original design, and that the previous rectification efforts did not fully bring those beams into code compliance. We found that the beams at grid lines H and J, we still have some concerns or questions about those and as it relates to their code compliance. But we did find that the spandrel beams north of grid line 2 or on that north elevation were code compliant.
Thank you. What about those beams was not code compliant?
So it depends on which step you're looking at. In the original design, there were issues related to both strength and deflection. As it gets later into that, we still have some questions as it relates to strength and how we've analyzed those beams. But that's where things stand at this time.
Could I back you up on that? So,
Sure.
And maybe this is not a question you can answer, but how did we wind up something that wasn't code compliant? And again, I know that you're not the ones who designed it. This probably needs to be, towards AECOM and Thornton Tomasetti. But I'm just wondering, just in general, and maybe this is staff that can tell me how we wound up with a design that wasn't code compliant.
So, Commissioner, the best way I think I can answer that is when staff reviews any plans that come before the department, so in this case, the Building Services Division, I think is what you're referring to. So they're going to look at anything that's related to code compliance for the ULDR as well, which is ours, right, as well as the Florida Building Code. Anything else that is stamped and sealed by the engineers, our Building Services Department, they're not engineers. They're looking for those stamps and those seals, a certification that those meet those code compliance requirements. If there's anything that needs to be done past what they see because they suspect something else might need to happen, they may send a comment to the engineer of record or the architect of record for clarification purposes. But that's generally how it works.
Okay, thank you.
So, Anthony, I mean, they were stamped incorrectly?
Well, they would have been signed and sealed by the architect of record as meeting the requirements that Brent is referring to, which are engineering standards that are held. Correct. Yeah.
So typically when an engineer or architect would stamp or sign a building plans, that's their sort of testimony, if you will, that to their understanding and knowledge that that design meets the building code. In this case, it appears that even though they initially believed that, that was not later found to be the case.
Okay. So I know you probably get there, but I mean, my next question is going to be, how do you correct installed beams that are not meeting the strength and size specifications?
And that's part of the presentation.
Should we answer that through the presentation? Okay.
You can just keep going. Yeah, thanks.
Thank you. As it relates to the third floor beams, we found that those beams, both the cantilever beams and the spandrel beams at the north elevation, were code compliant. And visually, just to understand where that's at, this is a plan view of the roof. The two beams that remain are still, from our perspective, we have a little bit of questions about, are the two cantilever beams here. But the spandrel beams, which is the beam that runs kind of east to west along that north elevation, we believe that that is okay. A little better view of on the third floor where those beams would be at. Now, as it relates to beam deflection, we evaluated as best we could with the information that we had what we thought that those deflections would be. And ultimately, we're putting it back into the engineer of records court in that no matter what the deflection is, it needs to be accounted for the design of that window wall. And we understand that there's ongoing monitoring of that, which I believe there's some questions as it relates to that from the commission. But that is, we've looked at that, and we have been informed by Thornton Tomasetti, the engineer of record, that that will be accounted for before that final installation of the window wall.
What does that mean, accounted for?
So there have been ongoing monitoring efforts to understand how much it is deflecting. They have done predictions of what that should be over time. And then based on the relative deflection, total and relative deflection between the two levels, then you can establish what dimensionally, what that's supposed to be between the levels, and design accordingly for the windows that have to fit there.
Okay, and there's a guarantee that that will be permanent and there will be no consequences with the change in the design?
When you say guarantee, what do you mean?
Well, I mean, how long is this redesign going to last? Let me tell you something. We've all traveled around this country and around the world, and this design is not rocket science. This has been used over and over again. The Romans used it, okay? They don't have deflection issues. How do we have a deflection issue in this year 2025? It's not so difficult to design something in such a way that its stability is going to be relied upon for the next 20, 30, 40 years. What is the city going to get in terms of guarantee that this redesign is going to ensure the integrity of this building?
So,
can you answer that?
I'll attempt to answer your question. You can tell me if I can answer it, if I've answered it.
Do you understand my question?
I think so.
Okay.
But I'll attempt, and you can correct me or ask again if I don't get it correct. So as it relates to understanding, predicting, and knowing the deflections, if we have that other figure, it might be helpful to show that here. And while that's coming up, we've been designing with concrete structures for, centuries, but yet predicting deflection still remains one of the most challenging things we can do in concrete. And there have been studies after studies after studies. And this chart that's shown here is sort of what the building codes has settled on in predicting how concrete deflects over time. So we think of concrete just, we put it there, it deflects, it's done. But that's not true. It moves over time. And so we need to predict what that deflection is so we can estimate where it's going to end up, because that's what really matters.
I just don't want it ending up in the street.
Right.
I mean, there has to be some. Why don't I just let you continue, because I think you're going to talk about remedial measures, and let's just see what those consist of.
Sure. So, Mayor, one thing I would point out on this is AECOM and Thornton Tomasetti have said they wanted to monitor deflection for 57 months. If you look on the screen at the bottom, you see 0 to 60 months. The reason it was 57 is because there were 3 months before the deflection was realized, right? So the total would be 60 months. So that's where that number, overall number, comes from. I just wanted to see if I could maybe clarify that, because I think there's been some questions of why 57. It sounds like a strange number. It's really 60 based on the original pour of the concrete, and I see Tim shaking his head. So,
okay. All right.
Where's this graphical analysis come from?
It's from the American Concrete Institute, I think.
This is from the concrete code. And in the concrete code, they describe how to estimate deflections, both immediate, but then we know long-term concrete will creep or move. And so this is a chart or curve that says, well, based on how long it is in the future, this is how much more we think it's going to move. And I think what's important to realize is that movement essentially levels off over time.
So if it's going to move, it's going to move in the first 12 months in any appreciable way.
That's
and
right.
then after that, it starts to kind of curve off. Okay.
That's right. And if there's any bright spot in all of this, it's that, as engineers, we would often prefer that the building would sit for a bit before you put the finishes on it, because it would improve the performance of the building.
It's going to settle.
And construction often doesn't allow that to happen, so we just try to estimate it. But with this curve, we would expect it to level off and there to be no appreciable continued deflection after 5 years.
And so, Anthony, you said who's going to monitor it for 57 months?
AECOM.
Okay, and so monitoring is one thing, then actually doing something about an issue that presents itself is another thing. So who's going to shoulder that cost?
So I would probably prefer that AECOM get up and address that directly, since they've been the one in conversations about that. And we can definitely bring that up. You want to talk about it now, or would you rather?
Yeah, I want to talk about it now because,
Tim or David?
Monitoring really doesn't do much if there's an issue.
Mr. Mayor, Vice Mayor, and Commissioners. I'm David Didier. I am the Chief Operating Officer for AECOM's East Region. I'm happy here to talk about this. This is a very important project for AECOM. Obviously, we have a very long history with your city, and we want to continue with that. This is a mistake that we are fully committed to rectifying. And so we're working very hard with our sub-consultant, Thornton Tomasetti, to make sure that a fix is made that's permanent. We're very happily working with your outside engineers to make sure that we all agree what is getting done, how it is going to make sure that the long-term serviceability of this building meets your needs as you should be getting. We are committed to make sure that you are financially made whole for this. We are going to take full responsibility for paying the cost of the fix for what we're responsible for. So with that, we want to continue. We want to make sure that we all work to understand what the cost is. We want the main two things that we would like, if I can put that forward, is that we just want to make sure that we can review that, what the costs are, and secondly, that we want to typically, with any issue, we want to wait till the project is over to make sure that we fully understand all issues with the building. Going back, I think, to the question that was asked was the monitoring and how are we, if something else comes up with that. Mm-hmm. And we're not going anywhere. We're going to continue to monitor the building for the 5 years. If something comes up within that 5 years or even at the very end of the 5 years and it hasn't met its needs, we're going to have to address that and work with you on that. So we're not going to go anywhere. We're going to stand by this building, and we're committed to it.
So who's going to shoulder the cost if something happens in those 5 years due to deflection?
AECOM will take full responsibility for anything that is associated with us.
Okay.
Yeah.
Thank you. I appreciate that commitment. Thank you.
Okay.
Great. Thanks, Anthony.
Andres, can we get Exhibit 1A back up?
Susan, is that going to be memorialized somehow or de-wane that commitment during that 5-year oversight for AECOM's correction of any issues?
Absolutely. I think they were working on an acknowledgement letter that was going to be incorporated as part of the agreement, and we'll bring that back to you when we have it.
We certainly have it on record today, but yes, I agree it should be in writing.
Great. Thanks, Mayor. Thanks, Susan. Great.
I think maybe one previous slide we were right at deflections. So moving on from deflections to the third-story columns, we had found that we felt like that there were design issues with all 4 third-story columns at grid line 2, and that previous rectification efforts didn't fully resolve those design issues, in particular as it relates to code compliance for shear strength and then code compliance for flexure at certain locations or under certain specific modeling assumptions. For the first-story columns, we agree with the findings of both LYE and Thornton Tomasetti that rectification measures are necessary to achieve code-compliant strength, and we were presented with repair designs for that, and we made minor additional recommendations to those repair designs for those first-story columns.
So essentially, we're going to put larger footings in the ground to be able to sustain the weight.
So as the forces flow down through the columns into the foundation, my understanding is at this point there will be both additional piles installed and an additional pile cap to tie those piles to the column to bring those loads from the column into the foundation, into the soil.
Okay.
And that's the part of it.
These issues are separate from the deflection, correct?
Correct.
Okay.
But I think they were caused by the
It's in the same
weight.
load path. As you follow the loads down through the building, it's chasing it through and making sure that each step and each piece of that has sufficient capacity.
Right.
So the extra weight from the concrete is being held up by the enlarged footings, the pilings in the ground.
Got it. So when we talk about monitoring deflection over time, we're talking about the impact, not only where the beams are, but also the impact on the columns, right? It stems from the upper levels.
The impact certainly does. The deflection monitoring is primarily for the beams because of how that impacts certain aspects of the building.
Right.
But as it relates to the problem and how it flows through the building, yes, it impacts each of these levels.
Got it. So with that, then I'm assuming we should be monitoring the columns, footings, and so forth, right?
So if there were any settlement issues related to that, they would likely show up in the deflection monitoring that's happening at the upper levels. If there's any sort of interesting differential or if they're both moving together, that would be a clue that maybe there's some settlement at the foundation that's there. I'm not sure that separate monitoring needs to happen to address that issue. I think it will be picked up in large part by the existing monitoring program that's in place.
Okay. Got it. And from AECOM's perspective, just want to make sure I'm tracking the if any, during that 5-year period, any impacts caused by the deflection, AECOM would cover not only those upper beams and support, but also all the way through. Is that your understanding?
It's my understanding that anything that in these rectifications does not, let me rephrase that, anything that's in these rectifications is a component of additional deflection, AECOM would cover that. And I see them.
Great. Got it. Okay. Just want to make sure I'm tracking all that. Okay, Susan, so that'd be part of our, great. Okay, thank you. Clarity.
My question, he's saying we're going to monitor over this 5-year process. What exactly does that look like? What is there some type of device that's going to be put there that we're going to watch it, or someone's going to go with a magnifying glass? What does it look like so we all understand that?
It's basically a laser, from what I understand. There's a monitoring device installed. I don't know, Tim or someone from Thornton can kind of explain what that is. I've never seen the device.
My understanding is survey measurements.
So you would use calibrated instruments to do a survey of the building, and we do this with a multitude of different projects, just as part of our regular, building process. So, for instance, when a building is installed, it's supposed to be at a certain elevation, but you got to pour the concrete, you got to start building it, and it's not until then that you can determine. So we do like kind of mid-cycle building surveys to just ensure that everything's staying in place and where it's supposed to be on the base floor elevation. So it would be something similar to that.
So annually, every year for 5 years?
No. They're going to do it every quarter. Every year.
Quarter.
Yeah.
Okay.
Yeah, we originally said, maybe annually, maybe twice a year, but I was feeling pretty strong that we want to know as soon as possible. So every 3 months.
Thank you.
Can we, as a city, double check the monitoring?
I don't see why we couldn't. We'd have to talk about what that looks like, but yeah, I mean, there's the ability to do it.
I think we should. I don't think it needs to be the same frequency as AECOM's doing, but I'll defer to you on thoughts, but I mean, it would seem like an annual evaluation to assure the evaluation is accurate.
And if it's done by a surveyor, it would be a Florida licensed and registered surveyor, but if the desire is to have some redundancy there, we could definitely look into that.
Okay. Yeah, I think it'd be good. Okay.
Would that be a cost to the city, or would that fall under AECOM?
Yeah, Commissioner, I think that should fall under AECOM is my view. Susan, think about that.
So we kind of have to get a feel for what that might cost, and then we can have a conversation with them about it.
Okay, thanks. Great.
I'm sorry, I'm I process a little. I take my time and process the conversation, because even with the comment that David shared with us that they will be taking responsibility, is that my question financial responsibility for whatever comes down the road as well? It was just said responsibility, so I would feel better if I knew exactly that full definition.
According to my understanding of our mutual discussion, it is financial responsibility. So. But I want to be clear that it's related to the deflection issue, right? Because that's kind of the issue at hand.
Right, deflection.
We're still going through phase 2 with the remainder of the building, and I know that's probably on people's minds what may or may not be found. We'd have to address those individually. But for this portion of the conversation, we're talking about the deflection.
Okay. Thank you for that clarity.
Please continue.
And then, as we mentioned, that all comes down through the foundation, and we would concur with the others that the micropiles and the pile caps are a reasonable approach to fixing the issue. Visually, this just describes what we went through with the third-story columns, the first-story columns, and the pile caps.
So next steps for what we're looking at is Moss will continue to implement the rectification plan from phase 1 peer review. WJ is continuing to work on phase 2. There's general site work, finalize the plans to maintain the existing detention booking facility if we can, with an anticipated move-in date sometime in the fall of 2025. Just as a general overview, the project is about 80% complete. There are some critical items that have been recently completed, including the installation of 2 very large generators. FPL is getting ready to energize the building, and the HVAC chiller and AC startup has been tested. The parking garage is substantially completed, but we still have to relocate the radio equipment, do the asbestos abatement, start the demo of the existing building. But a lot of that work can continue in overlap with the work that has to happen in the main building. And I think that's it for right now.
Is the radio equipment, isn't that the state's tower? Is that what you're talking about?
Yes, so we have equipment in the old building. So all the hardware is in the old building, and it's wired up through the tower. We have a temporary structure that we've procured and put outside. It needs to be relocated into that structure. And then when we are ready to discuss what happens when the new tower is built west of 95, we then decommission the whole thing if that's the decision to move forward at that point and move it over there.
Okay. Anyone have any questions?
Yeah, Anthony, talk to me about flooding resilience and sensitive electronics and so forth. How are we doing in terms of susceptibility to flooding, stormwater?
So we have to meet the minimum FEMA elevations, and this is considered, I can't remember, it's considered a critical structure. I can't remember the exact term that FEMA uses, but it has to be at higher elevation than a typical single-family home. So all that's been met. They actually were able to raise portions of it higher than what the FEMA elevation was at the time when we submitted. There are portions that are at the other elevation, but they still meet all the FEMA requirements.
And will it withstand a Category 5 hurricane?
It's supposed to.
Well, especially the cantilever section. I just want to make sure that a wind doesn't sweep through there and just pull it apart.
Yeah, I think what you see on that graphic that showed the curve is the typical understanding of how concrete should behave and perform, right, over time. So the basis of these rectification plans and the enhancements and from structural from the foundation to the first floor up to the third floor and on the roof with those upturned beams that we talked about last time when I gave a presentation is all meant to ensure that the building behaves as would typically be expected. So that curve would still be relevant.
Okay. So that's actually kind of my question, because I know that curve applies to normal projects where they're designed for the load. In this case, we have an under-designed structure, and I'm concerned that it's not going to perform along your standard curve, that under-designed projects will continue to deflect over time at a greater rate than one that's properly designed and could lead to catastrophic failure at some point.
I'd have to rely on an engineer to respond to that. I don't know if you want to take a step.
So the original design was under design or had a design issue. There have been rectification measures put in place to address those, and there's still some ongoing conversations about the items we identified. Once all the rectification measures are in place, we see no reason why that over time the structure should not behave and perform as intended. Part of our analysis and what we looked at is to try to understand the sequencing of how those rectification measures were installed so that we could understand the performance on the building rather than just as if it was all a new design. But from our perspective, once all the proper rectification measures are in place, that there's no reason that building should not perform as it's supposed to on an ongoing basis.
So no additional creep in the cantilever groove over time.
There will be creep. We saw that curve on how it would happen, and it doesn't completely level off. It's a very small amount that it continues to creep, but we would expect that it would behave in a similar manner to a typical concrete structure.
And then within that typical creep, how is that going to impact the integrity of the windows and the likelihood of potential moisture infiltration into the building? Because that was, one of the biggest problems that we've had with the old police station is that it leaked like a sieve, and we had, folks with substantial allergic reactions, health issues, workers' comp claims, all due to the mold in the building. And so, the concern that I've expressed to AECOM and to everybody else that'll listen to me is we're going to have a repetition of the mold issues. We just saw this with the county courthouse, the brand new county courthouse, replacing the old courthouse. Why? There was mold in the old courthouse. New county courthouse, mold in the courthouse. So the idea is we're trying to replace a sick building, and I don't want to replace a sick building with another very expensive brand new sick building. So that's, help me get comfortable with that.
I'm not sure I'm the person that can answer all of those questions, but
Okay.
I'll try to unpack that a little bit, and then maybe you can turn to others to answer some of those questions. As it specifically relates to the structure and the movement there, that is why we have indicated that it's very important to account for that in the design of the curtain wall, or window wall is maybe the more appropriate term. Now, the design of the window wall itself and its sealant joints and how it prevents water from coming in, that's a whole other design item to be addressed. And I'm probably not as a structural engineer, I'm probably not the appropriate person to get into that here today. But that needs to be done separately. And then as a separate conversation as it relates to sick buildings, not all sick buildings are caused by moisture infiltration. There's also humidity issues and many other building science related topics with that, and that would also be a separate conversation with another consultant. But as it relates specifically to the part that I can talk about as a structural engineer, if we properly account for the deflections and how they move over time, and that's incorporated into the design of the curtain wall connection, the window wall connections, then there's no reason that system shouldn't be able to perform and keep the water out.
Okay. And as I said, I've raised this with the folks from AECOM, so if you want to come up and address this as well and just sort of expand on that conversation, I'd like to, sort of have everybody else hear what you've told me in our conversations.
Yeah, thank you, Commissioner. So one thing I want to point out really quickly, because you talked about catastrophic failure, and I want to make sure that it's understood that structurally, what was not met were the serviceability requirements for deflection. Strength-wise, the building was strong enough. So we're not going to see a catastrophic failure. We're going to see excessive deflection with the way it was originally designed. With the repairs that have been proposed, we are going to make sure that it doesn't deflect. We are going to continue to monitor to make sure that it doesn't deflect beyond the anticipated amounts. With that proposed fix, and as it behaves as assumed, we're not going to see the deflection. As that's the structural part of it, and that should be fine to accommodate any tolerances that are built into the window installation. So as long as we meet the requirements, and we're going to continue to monitor it, we're not going to see excessive deflection, and we're going to make sure that the windows then they're installed properly, and they're not going to leak.
And that's part of the overall guarantees that we're going to be receiving.
Absolutely. All the repairs that are being made are to bring the structural component so that we don't get the excessive deflection.
Okay. Thank you.
Any other questions or comments? Okay.
Sorry, one other one, Mayor.
Go ahead.
Anthony, we had talked about this. I forget if it was at a commission meeting or just separately. Possibly having another engineering firm evaluate doing some boring and drilling to evaluate the ground and so forth. Do you remember that?
Yeah, so Keller, I believe it was Keller & Associates, did the original borings.
Right.
When I spoke to, I think, you earlier today, and I did reach out to LYA, I just don't think I've gotten a response yet, it was determined that the borings are the borings. In other words, and just to use lay terms, what you received in that data is what you got. And doing new borings really wasn't necessary. They could use that data, and they were okay with it.
Okay. And Pat, this is you and I had talked about this, right? Any need for additional borings in your view to further evaluate, settling factors or whatever?
So we looked at that question as it relates to the new foundation design and things of that nature, and what all borings have already been done. As part of the new foundation, there will be a pile test. And so considering all the existing borings and the information that's coming from those, the pile test that's going to happen, we didn't feel like it was necessary to do additional borings. Certainly they could be done, but it's not necessary to do so.
Okay, I'm good with that. Pat, feedback?
No, if that's how they feel, I don't know. I understand from your report that you concur with the proposed micro piles and pile caps going in, but doing that, there wouldn't be a need to do the borings test since you're going into the foundation again.
With all the information that we have and the fact that there will be a pile test before the piles are installed, we didn't think that was necessary.
So there's going to be a test?
So as standard practice as part of installing piles, you typically do a test pile, and I'm certain that's part of the Keller's shop drawings as part of that testing effort.
Okay. I had one other question. I was just curious on the deflection was I guess basically considered an architectural error, but is there any thought that any of the construction of the concrete work by the contractor had any effect on causing the deflection?
I know that has been mentioned by others. It wasn't something we looked at specifically to understand. Our goal was really to try to say, where did we start? Where are we now? Does it work? To answer that question, I'd probably have to go through a whole other series of documents and other calculations to know that, the answer to that. In general, I don't think I can answer that today.
Okay. Well, would the folks from ACOM what is their thought on that?
I'll do my best to answer it. I believe that we found a design error, and so I'm not aware of anything else that contributed to excessive deflection other than the design error. I can't speak to whether it was constructed properly, but we were able to find a design error, and that's what we're addressing.
Okay.
I could probably add to that just a little bit. I mean, during the inspection process, so staff will go out there and the inspectors, and they'll look at the plans and, the spacing for the rebar and the locations and everything to verify that it's per the shop drawings that they've got. So that inspection process, allowing it to move forward, would seem to indicate that it was constructed the way it was spec'd.
So one last comment. In my conversations with AECOM, one of the questions that I posed to them was with respect to a longer warranty period. The 57 months for monitoring, I understand the rationale behind that there's a standard curve for how long you think the deflection is going to continue. But when it comes to warrantying the quality of the work after the additional engineering has been done and construction has been done, we've got a 30-year bond on this building, and I've shared with AECOM, and they understand my perspective on this, that any guarantees that we get should be more commensurate with the length of time our taxpayers are paying for this building. That 57 months is simply inadequate when we're asking the taxpayers to pay for this building. I expect our partners who designed it and constructed it, our whole team, to stand behind the quality of the work. So they understand my perspective on this, and I know they said they were open to coming back and offering up a lengthier guarantee. As I said, as far as I'm concerned, the risk of the quality of the work should fall on the people who have performed the work, not on the city, not on the taxpayer. So I just want to be very clear and get that out. And again, they understand my perspective, and they said they were willing to come back with a lengthier response to that. So.
Okay. All right. And that would be incorporated in any supplemental documentation we need to moving forward, right?
Absolutely look forward to that offer.
Okay. All right. Is there anything further?
No, sir.
Okay.
Thank you.
Any further questions from the commission? There being none, thank you so much, folks. Thank you,
Thank you.
gentlemen.
Thank you all.
Appreciate it. Anyone else
Appreciate
wish
it.
to speak on business
you.
one? There being none, we'll move forward. Business 2, motor vehicle noise presentation. Who'll be making that presentation? Hey, come on up. Good afternoon. Could you please press the button at the bottom of the speaker?
There we
Very
go.
good, thank you.
Good afternoon, Mayor, Vice Mayor, Commission. Julie Steinhardt, Assistant City Attorney. I'm Police Legal Advisor. I have a presentation for you on vehicle noise in the city. There we go. No? Okay. Okay, so we really have kind of two areas where we deal with vehicle noise per statute, and with the police department. We have the Florida Motor Vehicle Noise Prevention and Control Act, which deals with noise coming from newly manufactured vehicles, and that's really going to deal with the noise that comes from the mufflers of the cars. Okay, so with that, with 403.415, we are kind of beholden to what the state mandates that we do, and we are not allowed to pass any ordinance, local ordinance that would challenge that, or have any more stricter guidelines than what the statute has. Okay.
Sorry, can you just go back to that? I just missed that first slide, please.
Oh, here.
Thank you.
This one?
Yeah. Let me,
Okay.
Yeah. Let me just read this.
But I thought in slide 5, page 5, it says this section does not prohibit a local authority from lawfully imposing more stringent regulations on sound produced by a radio or other mechanical or electronic sound-making device or instrument as described in subsection 1, which sound emanates from a motor vehicle. So we can restrict it.
Not when it comes to the vehicle noise coming from a muffler, but other noise that is dealt with in the statute, sound producing things that come from that, we can.
So just music and voices, but not mufflers.
Correct. So most of the time what we look at when we're looking at the mufflers is, do they have a kind of a modification on the muffler to make it have that kind of popping sound that comes from it. And that's where we're writing most of our tickets when it comes to the mufflers.
But those are not manufacturer designs. Those are aftermarket.
Correct. Those are aftermarket that they put on. So they're kind of the additions or the modification made by the vehicle owner.
And we can regulate that. It's just the manufacturer design we cannot.
Correct. We can't have more stringent guidelines by saying a muffler has to be quieter in the city than what the state statute allows.
Right. But most of the time, these, cars and trucks that come out of the factories, they usually have muffling devices to limit the amount of noise, right? It's the aftermarket stuff that we're worried about.
Absolutely.
Like when these police officers rev up their motorcycles.
Yes, I have some of them here with me.
They're the ones that are the real violators
yes,
here, right?
Exactly.
Yeah. Okay, we get that.
Yep.
Yeah.
Yes. Yeah, actually it is. This is our expert here.
Yes.
Okay, so now when we look at 316.3045, we're looking at the sounds outside of the mufflers coming from the vehicles, and that's going to be most of the time music emanating from a vehicle. Okay, so under the state statute, you see a person operating or occupying a motor vehicle on a street or highway may not operate or amplify the sound produced by a radio, tape player, compact disc player, etc., which emanates from the motor vehicle so that the sound is plainly audible at a distance of 25 feet or more from the motor vehicle, or louder than necessary for the convenient hearing by persons inside the vehicle in areas adjoining private residences, churches, schools, or hospitals.
Quick question for you.
Yes.
So a lot of the Harleys have radios in them. So it's not inside a vehicle. It is external to the vehicle. The speakers are mounted externally. How does that apply? And if somebody is wearing a helmet, it makes it a little bit harder to hear the music. So they may have to turn it up louder to hear the music through the helmet.
Well, we have
wear earplugs.
Well, we have an or there. So we have the plainly audible at a distance of 25 feet or louder than necessary for the convenient hearing of a person inside the vehicle.
So that's what I'm saying. So if you've got somebody who's riding a motorcycle with a helmet on needs to crank it up a little bit louder to hear it, but a person 25 feet away could also hear it. Maybe the guy with the motorcycle helmet can't hear it because he's got a really good helmet and it's got a lot of soundproofing to it. Just curious how that works. The or, what does the or mean?
So what does the or mean is that...
Asking for a friend.
My radio died on my Harley, so it doesn't work. I'm just curious.
You wear earbuds.
Does it have the Bluetooth on it? No. Yeah, so, I mean, if it's louder than necessary, I mean, you could look at it either way. So we're looking at a Harley. Well, you know, it might have to be louder than necessary on a Harley because the person cannot hear because of a helmet. But, you know, we can look at it if it's 25 feet away, then we're going to be able to say, well, that's kind of a nuisance to the neighborhoods or the cars around that.
Okay.
And sorry, can you just go to, is this just whatever slide
I'm so
you're...
sorry. I'm
no, it's all
ahead
good.
of myself.
I hung you up by going back. Thanks.
Okay, so that's where I was just...
Okay, so again, this is state statute?
This is state statute.
Okay.
So we can go ahead and give tickets under this state statute.
Right.
And also the statute allows us to impose restrictions that are more stringent than what the state statute is.
This is why I wanted us bringing this up.
Yeah, this is what I thought you wanted to get at.
Exactly.
Okay, so we also have our own ordinance that deals with sound as well. And that kind of pretty much mirrors the state statute with the 25 feet. So ours states that no person shall cause, allow, permit the operation of any amplified sound device from the following use districts or locations in the following manner. On rights of way, which we're looking at the streets here, sound shall not be plainly audible at a distance of 25 feet or more from a motor vehicle or any other sound source. Okay, that's our ordinance, which mirrors the state statute.
Yeah, and 25 feet is a long distance in my view. But okay, great.
Okay, so we do have
absolutely
motor vehicles, motorcycles, mopeds, and motorized scooters. No person shall cause a rapid throttle advance, so the revving of any internal combustion engine resulting in a noise disturbance. So we have that kind of as a different kind of noise. It's not necessarily coming from a loud muffler that's continuously going or the radio. This is just the loud revving. Okay, we have exemptions, just motor vehicles, mopeds, or motorized scooters, and muffled in accordance with state law. So that just mirrors the muffler, you know, but that doesn't have to do with the revving. That's just the standard noise that's coming from that. Okay. So I also went ahead and I looked at other areas in Florida that have noise ordinances, and just to see what kind of noise ordinances that they're using and how many feet and what kind of what kind of rules that they have. And we see ours is 25. We see some of them are at 30 feet from sound source, 50 feet from sound source, which is pretty far away. Some of them are just really, anything that annoys or disturbs the people of a reasonable person of ordinary sensibilities. We see in Pompano Beach, disturbing the peace and quiet and comfort of neighboring inhabitants. So it's really sort of subjective there as to what's going to annoy neighbors. It's not, hey, here's an exact distance from where we are to where the noise can be heard.
The 25-foot the 25-foot aspect of this means that it cannot be heard at a certain decibel level 25 feet away. What's the decibel level?
It's there's no decibel. If you go back and see, it's going to be plainly audible.
Plainly audible. Is that constitutionally supportable?
Plainly audible.
Plainly audible, disturbing. Is that considered
so wait, I think this
enough?
distance is about 25 feet from you to me. You're plainly audible.
I'm plainly audible.
Can I write your ticket?
Quiet down there, buddy.
Right. No.
Well, we're 10 feet away.
It's a practical right. So from the podium to my seat is probably about 25 feet, and you're plainly audible.
Mm-hmm.
But I don't think we want that as a measure. It has to be. I would think we'd want a decibel level that would make it disturbing.
Right. That's where I think plainly audible is somewhat
subjective.
ambiguous.
Yeah,
Right.
that's what I'm
These
saying.
are
Is that
very like a lot of these are very
constitutionally
subjective.
Right.
Mm-hmm.
Okay.
I think I can hear Anthony, and he's 45 feet away from me.
What?
Yeah. So we have issues also with having a decibel too, because all those the equipment like that would have to be calibrated correctly. When you go to court for these tickets, they would have to bring in people to show how these things are calibrated correctly, like a device for measuring speed as well. So most of these are just really, subjective as to what a reasonable person would think is not plainly audible, or if I can hear it this many feet away, then you're violating the statute.
What is the in some of these at certain hours, overnight, prima facie evidence of violation at 100 feet? What is that getting at certain hours?
That's going to be if it can be heard from 100 feet, then that's all the evidence that you need to show that you were violating the statute.
It can be heard. Okay, and otherwise, it's the more subjective standard, which could be much shorter than 100 feet.
Yes.
Okay.
Mm-hmm.
Huh. Okay.
And things also, right, when you look at it, you've taken to consideration to the area where you're at, how sound travels, where you are, things bouncing off of buildings. Are you on the water where sound travels a lot further? So sometimes those factors need to be taken in consideration too when writing tickets for these things. So our existing mechanisms that the police department has, we have our highly trained motor units here that is excellent at writing tickets for these types of things.
They have good hearing?
They have excellent hearing. They can hear plainly audible from 100 feet or more. No. So highly trained motor unit. We have, we've tried doing in the past targeted operations during peak times, but we've had some challenges with that. It's kind of more these vehicles are fleeting, and sometimes you hear them at intersections and then they're gone. They're not always in line at spring break and able to do the targeted things such as that. High visibility of our officers is something that we've tried before, and obviously making courtroom appearances is writing these tickets and having our officers show up for the hearings so that these things are they're litigated and they're paying their fines and hopefully learning the lesson by that. Okay, and so we wanted to talk about some recommendations to improve enforcement. And I mean, the bottom line is, if we want to really go ahead and improve our enforcement, we should, perhaps have additional motor unit officers, more people out on the street, more officers that are just dedicated to writing tickets, because for the most part, our officers that aren't motor unit, they're going from call to call to call, and quite often they don't have the opportunity to stop and write these kinds of tickets.
Okay. Is that complete? Oh, questions. Okay,
questions.
great.
If you have questions, I have my friends over here, Sergeant Beauregard and Officer Isaac here. If you have questions for them or about how they're writing tickets, how successful they're being in court when the tickets are being there, are they getting dismissed? If you have...
Is there anything you want to add? Come on up. Come on up.
Yeah, sure. I've got questions. Yeah, please.
I dare you
officer.
to come off.
Thank you.
Good morning, Mayor, Vice Mayor, Commissioners. I'm Officer Isaac, Fort Lauderdale Police Department. I'm in the motor unit. As to the part of where it comes up to court, I haven't lost a case in court for one of these music violations. So whether it be music or loud exhaust, I have not lost one yet. The hearing officer in the courthouse is pretty on board with it. He's sick of it as well. He's a resident of the city. When it comes to the 25 feet with the motorcycles, as with all the tickets that we write, we have discretion. So if the volume isn't absurdly loud and offensive, then we're not going to stop somebody and write them. We may go ahead and ask them to turn it down. We might stop them and give them a warning and advise them of the law. But there's operations that we've done where we've sat on Las Olas, where all the restaurants are, and we'll park our motorcycles on the sidewalk. And if a vehicle, motorcycle, car, one of those slingshots comes by, and the music's at such a volume that it overdoes the volume of the music from the restaurants, then we're going to stop that person and address it.
Right.
We're not out there just targeting any type of, I could hear you from here to there. It's got to be obnoxious, which I know is, like some based on each person, what they determine to be obnoxious or not. But like I said, one of the standards is if we're in an area where there's a lot of restaurants with outdoor music and your music is overwhelming that music, then obviously it's
so how have people responded to, like, you stop somebody, like in a car or whatever, or a motorcycle, how have they reacted to your stopping them?
So it all varies. We've had people that were completely understanding that just didn't realize that it was a law, so we'll educate them on the law.
Okay.
We do warnings as well as citations. So we'll approach somebody, we'll tell them turn it down, this and that. And, we are running into the same people again and again. So I may give you a warning today, and hopefully you take that into account. If I pull you over a second time for the same thing, I'm going to give you the ticket, and you have nobody to blame but yourself. But for the most part, a lot of people just don't realize that it is a law. So we do our best to educate them, let them know. We have other people that just don't care, and they're going to do it anyways, and we'll write them the ticket and let them be on their way. So.
Okay.
And then when it comes to, the exhaust, same thing. We're not just pulling over every single car with a loud exhaust. We're getting the ones that are doing the many of the BMWs, the Audis, that they have what they call a crackle tune, where they go down the road and as soon as they accelerate, it sounds like gunshots. We're going to go in and we're going to get those people. We're going to pull them over. We're going to write them the tickets. If somebody's cruising at a normal speed with a normal little bit of a rumble coming from their car, we're not trying to write all those people tickets. It's the people that are being extremely obnoxious, the backfiring, the vehicles that will get Lamborghinis going down Federal Highway where I literally hear them for 3 blocks before they get to me. And then when they see me, they press the little button on their dashboard to quiet their exhaust, and I'm like, it's too late. I already got you.
Is there a button that does that? Okay.
Yeah, so a lot of these vehicles, a lot of these high-end vehicles will have a off-road sports mode because the vehicle's not made for only the street, but you have the option of taking it to the track. So they'll have buttons on them where you can change the mode of the vehicle, which will change the tone of the exhaust. So we'll do a lot of these cars. We'll pull them over, and it's funny because we'll have it all on camera. You'll go up to the car, and the exhaust is obnoxious. You can't even talk to the person. And then you tell them to press the button. They press the button, and it's a whisper. And then now we can have a normal conversation. So they generally they know what they're doing. They know that their car has a different selection for different exhaust modes. The people that have the crackle tunes, those are modified. Those are beyond what the EPA allows, and they're not what the manufacturer designed.
So you're telling me you're not coming after old pickup trucks like mine, right?
So it's
just old, just to be sure,
just
like
old
I said,
truck
there's a great Hardy song that says "My truck's louder than your truck."
So as long as you're not going down Las Olas, the beach, or someplace
I'll stay off Las Olas.
You're flooring it, being obnoxious. Like I said, we're not generally if somebody's going down Sunrise or Federal or something like that, just cruising, getting where they got to go. We're not having an issue with that. It's the people that are trying to showboat, the people that are revving it up at intersections, the people that are having the loud exhaust popping, the people that are going through the tunnel that want to see how loud they can be inside the tunnel. Those are the vehicles that we're stopping. Those are the vehicles that we're riding when it comes to exhaust.
My questions, how many motorcyclists are related to your unit? How many is there? 12.
12.
Okay.
So.
Okay.
Because the main areas that I experience the most is Sunrise Bridge. Everyone thinks that's a great speedway going over the bridge and coming down, right? The tunnel and Las Olas Boulevard.
Yes.
And Federal Highway from time to time, but everyone seems to want to parade through these areas. And
beach too.
Yes. So we're
beach,
out there as well.
Yeah. Well.
And that was my next question. What areas do we can see you in enforcing this? Because citywide?
Yeah, we're citywide. We did at a time, we had a what they call an action plan, which is a directed patrol type thing, where we were coming in after our shift, after hours, where the noise was more prevalent. So we were coming in the evening hours, and we would be in the Sunrise Corridor, Federal Highway Corridor, on the beach, or Las Olas, and we were monitoring those areas, and we would have about 2 officers, 3 officers that would sit in those areas and get those cars nights and weekends.
Thank you.
So one last thought. I know when I'm sitting on Las Olas trying to have brunch, to the mayor's point, there's folks who like to come down and share their music with everybody else in the world on a Sunday afternoon. But my other thought about the motor unit is I happen to think it's extremely effective in dealing with the folks that are speeding through my residential neighborhoods in my district. So I've got, people that are complaining to me on a regular basis about driving through Poinciana Heights. I've got folks that are complaining to me. I had 3 emails today about people speeding through the area up around Imperial Point, Knoll Ridge, around the schools and around the churches up there. So I want to make sure, as much as I appreciate the fact that noise is a noxious behavior, and I also want to make sure that we keep most of the focus for the motor unit on safety. Noise is unpleasant, but when I've got kids walking in the street and we've got people speeding up and down these streets, I want personally more of the motor unit's attention focused on the safety of our residents and our children, less on the quality of life and more on public safety. So just as we think about how we're going to deploy our resources, my number one overarching concern is always going to be the children in the neighborhoods that unfortunately people just don't respect. And I know we're having conversations about putting more speed bumps out there and other traffic calming devices, but you guys are the best traffic calming device there is. Nothing slows people down more than a guy standing there with a gun in his hand, a speed gun.
So in that is our number one priority. So we do on the motor unit, we focus mainly on those emails that you get. So we do citywide, and we will get from the click fix, we'll go to different areas where we get problems with speeders, stop signs, this and that. That is our number one focus. This here is something that we do in addition. Like I said, the reason I'm talking about it so much is because that's what we're here on. But primarily, we do deal with speeders, equipment violations, safety concerns, stuff like that. That is our number one focus. Also, twofold, though, when it comes to speeders in the residential neighborhoods, a lot of people, they don't have the eye for speed. So most of the residential areas, speed limit's about 25 miles per hour. If it's not posted, then the speed limit defaults to 30 miles an hour. Now, when you're on a small 2-lane road walking your dog and somebody's coming at you at 30 miles an hour, to you, not to you, but to most people, they look like they're coming extremely fast. So in a lot of these complaints, we'll go out there and we'll do speed studies. We have different tools that we use. One of them is a radar box that we'll set up in the area, so that way they don't see us, but there's a box there, and we can calculate how many vehicles are actually using this road, how many out of those vehicles are actually speeding, and at what times of day they're speeding. Another thing that we do is we'll actually position one of our units out there with a laser, and we'll monitor traffic, and we'll pull over cars for speeding, and we'll cite people when applicable. But we've had from time to time where I'll get a concern from a citizen about speeders going through an area, and I'll sit out there for 3 days straight for a couple hours a day. One of them that was most recent was on South Birch Road. We were getting a complaint of speeders. I sat out there for hours. Out of the hundreds of cars that passed me, there was only 3 cars that I could pull over that were applicable for speeding. Now, that's a lot of time I spent out there, but that's their concern. So I go out there, I monitor it, and I relay my information back to my bosses, and then they decide whether we're going to continue enforcement out there or not. So when it comes to speeding in neighborhoods, a lot of people, 30 looks pretty fast, but then when you actually go out there and you sit out there for hours and you realize you're like, I saw 2 cars that sped, it's not usually as big of a thing as a lot of people do believe it is. The areas that are a big concern, we're definitely out there hitting. We're hitting McNabb Road. We're hitting Southeast 17th Street. We're hitting Sunrise Boulevard. We're hitting Federal Highway. Southeast 3rd Avenue by the courthouse, we're out there from time to time. And we get people, speed limit's only 25 on Southeast 3rd Avenue from Broward all the way to just a little bit south to Southeast 6th Street. We'll get people going through there at 45 miles an hour. And we pull them over. We ride them when applicable.
I need to hear you say 6 trunk. I haven't heard you say 6 trunk at all.
So that's not generally an area that I'm at when I'm patrolling the city.
Yes.
6 trunk is an area. If we do get a concern out there, we'll go out there. It's just not really one that I hit as much. I usually hit the major ones, like I said, 17th Street, Sunrise, Federal Highway, the big roads where I'm going to be very visible.
You mean
Because
people
it is-
speed on 17th Street? You can't go more than 5 miles per hour.
No, Southeast 17th Street. I pulled somebody going 90 miles an hour over the 17th Street.
On
Causeway Bridge.
17th Street?
Yes.
Yeah.
90 miles an hour.
They'll fly over the
Yeah.
bridge.
So,
Over the bridge.
over the bridge.
Yeah, over the bridge. They hit it hard.
So speed limit's only
It was
35.
fun. No, just
People don't realize a majority of the roads in the city of Fort Lauderdale are only 35 miles an hour, and everybody thinks that everything's 60 around here. So
And that's what we experienced on Six Trunk. That morning traffic, of course, they
Six Trunk.
allow Six Trunk. If they're delayed by the train, they're trying to make up the time. So it is an issue with Six Trunk. So we'll make that notation so we can see your presence there as well.
Well, unfortunately, the thing is, when it comes to the mornings, a lot of times we're at the schools. So, and there's so
Expect
many
that.
schools for us to get. Each one of our officers has at least 2 schools that they're doing in the mornings and in the afternoons. I got Bayview Elementary and Virginia Schumann Young, and those are the 2 that I monitor during the day.
Well, when we have our speed monitors at the schools, we can relieve you of that responsibility when the monitor.
Well, that's a whole other thing. A great majority of those vehicles are not registered to the people that are doing the speeding, and in certain areas of the city, the tags don't even come back to those vehicles. So those ones that are speeding in those parts, it's not going to be effective on them.
Really?
Yeah.
That's the first we've heard of that. Okay.
Yeah, we get a lot of vehicles where the tag doesn't even belong to the vehicle.
Well, that's another issue. Yes, Dan.
Couple questions. Thanks for your work. How many citations and tickets have we written sound violation wise
So
a
unfortunately,
year?
I don't have those numbers.
That's fine.
That's not something I was prepared for. I
Okay,
do apologize.
that's all right.
I don't have those.
Okay, that's all good. Julie, question for you. Does the existing city noise restriction apply to boats?
Let me.
It says motor vehicles, so I'm guessing yes.
For a motor vehicle,
A boat is considered a motor vehicle.
I'll have to look and to see if it defines it in the statute, but I believe so.
I think it does. Okay, great.
I'll check and verify.
Yeah, that sounds great. So, officer, from your standpoint, so this is our existing ordinance, right, up here. There's a lot of options to adjust our ordinance, right, if we wanted to, if the commission wanted to. So you could have this more objective that doesn't include like the 25 feet, like this, for example, this one, Atlantic Beach, just sound that disturbs the peace and quiet. Would any of these be helpful to you, or do you feel like what we have right now is good and gives you plenty of opportunity to?
So we don't use any of this.
Okay.
So we're not going by city ordinance. We're going by state statute.
Just by
And
state
state
statute.
statute gives us all the tools necessary to go ahead and effect the citations that we need to for the vehicles out there that are creating violations. We don't typically go on the motor unit. We don't do it by city ordinance, because the city ordinance, if we did that, it would end up being a notice of superior court, which would be typically almost like an arrest.
Yep.
We're not going to that extent.
Okay.
We're doing the citations. Like I said, we're doing the citations. We're making sure we're showing up to court. We're making sure that they stick. Like I said, out of all the ones that I've written, I haven't lost one yet.
Great,
So-
and you're always charging under the state statute.
Yes, so we're always
Interesting.
doing
Okay.
citations under state statute. So there's several different ones. The ones that are here are for modified exhaust, but there's also ones for defective exhaust. So if I stop somebody, they go, oh, well, the pipe broke on it, or this and that.
Mhm.
There's other statutes that result to leaking exhaust, broken exhaust, this and that. So there's multiple tools that we have when it comes to state statute that allowed us to issue citations for loud, obnoxious, broken, defective, modified, altered exhausts.
Got it. Okay, great. So then, Julie, my question would then be also, does the state statute allow for enforcement of marine traffic?
Well, that's the. Let me go back. Let me.
Yeah,
go to it.
here. I'll give you the clicker back. Thanks.
Because Okay, yeah, I would have to go back to the.
Okay.
Normally, motor vehicles includes boats too, but I have to go back to the exact definition to
great.
see if it has the definition in there where it excludes anything.
Great, thanks. And Mayor, I bring that up because marine traffic, especially our downtown, the noise is a major challenge for our residents downtown. So want to make sure, and obviously I know that probably would not be you enforcing marine
Now, when you say
noise, but
it's a concern, are you getting loud music or are you
Loud
getting
music.
Loud music.
Yep.
So loud music, from my understanding of the statute,
Yep.
loud music would be covered because it's just that whole 25-foot thing.
Right.
So as
Regardless
exhaust,
of the source.
Not
Yeah.
sure about the exhaust when it comes
Yeah.
to boats, but for loud music, I believe that it would be applicable.
Yep.
I know
that's something our Marine unit would have to.
Exactly.
Yeah, I know. Prior, in Miami-Dade County, where I was before I came to Fort Lauderdale, we had issues with boat noise because of how the sound travels
Exactly.
underwater.
It's a
so
major
that was
challenge.
a really big problem with monitoring how far you could hear the music from, and and they were trying to use decibel monitors for that because of the water and how the sound traveled. It seems a lot louder than sometimes than it really is, and people from the houses they were hearing it from a boat out there. So
same issue here.
So that was okay. I'm happy to look into that too for you and get back to you to see if there's anything we can do to work with that with our Marine unit.
That'd be great. Yeah, if you could, that'd be really helpful. The other piece, and you kind of just referred to this, is remote noise monitoring. There are some cities that are actually deploying noise sensors and actually taking pictures of license plates and deploying enforcement measures remotely. I don't know if you've looked. I don't know if the state, and Dwayne, this might be a question for you, if the state statute allows remote censoring and citing for noise.
I'm only aware of I'm not aware of any statute that particularly permits that. That's something that we can look into. I don't know if Julie has any information on that.
And I know the police chief, because I thought it was allowable, but the police chief has told us in the past, and I don't know if it was a court case or whatever, that it's currently not.
Yeah, I believe we had
there
been
he
looking
is.
into that
Yes.
before, and there was something that was holding us back from doing that.
Chief. Yeah, like City of Knoxville, Tennessee uses noise monitoring cameras. Chief.
Currently in the state of Florida, there is no statute that would allow that.
Would allow noise monitoring enforcement.
And take photos and send citations. We don't have that.
So it allows for speed cameras,
but not noise.
So that's a state legislature limited. Another
And
item.
I will tell you, Miami Beach, and we're going to have an expert here soon.
Yeah.
They tried them, and they were not very accurate.
Okay.
But they only tried them. They couldn't issue a citation.
Got it. Okay. Good to know. Thank you, Chief.
Welcome.
Officer, anything else how else can we equip you, support you to enforce, obviously, the public safety #1, but then the sound. Anything else you need, or tools or frustrations?
No. 10 more officers.
10 more officers.
10 more officers.
Okay, got it.
So we need to expand the motor unit.
Like the chief whispered in your ear.
Some of the things that I could suggest, I don't know if I would be stepping out of line when it comes to chain of command.
Yeah.
But just with
Speak freely.
Well, just when it comes to the fact of if some of the concerns are after hours, implementing plans like we had before, where we would come in later in the evening to enforce those things.
Okay.
Other than that, you don't really want to. So there was talks before about decibel readings. This and that. You don't want to start doing that. Because if you start doing that, it's going to go ahead and limit us. Because then, if you got 5 cars on the roadway and you got a decibel reading, now we're going to come into the whole point of where we're going to have to try to testify and explain how we knew that out of the 5 cars that passed, that decibel reading was from that specific car right there. So right now, the way that the law is written, it allows us to go ahead and use common sense. And obviously, if I see this car coming and I'm looking right at them and the RPMs match and this and that, we're allowed to enforce it.
Yeah,
if we start getting decibel meters out there, as she had spoke about, we're going to have to go ahead and make sure they're calibrated all the time. We're going to have to make sure we have a whole bunch of documents that we submit with the court things. And then we're going to have those arguments of, well, how do you know the decimal reading was from my car versus the car next to me and this and that. So that would actually go ahead and hinder us in our enforcement. So as the statute's written right now, the statute is great. The only thing I can say is, some of it is the hours of operation when it comes to people's concerns. Right now, we're doing it a lot where we're doing it during our regular shift. And again, it's a secondary. We're doing the speed, the equipment, the red lights and all that stuff first. But if I just happen to be at a red light at an intersection and a guy, 3 cars ahead of me just starts revving his motor and it's bah, 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 then I'm going to go ahead and pull that guy over and write him some tickets.
Yep. Okay, great. Thank you. Julie, thank you. That's really helpful.
Also, with that being said, that is an opportunity also for any officer to be able to enforce this ordinance, right? Not just specifically the motor units.
Yes, any officer for the city of Fort Lauderdale is able to write any vehicle for the state statute. As she had addressed earlier, though, it's a little bit harder for the patrol units to go ahead and do that. I did patrol for about 16 years of my career, and when you are going from call to call, sometimes it's hard to do that traffic stop in between those calls. Life takes priority over the noise violations.
And that's where I'm going also. I appreciate what you all are doing. It's necessary. But also with the 10, if we get 10 more, I would also like to see them in the districts working. And the mayor's always giggling at what I'm saying. But, District 3, yes, I'm ringing my bell. District 3 has issues that we also need to address. I appreciate this. I'm supporting this. But also we know that this is also, it has its priority, but we have overall safety priorities as well.
Commissioner, we definitely hear that. And we have worked Sistrunk numerous times, and I can get you the statistics to show you that.
Yes, and I'm working with the Lieutenant Will August, and we are up to date on that. But I can't leave a blanket statement out there without letting my neighbors know that we are overall citywide. This is what we're doing.
Citywide.
Okay, citywide.
Thank you.
Thank you.
Excuse me. Any further comments or questions? Okay, there being none. Thank you, Julie. Thank you,
Thank
Officer.
you.
Thank you so much. Thank you, Chief.
Thank you all.
Okay, moving on to Business 3. This is a presentation on City Commission priorities.
Good afternoon, Mayor and Commissioners. Erica Johnson, Structural Innovation Manager in the Office of Management and Budget, and I'm here this afternoon to share with you a draft of the fiscal year 2026 Commission priorities. Last month, I know it's only been a few weeks, but it seems quite a while ago, you all held your annual Commission Prioritization Workshop where you set your goals for 2026. You shared your ideas and aspirations for the next year. So as staff, we took our notes and we reviewed all of those ideas and consolidated them into 6 draft priorities. In no particular order, they are public safety, homelessness response, number 3, infrastructure and resilience. 4, public enjoyment of waterways. 5, public spaces and cultural initiatives. And 6, bolster thriving communities. Up on the screen, and as part of Exhibit 1, is a comprehensive listing of all of the different key themes that we heard from you and how they fall under each of those 6 priorities. So today, we request your feedback on these priorities before we bring them back to a regular meeting next month for those to be formally approved. Upon adoption, we will use those as we build the fiscal year 2026 budget. With that, I'd love to hear any feedback you have on how we've consolidated these.
Okay, great. Thank you so much. Anyone have any comments or questions? I think they're pretty comprehensive, what you wrote there. Any comments or questions or additions, modifications? All right. Go for it.
We'll bring those back in March. Thank you so much.
Thank you so much.
Thank you.
You listened well.
Yes, great job.
Except we do have Ted and Sarah who's asked to speak.
Hello, everybody. Hello, Commission, Mayor. My name is Ted and Sarah, President of the River Oaks Civic Association. I did have somebody point out the fact that the best line so far was when you compared the Romans with the design of the police station. They thought that was very, very funny. But I'm here to speak about the same thing I spoke about many times that I've been accused of campaigning about. But even though I spoke about it at the old city hall, was the homeless situation. We are just not seeing any strides in getting things better. We are putting in concerns with the fix it, with the everything, and it just seems to nothing be happening. I know boy, we were very happy when that new law was passed, and then you commissioners kicked it up a notch and made it even a little tougher. We were all right, finally we're going to get something done, and still haven't seen done anything. What if the person's not here? There's words like, when it comes to that evaluation you just saw, we're going to consider, we're going to explore, we're going to evaluate. Those are passive words. Those are not very action-minded words. I'd like to see the word consider be, use accomplished. Instead of explore, use the word handled. Instead of evaluate, use the word implement. And actually just show some progress. Because, I ride buses, I ride my bike. It's getting worse out there. And like you've said before about the police station and the hospital, now we're seeing a lot of it leaking into the neighborhoods, and that is just something that we'd like to see finally, brought to fruition and some action to be done. Thank you.
All right. Well, thank you. Anyone else wish to speak on this item? To your point. I know that our neighborhood support members have been really doing a great job at trying to work with homeless people and to try to mitigate the impact it's having in our community. And with the additional police officers, I know that we have been able to handle and make progress on quite a few more homeless situations than we have in the past. It's also been pointed out to me that the population has increased too, not because we haven't been able to work with more homeless people, but the population continues to drive itself towards Fort Lauderdale and other areas in South Florida, especially during the winter months. We don't have a solution, especially since the solution requires us to partner with county agencies, including the Sheriff's Department, who controls the jail, and who has refused to participate with us in trying to use the jail system as a way to improve our enforcement capabilities, whether they be to enforce the state statute or any of our local ordinances. So until we have that resolved, I don't know whether we're going to really be able to make any significant gains in reducing our homeless population, other than to just continue to, work with homeless people one by one, try to resolve their issues, and try to take them off the beach, try to take them out of alleys, try to take them out of neighborhoods. I can tell you personally that I have seen progress. I've seen progress on the beach. I've seen progress in certain areas, but I've also seen homeless people show up in places I've never seen them before. I went to an event Sunday night at America's Backyard over by Himmershey Street, and I saw 6 or 7 homeless people camped out along the street there. I've never seen homeless people there before. So it's a difficult situation. I wish we had more cooperation with our county agencies, but we've been working with our own police department, our police chief. We're going to try to see if we can resurrect some of our own facilities, to see if we can perhaps be able to handle our own situation by ourselves and not have to rely on anybody else. But your point is well taken, and let's try to be more vigilant. Anyone else have any comments with regard to Business 3?
In terms of homelessness, we're making we have a massive effort, as you well know, across the city. Commissioner Beasley Pittman, I know, sits on the Continuum of Care Board, helping lead the effort on working with all county agencies. Chris Cooper is doing a fantastic job helping drive our initiatives there. I've been meeting almost weekly with multiple service providers around the city to help coordinate and calibrate efforts, which has been very positive. The United Way, Salvation Army, Hope South Florida, LifeNet for Families, among others. So we've got great engagement across the board, and we're working every day on it. As I know you are, and you know well, and so I think we're taking a very proactive approach.
A year or two ago, we started talking with the hospital district, talking with the sheriff's office about discharge protocols. Have we gotten anywhere on any of that?
So I know that the police chief and fire chief have had discussions with them. One of the things we talk about with bringing back the holding facility was the concept of, because that's going to take a little bit of time, but of standing up a temporary facility and partnering with the hospital. And we did have conversations with the CEO there. So we'll follow up and get you some information.
But we haven't seen any measurable progress in that, have we? I have not.
No, not to date.
Okay. All right.
With that, Mayor, a reality, a part of that conversation and the reality of the numbers of homeless people that we're seeing, you explained and have said how we see the influx of individuals coming here because it's South Florida, it's warm. And even in those areas where we are making progress, what's being deposited or added every day is making it hard to see the true accomplishments that are being made. It's like throwing a rock in the middle of a ocean and you're just seeing a small ripple. But there are things that are being done, and unfortunately, it's gonna be a process that we're gonna walk through for years until things begin to change, as how we, as neighbors, begin to approach how we also become a part of the process for fixing this. And, we've heard many times, there's so many of us, no, we don't want to see this in our backyard. No, we don't want this at our parking garage if we're trying to do temporary overnight parking for individuals. But this is a very complex situation, and I believe we all can admit that. But again, as a whole, as a community, what are we willing to put in to make the change? Are we going to be a part of the change, or are we just going to say what we don't see? So we all have to be proactive with this. Thank you.
All right, thank you. Continuing on to CF1, performance audit of the cemeteries administration.
Pat? Patrick Riley, City Auditor, Honorable Mayor, Vice Mayor, and Commissioners. The City Auditor's Office completed a performance audit of the cemeteries administrations. This audit was included as part of our annual audit plan. Beginning with a little background, the City of Fort Lauderdale operates a public municipal cemetery system under the Parks and Recreation Department, consisting of 4 cemeteries on 98 acres: Woodland, Evergreen, Sunset Park Gardens, Sunset Memorial Gardens, and Lauderdale Memorial Park. 3 of the cemeteries are currently active. No new interments are available at Woodland. The city is starting to begin with doing some more mausoleums that are coming in the future. The cemeteries have been owned by the city since 1917 and were managed and maintained by a private contractor since 1993. Contract management ended September 30th, 2018, with the city taking over operations in-house thereafter.
Pat, sorry.
Yes.
Sorry to interrupt you. Can I make a suggestion? Do you come up here? Would that be all right? Just so people can see you
Sure.
while you're speaking? Is that
Sure.
Just because they can't see
A lot
you.
of stuff laid out here, but
You-
sure, not a problem.
Okay, thanks. Yeah, put it right up here. Yeah, use this. Use up here for anything else you need.
Probably turn off that one, right? All right. The cemeteries have been owned by the city since 1917 and were managed and maintained by private contractors since 1993. And at September 30th, 2018, the city decided to bring operations in-house. Pursuant to the Code of Ordinances, Chapter 10, the City Commission appoints a cemetery board of trustees consisting of 10 members to administrate the operations of the cemetery system, as well as oversee the perpetual trust fund as trustors. The cemetery employs a trust fund to ensure necessary land maintenance in perpetuity. The city's finance director is designated as responsible for collection and separation of trust fund corpus and income and delivery of money to the trustee. As of September 30, 2023, the Perpetual Trust Care Fund held a balance of approximately $30.5 million. A pre-need trust also exists that is currently administered by the former private contractor, and this is purchases made in advance of need, and it's a nice way of saying it, I guess. This separate trust contains a balance previously collected by the private contractor for certain pre-need sales in the future. The pre-need trust carried a balance of approximately $5.4 million as of the audited period of September 2023. The Parks and Recreation Director employs two managers to separately direct cemeteries administrative office and grounds maintenance operations under one enterprise fund. The administration's office operates primarily includes sales of interment rights, property such as lots, plots, and niches and crypts, and merchandise and services controlled by a general price list. Merchandise primarily includes vaults and memorials. A city resident obtains a 25% discount for property and service of sales. Lastly, as the cemetery system owned and operated by a municipality, both operations are largely exempt from state regulations. During the first 4 years, cemeteries' in-house operations were profitable with approximately $5 million in revenues versus $4 million in expenditures. This success ended in fiscal year 23 when expenses outpaced revenues by approximately $500,000. The objectives of our audit was to determine that internal controls were adequately designed, there's efficiency and effectiveness of operations, safeguarding of records, and financial records are maintained properly. Now, our scope and methodology, the audit included an internal controls, a review of internal controls. The audit period included the first 5 years of in-house operations, which was October 1st, 2018 through September 30th, 2023. Our audit methodology included routine auditing things such as reviewing regulations, procedures, reviewing records reports, interviewing appropriate city staff, and third-party personnel performing analysis. And this audit was conducted with generally accepted governmental auditing standards. To summarize our conclusions, the auditor's office found that the cemetery's administration office operations were not effectively supervised. After the in-house transition in October of 2018, in accordance with Section 10-28 of the city ordinances, specifically, a comprehensive system of internal controls was not designed and implemented. An adequate record-keeping system was not created and maintained. Managerial duties relating to the perpetual trust and the pre-need trusts were not properly handled, and price reviews were incomplete and untimely. The key findings I did want to discuss are cemetery management's inability to expedite the implementation of a software management system, which is vital to collecting revenues of approximately $5 million annually from hundreds of customers, inclusive of credit sales, in a business that requires a long-term retention of accurate, important records. As of the end of the audit fieldwork in 2024, the turnkey software acquired in 2020 was not implemented, and no alternative backup accounting software was used as a temporary solution. In the 5 years since the in-house transition, cemeteries' administrative record keeping operated primarily based on filing system, a paper system using spreadsheets which were not properly controlled. Lack of oversight with the software implementation, coupled with a significant issue with the task of completing a historical clean data conversion, led to the conflict with the software vendor. The absence of accounting software and file management controls with inadequate oversight notably resulted in revenues continuously recorded a few months late in financial records. Also, errors and omissions within important cemeteries data supporting the city's financial reports that, despite years in-house staff effort to correct, still have not been remediated. Uncertainty by both cemeteries management and its credit customers of outstanding balances and relatively low prolonged collection rate over the years due to the inability to periodically bill the credit customers. As a result, we noted that individuals were compensated with their main job as to research and respond to customers' inquiries as their current balance and to determine what their current balances were. Also, exposure to loss of important voluminous hard copy files due to the absence of digital backups. From this condition, we recommended that, we need to get a software adequate for transaction recording and long-term file management. We need to centralize and digitize all our hard copy documents. And also, there's a lot of what they use the word scrubbing to correct errors and omissions in our legacy documents and our in-house recent transaction data in the last couple of years, basically using spreadsheets instead of an accounting software package. And I think going forward, and I've spoken with the city managers, that we want to go ahead now and get a new software package, but we also want to probably outsource the process of cleaning the data and have to do separate projects there, because I think we can go forward with a new software package for future sales and activity, but we do need to get that software, that's hard copies and some of the data that hasn't been able to put in the system by the prior software vendor. That was the biggest problem of why nothing happened, really didn't come to fruition by, this year after buying the software in 2020.
So the software we bought in 2020, is that just no good anymore?
Well, there was issues with it, and last current thing that we wanted was that their compliance with the SOC 2 requirements relating to how they safeguard information in their database was a concern. But there was a lot of back and forth over the years, not just with that. I think we started with a off-the-shelf program and wanted to do some changes to it. And there was a lot of stoppage. I don't know if you recall, in April of 23, since everything came to a stop, they tried to put together a 9-point plan to get everything rolling again, but that basically didn't come to fruition either. So at this point, I think we're moving along to getting a new one.
What kind of cost are we looking at for a new software program?
Well, I know we spent about $160,000 for the software in 2020, so it's probably that and probably a little bit more. I mean, you have to put out probably an RFP to determine what's available out there.
And then we have to pay people for data entry to put the hard copy stuff into it.
We should be able to do that on a brand new sale. We should be able to do that in-house.
A brand new sale, yeah. But I'm saying past sales.
Past sales, we got to clean up the data to migrate it into the software.
Into the software. Okay.
How many years of past sales are we talking about? We said 2020 we got the new software. When they started in 2020, how far was the backlog of entry to go into the system?
Oh, well, they continued operating using spreadsheets to record the transactions. So they just waited to. I mean, they kept rolling in operations, but that's one of the things that needs to be done too, is all the work that's been done through Excel and putting the current sales on Excel rather than having a software package. There's that data needs to be put in too. So that's not even really the legacy data from way past many years, but like the last couple of years.
So they never really used the new software. They just started using spreadsheets on Excel.
Right.
And one of the larger challenges was, as Pat said, the
Data conversion. There's a lot of work in moving data from the carriage system and the X number of years that we were doing it manually, and a lot of data validation. The other thing, when this came to our attention, we got our IT folks involved. The deputy director of IT did a very comprehensive review of the software to let us know, what we didn't do well at the first time, meaning we didn't have a project lead, we didn't necessarily have a good planning document. So there's some lessons learned from the initial implementation that will carry forward to the new one. We're looking at bringing forward a contract termination and considering a procurement waiver with some software that the cemetery board and staff have identified, but that will be coming sometime in the future.
Okay. All right. With the Perpetual Care Trust, we felt that that some of the withdrawals that were made out of the Perpetual Care Trust that were listed as reimbursements for operational maintenance expenses that were really fully covered by the operational profits of the operation. So we kind of questioned some of the expenditures. I know some of the withdrawals were. Actually, there was $6 million withdrawn from the Perpetual Care Trust, where only really $3 million was needed for capital project needs, and so we were kind of concerned that that needs to be monitored a little better to see what is really needed if they need to do that. Now, I know in the past there was discussion that 19% of the sale of plots go back into the perpetual, and like I said earlier, there's $30 million in the perpetual care, but that's really, got to really be monitored to make sure that that's going to last to cover maintenance for, for forever, really, for those cemeteries. So, we just kind of question that needs to be monitored. Finance does the process correctly in making the transfer, but and the board approves it, but I think in some cases it looked like it really did need to be used in the operations of the operation, had the money to do the reimbursement for maintenance.
So let me ask you a question on that, Pat. Did they violate the rules when they did that?
No, we were just basically saying that, we questioned that the necessity of those transfers. I mean, they can use that for some of the operations, but our point was that you didn't look like you really needed to bring any of that money over, since you had, revenue, you had profits from the operations.
So typically a finding is something where a rule has been broken. You're saying that they followed the rules, but you still have a finding. Well,
our concern is we didn't feel that there was a real good review of the need to transfer that money. Again, it was always all quoted as maintenance reimbursement, and it really is not the main purpose of the use of that perpetual care fund.
But it's permissible use of the perpetual care fund.
Well, I mean, it seems like it wasn't the best use of the funds, in our opinion, because you had the funds available. You had built up in some years $7 million in cash and cash equivalents there, so you didn't really need to do that. While that money was not earning interest and increasing the perpetual fund. So that was our point there.
Yeah, and I'll just note that management did disagree with this particular finding from the perspective that you're talking about, that it didn't violate anything. I think what they indicated is moving forward, they're going to work with the board to develop and document such policies to enhance the transparency, but we did not feel that any policies were violated.
Okay, so we're consistent with the rules. The board approved it, so we've done everything in accordance with our rules and regulations. Okay. It's just you're suggesting that you disagree with the board's decision to use the funds in the way they did.
Correct. It was.
Right. What period of time did that occur in? Was it over several years? Or?
Yeah, there's a Exhibit 5 that shows from 2018 through 2023, and you'll see multiple withdrawals, I think $1.5 million at some point each of the times, for a grand total of $6 million.
Got it. Thank you.
Okay, regarding the pre-need trust fund, that one's a kind of interesting one. The exchange of funds as owed between the cemeteries and the third-party pre-need trusts has not occurred for over 5 years, resulting in uncertainty about the significant accumulated balances owed by both parties. The situation is when we went in-house, we had the private contractor had built up more than $5 million in pre-need funds that we haven't accessed in over 5 years. And at the same time, the city is collecting on the receivables from those pre-need sales, but we're responsible to transfer that into the pre-need trust, but we haven't been doing that either. So I think when we went from privatization to in-house, we really needed to get that in place. But again, like 5 years have gone by now, and we haven't corrected that. So that's a real important thing that I was just bringing to the attention, that we really need to finalize and get access to those funds. We did a lot of legwork trying to figure out what the problem is. We don't have a pre-need license, and the company that's holding the $5 million of funds will not transfer the money to us unless we have a pre-need license, or we get someone who has a pre-need license that would transfer that. So that's kind of been the holdup. I've spoken to their side, and then I did a research with the people that handle all of the Division of Funeral, Cemetery, and Consumer Services in Tallahassee, and they explained to me, right now we are really exempt from a lot of the regulations the way we're set up right now. But if we do get in our own pre-need license, we will be under a lot more review by the state. But what we learned could happen is you could create a cemetery company, which would lead to getting a pre-need license. But I don't know if the city wants to really go there. That's just another thing to throw up and see if we want to do that. Maybe we don't ever want to get into pre-need merchandise sales and continue how we've been going with just the right to sell the plots, but we can only sell merchandise once it's in need type of
I'm just thinking like T-shirts and things.
No, like memorials and things like that.
Could I ask a question? I don't want us to get in the business of doing this ourselves for a variety of reasons. This is not a path we should be going down. However, could we just do an RFP for a third party to handle pre-need?
We've talked about that. We're kind of batting that around as one of the options to solve.
Okay. We have been talking about this for a while, so at what point do we come to a conclusion on how we're going to resolve this issue?
Soon. We'll get it going. We've met with the attorney's office, with the staff from the cemetery, with the auditors. We all got together and just talked about the different ways that, because we have to find a path forward. There's no question we have to find a path forward. So yeah, we're looking at it.
Soon, sometime this fiscal year?
Yeah.
Okay.
So, Susan, while we're on this topic, and I know that we've talked about this during our pre-agenda meeting, and no pun intended, but what is the end game with these cemeteries? I mean, soon we don't even have any space, right? I mean, that's dwindling. So then what? We just maintain and what? And that, I mean, why? I've never understood why we're actually in this business at all, and yet I don't know what the options are, but I agree with what I'm hearing. I'd like to see us really move on this, because I just don't even know if it makes sense for us to be in this business at all.
Right, and that's something I think we should probably kind of give a conference presentation and have a little bit more time to get some direction from the commission as far as what, our involvement, and 100% outsource parts of it, outsource, all of it, when we had outsourced the whole thing before, I think that they weren't super successful, but there might be pieces of it that we can. So I think just a conference presentation with some options, and it looks like Carl is standing up. So I think that, and we'll give him some time to get to the podium.
I just have one question for
Got
Pat.
it.
So Pat, how often do we conduct an audit like this that we just did, that you just did?
Not that often. There was an audit done in 2016 when we were still under a private company running it, and I just thought it would be a good idea since we brought it in-house and we haven't looked at it in a while that we would add that to our audit plan. That's how we ended up doing the audit.
And I thank you for that because I do find it very thorough. It's troubling in that there's a lot to unpack here, and I know there's a lot of back and forth with management response, and but obviously maybe every 8 years is a little too long. But obviously a lot's happened in the last 8 years. But there's definitely a lot of issues. So
Can I just interject something here to your question? The reason why we took it back in-house is because we did farm it out to the carriage group.
Right.
And it was an absolute disaster. They were mismanaging it. They were losing money. It was just a disaster. So taking it in-house was to restore people's confidence in the ability to manage it as well as to properly manage things. So we've not had a good history of privatizing our cemetery system. So I think that's why, to answer your question, that's why we're doing it.
Do we know how common it is for municipalities, whether it's Broward County or anywhere else, to actually operate a cemetery system?
I think we've had some data on that, Carl, because I know you've done some research for us as far as some of the places that have them.
Good afternoon, Mayor and Commissioners. Carl Williams, Parks and Recreation Director. So there are municipalities that perform cemetery operational functions. However, it's not apples to apples with what we provide. With our 4 cemeteries, you may have some of the local cities may have 1 or 2, but not to the size that we have. In addition, with the staffing that we provided to provide these here services, also add to that as well. When we took it over from the previous vendor, we had to ramp up operations fairly quickly, equipment, fleet, staffing, the whole 9 to be able to function as a true business.
And do you think it's wise for us as a city to be in the cemetery business?
So what I will say is that I think that we've learned quite a bit with our taking this over. It's not something that we normally do. Now, to the manager's point earlier, was that we've outsourced this in the past. And a few years ago, we even took out an RFP to just outsource a portion of it, whether that's the burial part portion, the maintenance portion, and then the whole gamut all together. And we didn't get responses. Partly of that is due to the fact that we don't have a large inventory of revenue-making places in the city. Outside of Lauderdale Memorial Cemetery, our other cemeteries are either full or about to be full. And so from a outsider coming in looking to generate some revenue, those are some of the challenges that they would look at in trying to take this over.
Sure. So with that being said, how do we generate revenue going into the future if all of these other companies would say, well, there's no way to generate revenue?
So we would continue with our operations as we have them now. I mean, over the course of the last year, minus the year that the auditor mentioned, we've been in a positive revenue situation. Now, granted, some of those years were COVID years that also impacted some of the increase in revenue, but our team at the cemetery has done an outstanding job of kind of continuing to try to stay above ground, if you will, on the work.
Speaking about above ground, do we have space in the 4 cemeteries for the addition of mausoleums? I know, obviously, we don't have the land for burials, but what about other options?
You're correct. So we currently are in the process to add, I believe, 3 new mausoleums at Sunset Memorial Cemetery. But as quickly as we get those up, those will be filled relatively quickly, especially at the pace that we've been moving in the in the recent past. So the only cemetery that we really have the appropriate amount of space is Lauderdale Memorial.
Okay. So again, I just think that this really necessitates discussions, reports, a deeper dive, and as going forward, it just makes sense. So many questions, and again, thank you for the audit. Also, Pat, I think it's very thorough, but when you see the back and forth between your department and management, there's still a lot of unanswered questions and things that I think that we could just be addressing a little bit better.
So Carl, on these cemeteries that are full, what's the income that we're using in order to maintain perpetual care? Is it the interest income on the trust fund?
So that is So we utilize those funds to do all the trimming, the cutting, the detail work of all those cemeteries, and that's all part of that.
And it doesn't come out of the general fund, right?
Correct.
Okay, so it's not like a Ponzi scheme where we need to sell new plots in order to pay for past plots, right?
No.
Okay. So it's self-perpetuating. Okay. Any further questions? Any more of your report, Pat?
Just one little piece that we had noted that we just think we looked at the pricing and compared to the local markets, and we felt that should be done more often than I think it was quite a while. I think that we looked at the prices. So I mean, and there's other issues. I don't know. I looked at a lot of other cemeteries, and some people, some
you need to get a life, Pat.
Well, no,
if you're going around looking at cemeteries.
No, some other cemeteries only allow the residents of that city to
be able to bury their citizens there.
So like that was I found that a lot. So that's something because that would because we allow non-residents also now. So I think we always have. So. That's one thing that a lot of people think of. And the other day when we were talking about, just the future of it, I did try to get some information from the biggest company. It's Service Corporation International, and they do buy cemeteries. But again, I think a vice mayor's point is that they've got to have at least a way to have a revenue source happening there. So. I mean, for example, Sunset Memorial, we're building up. We're not, have the land available. But I don't know if that would be something to be an option if we were, possibly wanting to get out of that business.
Maybe live local.
Yeah.
I don't think we're going to find anybody that wants to buy a closed cemetery. So the only market is going to be for somebody. Look, I dealt with a prior contractor, Carriage. So Carriage used to have an evergreen contract where we never even put it out to bid. We finally put it out to bid, and we wound up with the same vendor, and we had them for years and years, and we finally got rid of them for a number of improprieties in their oversight and management of the system, which is why. As the mayor pointed out, we brought it back in-house. Right. But, with regard to the pricing schedule, the policy decision was made by the Cemetery Trust Board and endorsed by the commission that we want to keep this as a low-cost option for residents. We're not trying to maximize profits on this. The goal of the cemetery system is not to make money. The goal of the cemetery system is to provide a low-cost option for people to be able to bury their loved ones and be local and be able to visit them and so forth. The idea is that we make enough money so that we hopefully don't have to use general fund to do ongoing maintenance. But when a cemetery is completely filled up, when it is built out, so to speak, our maintenance obligations with respect to that really come down to mowing the grass. I mean, this is something that the Parks Department can handle. So when we talk about perpetual maintenance, we're not really talking about substantial amounts of improvement. These aren't buildings that are going to be falling down. So I think there's a misnomer when we look at perpetual care. The perpetual care 90% is what the state has put in place primarily for privately run cemeteries. We're following the same guidelines that a privately run cemetery has, and that's because once a cemetery is filled up, that privately run cemetery no longer has a revenue stream to support the perpetual care of those graves. We're not in the same position. The city isn't going anywhere. We will provide perpetual care for our cemeteries as long as the city exists, and cities have perpetual life. So I don't have that concern. I want to get that out there, that we're not trying to make money off of our residents when it comes to helping them plan for the final needs of their loved ones. We need to get away from that concept that we're trying to maximize revenue off of everybody everywhere we can.
Well, I didn't really. That was not my intention, but my point was we need to be somewhere in a break-even analysis for that, because there are expenses related to.
Actually, we don't. That's a policy decision. That's what I'm saying. Okay, that's a policy decision for the cemetery trust, which under the charter has the authority to make decisions with respect to spending for the cemetery system, and then for the city commission to weigh in. So it's something for them to consider, but at the end of the day, the city will be responsible for ensuring the care of the grave sites and making sure that it's done in a respectful way. So I get what you're saying, but at the end of the day, Pat, those are policy decisions.
Right, but I think what he's saying is that we are financially stable enough.
We are financially
stable.
stable.
Don't have to delve into the general funds.
We don't have to. I agree, but we also don't need to be talking about making sure that we're looking at prices and everything else on a regular basis. I don't like that idea, Mayor, because the cemetery system is not designed, set up, or operated in such a way as to maximize revenue.
Your point is well taken. The one thing we may want to revisit is whether or not we should continue to sell plots to non-residents. I think that's a great idea. Yeah, as we have a diminishing supply. Okay, all right. Any further comments?
That pretty much wraps up my
all
report.
Right. Well, thank you very much.
Thank you,
very
Pat.
comprehensive.
Yeah,
and thank you so much. Carl, do you have anything else you'd like to add? You're going to open a soccer field on it's Parks and Recreation.
No soccer field.
No, okay.
No, I just want to briefly talk about our next steps. Once we had our initial conversations about the audit, we and the manager already touched on this, is that in March we do plan on coming to you to get out of the current, terminate the agreement that we currently have with the provider for our cemetery software. And as such, we are going to be having some demonstrations from a few companies that provide cemetery services and accounts receivable software. And we'll be coming to you, my hope is prior to summer, to get a waiver on ordinance rules to allow us to proceed to select a vendor to provide us with a software so that we can move forward with and also cleanse the data.
Okay, very good. Thank you so much. All right, very good. Susan, did you want to add anything to this?
Nope, all good. Thank you.
Okay, thank you. So we're a little ahead of our executive closed door session, so we might want to just move into commission reports. And so at this point, I would like to invite District 1 Commissioner Herbst, if you have any report. Okay. Commissioner Beasley Pittman?
I'm going to pass today. I do not.
Vice Mayor?
Thank you, Mayor. Now I have so much extra time. Yeah. This is great. Thank you. I'll go very quickly. Thank you. Wanted to congratulate the team over at the St. Regis Resort and Residences last Thursday, actually a couple of Thursdays ago. The opening of the sales center was quite a festive occasion, a lot of excitement generated from that event, not just on the Barrier Island, but for the entire city. Monday, February 10th, I really appreciate the staff's work. I attended at the Beach Community Center one of our scheduled noise ordinance update meetings for the residents of District 2. Also that evening, the in-person stormwater update for Fortify Lauderdale took place at the Progresso Village Civic Association meeting. Thursday, February 13th. Again, thank you to staff. A lot of fun at Neighbor Support Night. Had a good time. Thank you to the Flying L's Marching Band, Fort Lauderdale High School, for opening up the evening. A lot of fun. Great seeing the energy. All of the folks from the community that come out and really get the opportunity to meet with staff. It's a really terrific evening every year when everyone gets a chance to spend some time together and see exactly what happens and the fine work that's done by staff. So thank you for that. Tomorrow, I'll have my District 2 President's Roundtable, where we'll be bringing together all of the folks from the district, the Neighborhood Association presidents. I'll thank Chris Cooper in advance. We've talked a lot today about homelessness, and he will be our guest speaker tomorrow at our President's Roundtable. I am also very much looking forward to participating. History Fort Lauderdale is opening up a new permanent exhibit tomorrow, and I'm really looking forward to it. It's actually called Roots of Resilience, and it is a permanent exhibit at the Inn, basically commemorating the rich history, the enduring impact of the Fort Lauderdale and Broward County Black community from 1793 to the present, and I will be very much looking forward to participating in that ceremony tomorrow. Also tomorrow we have the grand opening of Timber on West Las Olas Boulevard, and also at Savor Cinemas from South Florida with Love. Genvis is doing that evening. That's the Generation Venetian Arts Society. They do a lot of amazing arts and cultural work throughout the year in our city. And then this Friday we have the annual Greater Fort Lauderdale Chamber of Commerce Luncheon at the Marriott Harbor Beach Hotel. And I think that's it from me, Mayor. Thank you.
Okay, Commissioner Sorensen.
Thank you, Mayor. One or two events coming up. Ignite Broward, their lighting installation at Esplanade Park. It's open until February 23rd and free, so check that out.
I was there.
Were you there?
The
Good.
other night. Yeah,
It was cool.
Seen it yet. It was cool. I did where the Esplanade Park is. Yeah.
Yeah. Great. Let's see. A couple topical questions. I talked with David about this. City Clerk, electronic campaign finance reporting. So, Mayor? I think, I don't know when, maybe a couple years ago, but we went to partial electronic filing. And so I think the next step is requiring all filing to be electronic for ease of use, archiving, and so forth. So what can we do towards that next step? I'd like to kind of explore that in moving it forward. David, what's your...
So if there was a commission consensus for that, we would have to pass either a resolution or ordinance requiring to make it strictly one reporting way.
Yep. And this is don't a lot of municipalities do this? It's electronic solely?
Most of them that implemented the system have gone simply to only electronic.
Okay. So if you all are open to that, I'd like to
how would that
move
work?
that. Yep.
So the system is something that we pay yearly into. It's we have the contract with the supervisor of elections, so it's free for anyone to use that is running for office. And once they file with our office, then we provide them with all the information of login and all that.
Okay. Doesn't affect me, but
great. Yes, as you coast into retirement.
A lot of old school people, still like manual and paper, and
right.
Sometimes
are you ready for anything again?
I'm just saying. I'm just talking. I'm just trying to present the discussion topics that you might hear.
Yes.
Because also, sometimes there's a glitch in the system, and it's not a bad idea to have that as a backup. I'm just saying. Right. I mean, I haven't thought it out like that as much as you have, but I'm just thinking that sometimes people like the options of either doing that filing manually or electronically. That's all, just a thought.
Okay.
Yeah. And I would say you could have the paper version. Could people come into the city clerk's office if they didn't have the technology or understanding and you help them file it or scan it? Is there an option for that?
I couldn't really assist them with that
Right.
because I think that would be crossing into it.
Yep.
But whether we could provide a computer to do it for that, maybe. It all depends. The reports you have to individually put in. So I'd check with probably Dwayne to make sure that's something we're allowed to offer.
We'd have to research that and get back to you.
Okay. Well, let's, if you all are all right, let's move forward with trying to digitize everything.
Getting a yes, no. Okay. So if it is all submitted digitally, you can, with the option, if you don't like looking at the report virtually, you can select an option where it pulls it up as a PDF that looks like the report that's put in manual. That's one of the options once it's in there.
Mm-hmm.
You can have it brought into the individual one if that's how you like to view it, which actually I do better than it.
Well, it's an option. Yeah. I think it should be an available option for those who prefer using, electronic filing.
I would say with some feedback that I received that it was confusing that there were reports in two different places. So I guess that would be the argument for or removing it altogether is that we couldn't really have the reports that are submitted in hand be in the same area as the electronic ones. So people were saying some people's reports are in one place, another person's within the database, so it gets a little confusing.
Actually, it was a lot easier to read the manual reports rather than when you clicked on to try and read all the electronic reports. You couldn't just go to one. I mean, actually, it is easier to read and look at the ones that are filed manually than it is to look at the ones that are filed digitally. That's just true.
All right, so let's revisit that.
In terms of reading, it's just a matter of improving the technology provider. It sounds like there's not interest to do that. We've just as a city, it's going to be helpful for us to move into electronic document storage. So like right now we spend tens of thousands of dollars on document storage, hundreds of thousands. So it's something for us to really think about in terms of cost savings, efficiency, to really move towards the electronic submission. So, okay. Well, I guess there's not support for that right now, but maybe another time. Great. What happened to our joint meeting with the county commission? It was canceled, and I want to understand why and what. Yeah.
So what happened was we had a joint meeting planned, and Russ Clennett had a pre-meeting with members of the county, and reported to me that he advised us not to meet yet because he thought he had made progress, and he thought that it would be counterproductive to raise issues that he felt had now been resolved, and that he asked for our patience in not having the meeting at the day we had planned to have the meeting. So we took that as an opportunity to allow him and others who were moving forward on trying to achieve consensus with the county and see where it would go. However, Susan Susan and I had a conversation, and we just said, okay, then let's cancel the meeting. If on their advice that it was
Or reschedule.
And reschedule, not cancel the meeting, but reschedule it because they were making progress on achieving a common consensus. Then we found out that maybe those representations that Russ thought he had heard may not have been as solid as he thought they were. But I have since had a conversation with the mayor of the county. We met at his request. We had breakfast last week. And it seems that they are farther along in achieving a consensus with the city on a tunnel than they previously were. And so Russ's understanding was correct. And now it seems that they're not so much against the tunnel as they are now in trying to seek what sources for funding are available. They have tentatively represented to us that the money that they were going to spend for the bridge, the $250 million, would be could conceivably be made available to us towards the construction of the tunnel. Why is that important? It's important because whatever funding we get from the state or the federal government, we would need a local match. And the local match usually is about 1/4 of the total. So the last representation that we had from BDO was the tunnel would be about $888 million, all in. A $250 million contribution would exceed the 25% match. My understanding now is that that $888 million is probably going to be at the low end. It'll probably be more than that. So if it went to $1 billion, the $250 million is still the 25% match. So we seem to have, we're getting close. We're getting really, really close. But I still thought it was going to be appropriate that we reschedule. And did we get a rescheduled date?
So they initially proffered a March 11th date. However, that is the same time as the National League of Cities meeting. So I asked them to hold on to that, but give me another date.
National League of Cities, that's the national conference in DC? Okay. And you're attending that?
I think it's the 9th through the 12th is the NLC.
And you're attending that? Okay.
So I asked them to give me another date.
So sooner than later we will be able to meet with them again. But your concern is as great as mine, and but I feel that if we seem to be making headway, and because the mayor Beam Fur asked to meet with me, in which we did meet, I told him I was going to report back to my commission to tell him what the status would be of the counties willing to participate in a tunnel approach, and he said, "Fine, go ahead and make those representations." So that's where we are now. But we do need to meet. But we should meet not just on the tunnel. I'd like to meet on homelessness. I'd like to meet on, are they building their joint government center? I've now heard that maybe that's on hold. So, there are all kinds of things that I think we could probably talk about in 2 hours, and I think we as a commission should make some sort of short agenda that we can all agree upon that we would like to discuss at such a joint meeting.
Sure. So that all sounds positive, but we agreed that we were going to meet, and so I'm disappointed that meeting was canceled. There's a lot of communication that I've been having with county commissioners and the Mayor Beam Fur as well.
Did he represent the same things to you then?
Making good progress, yeah. Making good progress, but
he too said it was probably not the right time to have had the meeting. He told me, I'm glad. He said, I believe he said to me, it's good that we continue having our outside discussions and we continue to talk with all the commissioners and to build a consensus so that when we do have a meeting, we'll be able to, instead of it being contentious, it will be an opportunity to have a general understanding of how we're going to move forward. So there's no time wasted, and I don't think there's any opportunity wasted. But I do think that maybe we could have had the meeting, but we didn't. So now we're going to have to reschedule, and hopefully we'll make more progress between now and then.
Okay. Well, great. And my ask would be, can we please not cancel at the last minute again? Is that fair?
Yeah. I agree.
Okay. All right. So what, Susan, do you need from us should we suggest alternative dates to you? It sounds like March.
So the county is going to be sending me some dates back, and as soon as we get them, we'll start socializing with you
All right, the sooner
on those
the better.
dates.
Okay. All right. Thank you. Thanks. That's all I've got. Thank you.
Mayor, one last thing with
Yeah,
that.
go
though.
ahead.
So, as I've heard from the county, is they've essentially said we're going to limit our contribution to $250 million. If you want to take it and go assume control of the project, go right ahead. I hope that's not where we're going with that, so that the city would somehow be on the hook for any cost overruns or anything else, because that's what I've understood is like, you want the project, here's $250 million, go run with it. So I'm hoping that's not the tone, direction, and desired outcome for that. Because if it is, I'm adamantly opposed to that in every way, shape, or form.
Yeah, I don't think anyone thinks that this is going to be a city responsibility. This is the county intends to own the project, and it's a project. It's a transportation project of regional significance, so it's going to impact more than just Fort Lauderdale, and so. But I do think it's a step forward, and they're agreeing that we could build a tunnel. That would be their contribution, and I think that once we have I think BDO is coming back to us soon.
I think Ben told me end of the month of February that we'd have the final BDO.
That's still correct then?
Yeah, we should just ask BDO.
Good afternoon, Mayor, Commissioners. Ben Rogers, Acting Assistant City Manager. So BDO is in the final stages of their study that we asked them to do on the bridge, the TY Lynn report. They should have that to us by the end of this month, and then we can have them here on March 4th or March 18th, depending on the Commission's desire.
Okay, so if we can have it on March 4th, that will give us a better understanding as to what kind of numbers we're looking at, correct? And if we have up-to-date numbers, we'll have a better there'll be more points of discussion that we can have with the county at our next meeting that based on real numbers. So, okay.
Could we also get some discussion about the new administration's, let's say, desire to cut back on funding projects throughout the country as well as everything else? Because I think any chance of getting any real funding out of the federal government is probably going up in smoke. So I'd like some discussion about that, because the last thing I read in the Wall Street Journal talking about them funding train projects was not a snowball's chance in hell. So I'd like some discussion about that, because if there's no federal funds for this, I think we're all wasting our time. And that's bridge or tunnel. I don't, I think no pun intended, but that ship may have sailed.
Well, you may be right, and it'd be unfortunate if that's the case, but let's still have our conversations and see where we can go with this.
I'm not that pessimistic about it. I still think there are enough people that have enough say and connections, and I think we're going to have to maybe rely on some partners and look at new ways of going about this. But I still think it's worth the effort.
Okay. So, yeah, I don't think Commissioner Herbst is saying let's stop. He just says let's be realistic going forward.
So, Mayor, if I can confirm real quick, BDO on March 4th, they'll be providing their updated study on the TY Lynn report. They'll be touching on the inflationary impacts on the tunnel costs since the last time that they provided that update, and then an overview on federal funding opportunities.
Good.
All right, thank you.
Yep. That might be the whole afternoon. Okay. Any other questions or comments?
Nope, that's it. Thanks.
Okay, great. Thank you. Just a few things. A lot of us attended. It was really a great opportunity for the city to appreciate what's happening at the Bahia Mar on February 6th. They had the launch party for the St. Regis Hotel and Residences, and looking forward to seeing that happening. As many of you know, the sooner they build those residences and close on the purchases, the city will start to see some significant funding coming into our general fund, which would be great for us to cover many of our expenses going forward. I participated in a panel discussion on the state of the city. The Ombel developers held a panel discussion on February 12th in front of about 80 realtors and other investors in our community. It was really a great panel that we had, and a lot of good feedback from the audience. let's see. Also that day, we had an event at the Tower Club. The Chamber of Commerce of Taiwan held an event with the Director General of Taiwan participating. There were about 70, 80 people there. It was another opportunity to connect with our sister city partners as well as the Taiwan Chamber. That same night, I attended the Winterfest Captain's Cup presentation. That's an opportunity where the Winterfest organization recognizes sponsors and other participants with various awards. The city of Fort Lauderdale received 3 such awards, and they're hanging somewhere. So very happy to receive those awards on behalf of the city. The following day, the city participated with the Council General of Israel. We had a Tu B'Shavat tree planting over in District 1. We have a new park on Federal Highway, which needed to be popularized, and I think maybe bringing attention to it by having the tree planting was a great way to start. It's a nice little pocket park right there on Federal Highway. The next night, that same night, we had the neighborhood support night, and as the vice mayor said, it was really a great opportunity for people to come out. I think it was probably the best attended one I ever went to, and I want to thank each and every member of our staff, over 2,800 who work for the city. Thank you for all that you do and the commitment and dedication that you have towards the betterment of our city. And I think it showed in many ways at the neighborhood support night. It excited a lot of people to be there, and you were there to answer lots of questions that people had. So thank you again. On the 15th, Saturday morning, this past Saturday, I attended the Fire Rescue Remembrance Ceremony. This is a ceremony in which members of our firefighters community have passed away, and where many families came together in remembrance of their dads, their uncles, their moms, their aunts who once worked for the city of Fort Lauderdale for greater than 20 years, and there were many people who reached that milestone. On the 16th, I spoke at the closing party of the Florida Sunshine Cup. It was a national tournament which comes to Fort Lauderdale every year. It's made up of the LGBT community. Over 800 people from around the country came and participated in the flag football tournament, and for 3 days they played their hearts out. And that night, Sunday night, they had the closing party, and it was just an amazing event. And it was held at the America's Backyard here off of Himmershey Street. Let's see. You mentioned a number of other things, so I don't want. We're having the Greater Fort Lauderdale Chamber of Commerce annual lunch. That's on February 21st. I believe that the city bought a table. Yeah, either the city or the airport, one or the other. Yeah.
Yes.
So if anyone's interested in coming, please let Susan know so she can make sure you have a seat at our table. Let's see. NSU. The NSU Museum is on February 23rd is having a Neighbor Day in which the community is invited for the free exhibit of Surrounded Island. This is the new exhibit that the city has it has been donated to the city of Fort Lauderdale. This was when the islands in Miami Harbor were surrounded in pink plastic. Who was it?
The artist was Christo.
Christo, right?
We have a proclamation for that this evening.
Yes, we do. And so it's at noon at the Art Museum. Again, it's February 23rd, and it's open to the community. Let's see. A couple new restaurants opening on Las Olas Boulevard. February 26th, the opening of 60 Vines Las Olas. That's at 6:30 p.m. And then following that, on the 28th of February, the opening of Earl's Restaurant at 5 p.m. Both great new restaurants. Really looking forward to it. Let's see. So I know this is a touchy subject, but let's face it, we've got to deal with it. There were multiple letters to the editor in the Sun Sentinel newspaper today regarding water bill spikes, and I know that we're trying to address that with the changing out of all the water meters and digitizing them instead of relying on the old-fashioned system. But I don't know if anyone has any comments on this. I know each and every one of us has made statements regarding this and the frustrations that we have all suffered through. But does anyone else want to add to the conversation? Because I know it's going to keep coming up.
Mayor, if I may as well.
Yeah, please go ahead, Susan.
Yeah. So when Steve Bousquet contacted us and let us know that he was running the piece, he asked if we had a statement. And we responded that it would be really difficult to give a statement until we knew what type of issues. So he brought examples of, I think, 3 or 4 of those folks. And we addressed each and every one of them. In one case, it was a leak. In another case, it was someone...
Was it a verified leak?
Yes. Another case, it was someone who didn't have an irrigation meter. And, you know, when we talk about the rate increase happened October 1, along with dry season and an increase because of not having an irrigation or separate irrigation meter, it was that. So we've addressed each and every one. We did provide him a 2-page response as far as different things, as far as education, irrigation meters, the AMI system, the water plant, and the necessity for the rate increase. Not all of that was included in the article, but we were going to prepare a response memo for the commission to look at and provide to him and anyone else. We have updated everything on our website as far as, you know, what the rate increases are, how folks, if they do suspect they either have a leak or an unexplained increase, what the process is to, you know, receive that partial credit. So getting more word out on all of that.
Okay. All right. Well, the sooner we get these new meters in, the better. I mean, we've been begging for these things for years, so we appreciate whatever efforts can be made to try to accelerate that process. Anyone else have any comments or amendments to their reports? City Manager, do you have any report?
Yes, I was just going to talk about spring break if I can. City staff are finalizing the operational planning efforts through cross-departmental coordination, stakeholder meetings, and lessons learned from previous years. February 10th, I sent out a memo declaring a high-impact event, spring break, between February 23rd and April 12th. This allows additional prohibitive measures be implemented, such as the no coolers or tents on the beach, no amplified noise, and other items. The peak periods are expected to be the week of March 9th and March 16th. In advance of that, barriers along A1A and message boards are scheduled to be deployed the week of February 23rd. Police, fire, ocean rescue, and parking staffing levels will be increased during the entire month of March. A series of stakeholder meetings are being held in advance of spring break to share the plan and gain community feedback. This is coordinating with the Central Beach Alliance, the Beach Improvement District, District 4 Barrier Island Working Group, and Himarshi Entertainment District. And if you look on our website, fortlauderdale.gov/spring break, it's been updated with all kinds of information for our spring breakers and the community. And a press conference is scheduled for February 26th, and you're all invited if you'd like to. With additional community messaging efforts thereafter.
All right, great, thank you. Dwayne, do you have any report?
No.
Okay, so do you have it says manager commission follow-up items. There's really nothing else you want to add to your report?
No, just what has been posted on there.
Okay, great. All right, so the conference meeting is now concluded. We have a closed-door session. Are we doing it here or downstairs? We'll do that after the CRA. So are we going to do downstairs?
Yes.
Okay. So the commission will reconvene in the downstairs to do the closed door session. We should be back by about 5:15 or 5:30, at which time we'll do the CRA meeting.
Do you have to make the announcement? Do you have the script, Mayor?
Yes. Yes. Thank you for reminding me. Okay, so At this time, the City Commission shall meet privately to conduct discussions between the City Manager, the City Attorney, and the City Commission relative to pending litigation pursuant to Section 286.011 parentheses 8 Florida statutes in connection with the following matter. 625 Fusion LLC doing business as Red Door Asian Bistro et al. Versus the City of Fort Lauderdale and Robert Gonzalez. Case number CACE 19CV 61308 RKA. Present at the attorney-client session will be myself, Mayor Dean Trantalis, Vice Mayor Commissioner Stephen Glassman, Commissioner John C. Herbst, Commissioner Pamela Beasley Pittman, Commissioner Ben Sorensen, Acting City Manager Susan Grant, Interim City Attorney Dwayne M. Spence, Assistant City Attorney Robert Oldershaw, Outside Counsel Hudson C. Gill, Esquire, and Certified Court Reporter from Bailey Enton Court Reporting. The estimated length of the session will be approximately 20 minutes. Good afternoon, everybody, and welcome to the back to the City Commission. We're going to begin our Community Redevelopment Agency Board meeting, and Mr. Clerk, if you could please call the roll.
Commissioner Herbst. Present. Vice Chair Glassman.
Here.
Commissioner Beasley Pittman.
Here.
Commissioner Sorensen.
Here.
Chair Trentalis.
Here. We have a full attendance. So we'll start with our agenda. M1, motion approving minutes for the January 22nd, 2025 Community Redevelopment Agency Board meeting minutes. Someone like to move that item?
So moved.
Do I hear a second?
Second.
Moved and seconded. Please call the roll.
Commissioner Beasley Pittman.
Yes.
Commissioner Sorensen.
Yes.
Commissioner Herbst.
Yes.
Vice Chair Glassman.
Yes.
Chair Trentalis.
Yes. So M1 is now approved. R1, so resolution approving a second amendment to the interlocal agreement for the 4th Avenue Complete Street Project between Broward County, the City of Fort Lauderdale, and the Fort Lauderdale Community Redevelopment Agency. Anyone have any questions with regard to that item? There being none, would someone like to introduce the resolution?
Introduced.
The resolution's been introduced. Please call the roll.
A resolution of the Board of Commissioners of the Fort Lauderdale Community Redevelopment Agency approving a second amendment to an interlocal agreement among Broward County, the City of Fort Lauderdale, and the City of Fort Lauderdale Community Redevelopment Agency to extend the term of the interlocal agreement and providing for an effective date. Commissioner Beasley Pittman.
Yes.
Commissioner Sorensen.
Oh, hold on. Sorry. Before we take the vote,
Okay.
we have a person who signed up to speak. Troy. Sorry, Troy.
That's okay. It's been a long day.
Hit the button there.
Yep. That's okay. It's been a long day, and I know you have a long evening, so I'll be quick.
No, it's okay. Take your time.
Okay.
I just pulled the timer out.
That's okay.
Well, the cord was too short.
Who's in charge of technology?
We need to digitize.
Hourglass.
An hourglass. Exactly. We need an hourglass. Papyrus. Exactly. Like the Wizard of Oz. Thank you. All right. You have 3 minutes, Troy.
Okay. My name is Troy Liggett. I'm president of the Middle River Terrace Neighborhood Association. Thank you for giving me this opportunity. I'm here to speak on this resolution for 2 reasons. First, I don't think the memorandum and the information you have before you accurately reflects what's happening here. And second, I want to explain to you what is happening with this project. First, this is simply putting in sidewalks for 2 blocks on 4th Avenue. If you're familiar with the Home Depot, it's basically the 2 blocks just north of that. This project has been under the works for now 4 years, and they're asking for a 5th. It's been under construction for 1.5 years, and this is just 2 blocks of sidewalk. This commission approved the contract for this project in June of 2023, and it was set to commence in September of that year. And it did, They came in and plowed up all the sidewalks on the east side of those 2 blocks in the first week of September in 2023. The project was supposed to be in 2 phases. The first was the sidewalks and trees, followed by the lighting. They had a contractor. You approved the contract in June 2023 to do the sidewalks and trees. It's supposed to be followed immediately by the lighting. The 2 blocks that tore up for 9 months. And the neighborhood, the 2 neighborhood associations, the Central City Alliance were pressing what's going on. In the contract you approved, there was a substantial completion date of 270 days after it commenced, which was coming up in June of 2024. Approaching June of 2024, the project was still just kind of sitting there. I know that they were working some days, but not most. About that time, they had an on-site meeting and they invited me as the neighborhood president to ask what was going on. And we learned at that meeting that it was attended by FPL, who was going to do the lighting, the engineer, the contract, and the city project manager. And FPL, they started the meeting like, okay, FPL, please give us an update on what's going to happen with the lighting, because it's supposed to start when the project's completed September 1st. FPL said, we don't know what you're talking about. You sent this project several years ago. You sent us a contract, but it was never completed. And FPL also said, and when they installed the contracts, I was there with, they're looking at them, they're looking down at the conduit. They said, and we can't install the lighting there because the contractor never got with us and they couldn't do it. So you'll see in the memo.
So all right.
Yeah.
So Clarence, do you want to respond to this?
And Kristen Thompson from our TAM, Transportation and Mobility, is able to respond as well.
I mean, I witnessed the sidewalk thing. It did take forever.
Right.
I mean, we had complaints from businesses on there, because customers couldn't walk to their business because the sidewalks were ditches.
Right.
Do you want to step aside just a second? Let's see what staff has to say.
Thank you, Mr. Mayor, members of the commission. I'd like to have Sija Minjabar, who's the project manager from the CRA, who has all of the intricate details about what went on, as well as Christian, who can give you some clarity about what actually happened.
Okay.
Good evening, Mayor and Commission. So the project did take a long time. I've had meetings, several conversations with Troy to talk about the series of events. Unfortunately, sometimes when you give a contractor 270 days to complete a contract, they actually take 270 days to complete that project. It did sit. We had concerns. We did share those concerns with the contractor. But the project was completed within the substantial completion and final completion date for that contractor. The lighting, though, however, was not in the scope of work for that contractor. So that was something that was going to come after this contractor was on board. And to clarify, there was an FPL agreement that was initiated. City staff, Corey Collier at the time, did sign the agreement. It was forwarded to FPL. There were, again, some unforeseen situations that FPL did not turn back in the agreement. It was not executed. And so we could not move forward with the FPL agreement, which now we went to solicitation for bid to have the lighting done by an outside contractor.
So all the time that the sidewalks were being installed, you're saying that no one followed up with FP&L in the interim to figure out why their contract was not signed or their work commenced?
Correct. So I think at the time of the transition, there were, unfortunately, between 2019 and 2023, there were 3 project managers within TAM that held this project. There were some concerns with the handover and things that were missed. And I think because Parks was working with the agreement and had sent it over, our project managers, there was a heavy oversight for the execution of that agreement and the move forward. Once FPL was notified, they did come out to rectify it, but the equipment that was installed by the contractor was not the actual equipment that FPL would be able to move forward on. And because the contract that was executed in 2023 for the contractor and then the substantial completion, once it was actually completed, the agreement for FPL, the same type of agreement, was no longer, I guess, in effect with FPL. So they were unable to use the same type of agreement that we were trying to pick up and honor once we identified the error.
You know, this doesn't bode well as we are trying to, undertake a citywide sidewalk effort to try to install sidewalks throughout the city. And if we're talking about it taking 4 years to build 2 blocks of sidewalks, this is just makes no sense to me whatsoever.
I do want to add for the 4 of the years, the 2019 agreement, and I may have to get a little more information. It was executed December of 2019. We all know about 2020 and COVID. After that, once the design was underway, it was underway in 2020. Once we got the ILA underway, we had to go through the solicitation process. So this 4 years, it was not just 4 years of idle construction. It was 4 years of, we got the agreement, now we have design, now we have solicitation for construction. There was also a design variance that took FDOT 8 months to approve. So there were some other items that attributed to the delays.
For 2 blocks.
I know, for 2 blocks. Yeah, it's more not just about the stretch of the blocks more than it is the actual process that it takes to go through certain things, from solicitation for the design and dealing with an external agency during COVID. And then the variation that it wasn't just us working with our, DSD, it was working with external agencies, which adds a little more complication to it.
So what if we extend it another year? What's the expectation that the project will be completed within that year?
So I have.
Do you need 2 years?
Absolutely not. So this was the funny part of this extension.
Wait, we got to speak to Troy because he doesn't think anything's funny about this.
Well, it's so funny because we had a meeting with Troy at 8:30 this morning, so he's heard everything that we're saying now. What's happening right now is we had 2 options. The actual scope for the contractor did not include the lighting. We were trying to be good partners with our grantor and request that the scope is extended, or the agreement is extended, while we make good on every single item that was listed in the scope for the grant. But our contractor, he never had lighting in his scope. So that project that was underway is completed. But instead of the option 1 of asking the grantor to remove lighting out of their scope so that contract is completed, we said, hey, can we extend the contracts while we conduct the solicitation for the lighting? And so that was the option that was taken, and so that's why we were proceeding with the extension. It wasn't necessarily we need the extension to complete the sidewalks. That has been completed. The entire scope of work from the contractor had been completed.
Okay.
Can you just discuss the pricing of the lighting? Because I'm understanding that that's been an issue. So if you could just take it back to what originally we were spending on the lighting with FP&L, and has that
Yes.
changed? And if so, how? And are approvals still necessary for that?
Yes. So the initial agreement for FPL was about $106,000 for FPL to conduct the installation of the lighting. Once we found out that the agreement was unable to move forward, we asked the contractor, FG Construction, if they could provide an estimate, seeing if we could possibly do a change order and have that added to the scope of work. However, we did not want to move forward with that once we saw that, first of all, we were coming up on the end of the project. It was not in their initial scope, which then it was not part of the solicitation that they fairly won in the past. And also because the contract was expiring and the price was, it was around $100,000. It was $80,000 with the subcontractor, but FG was adding on their own markup. At that time, it would have been more timely, believe it or not, for us to proceed with not including that in the contract because we would have had to wait until this contract extension was granted before we can move forward with that work with the existing contractor.
All right, so the contracts are signed. Okay. The scope of the contract includes lighting. Yes?
The grant contract, yes.
Yes, okay. The price is the same. The price has not gone up.
The price has gone up on the
So
lighting.
the delay is now causing a price increase.
Correct, but the price increase is not to amend the contract to increase. We're not asking for additional money from the county. We're just asking for additional.
The city.
The city is not asking for additional money from the county. We're just asking for additional time while we discuss with the CRA for the additional funding.
We're
how
the
much is-
CRA. You're asking us for additional money.
Yeah, well, I'm TAM. I'm just saying we're working with the CRA to identify.
Is this going back to the CRA advisory board?
The money issue, this isn't about the money right now.
I know it's not,
We'll
but I'm
come
asking: is this all this delay? All this delay is going to cost us more money.
Yes.
Yes. When are we going to stop this? I mean, it's so ridiculous. All these ridiculous delays. Every year we wait, it's costing us more and more money. This is ridiculous.
I'd like to add to the increase in the cost.
Yeah.
So we had to go out for a solicitation, a formal solicitation, because the cost was going to exceed $50,000. If it was within that threshold with our procurement rules, we would be able to just get 3 bids and move forward. Because it was in that weird spot of $80,000, we had to submit a formal solicitation. When we submitted the formal solicitation, the bids came back. The lowest bid was $165,000, and that is where the increase came. We thought, I think there was something proposed where the thresholds would possibly be increased, and if the thresholds were increased to $100,000, we would be able to obtain 3 quotes, at that certain level without having to continue with the delays. But due to just our procurement process, we had to go through a formal solicitation, and the contractors not connected to the existing project, not connected to, having, when it was already mobilized, they put in a full bid, full mobilization, full MOT, and like I said, the lowest bid was $165,000.
Could you have broken up the contract into component parts to be able to reduce the total cost of the project?
I think right now, so that's where we are now. The bid just opened within the last 2 weeks. So we're trying, like I said, we're trying to talk through it right now, either identify funding, reject the bid, see if we can remove the material for the poles to be isolated and have an annual contractor actually install the infrastructure. But that's exactly what we're going through right now.
Okay.
It's just we like I said, we wanted to make good on the contracts and keep that current. And the Broward County approved it. They actually drafted the amendment that they were okay and in support of the contract being extended while we figure this out.
Why are they waiting till April to extend the contract?
So the amendment has been drafted and it's part of the exhibits. After you sign, the city signs or CRA, it goes back to them and then they put it on their next meeting to be executed. Okay. So that's why.
Thank you.
Okay. Any further questions or comments? Absolutely. Go ahead.
I'll be quick. Kristen made a comment about this project being done within the 270 days. I don't think that she might be up to date on this because I know Vice Mayor Glassman got an earful about this. In the contract
From you?
from me and Ed Catalano and Bear Klett and a lot of people, in the contract that you approved, it includes a substantial completion date of 270 days. But in at least this contract, there's no penalty if they don't make that. The substantial completion date of this project was the 1st of June, and it was all torn up at the 1st of June. You can see in the memo that it wasn't completed until August 23rd, which was right before the final completion date. So in future contracts for all of you, I suggest that maybe some penalty or more attention to pay
There should
that.
be some performance milestones throughout the course of the contract period.
Right.
Instead of just waiting the last week to get it all done.
Exactly. And that's what happened here. So
okay.
Thank you for your time.
Okay. Thank you.
Thank you. We can do better, Mayor.
Please call for a vote.
just going to start over. Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst?
Yes.
Vice Chair Glassman?
Yes.
Chair Trentalis?
Yes, and that item is approved. Moving on to R2, it's a resolution approving a $6 million forgivable loan to the SJC Sistrunk LLC and authorizing the executive director to negotiate and execute the development agreement and any and all other documents or instruments necessary or incidental to consummate the transaction. Someone like to introduce the resolution? Hold on a second.
Introduced.
Okay. Mr. Jones, you signed up to speak.
Yes, I did. Mayor, Vice Mayor, Commissioners, for the record, my name is Sean Jones. I'm a principal of SJC Sistrunk LLC. Upon discussions with Commissioner Herbst, Commissioner Sorensen, Vice Mayor Glassman, they impressed upon me the need for additional affordable housing. So what I want to do is amend my application and add another 5 units of affordable housing, which will be rented to persons at 120% or less AMI, adjusted median income. This will bring up the amount of affordable units at the project from 14 to 19 of 121 units, making it 15.7% affordable.
So what's the affordable income range then for all these? 80 to 120%?
The first 7, excuse me, the first 14, 7 of those are at 80% AMI. Another 7 are at 100% AMI. I'm adding an additional 5 at 120% or less AMI. So we'll have a total affordable of 19 units of the project as affordable.
So this is a forgivable loan. Okay, this is a forgivable loan, which means it's paid up front or it's reimbursed after construction is concluded. How's that working? Who's here from the CRA?
And Clarence is
Clarence,
here.
can you come up here, please? Clarence, can you explain how this money is going to be involved in this project?
Mr. Mayor, members of the commission, Clarence Woods of the CRA. Typically what we do is once the developer has obtained site plan approval, they have their plans done, they have their permits, and they begin the construction, what we do is we enter into a funding agreement that will determine whether or not, just based on what their financing is, we can fund what we call pari passu with the bank in their debt. We could either do it with the equity contribution that's going to go in from the actual developer, but typically it is on a pari passu basis with the bank and its debt funding, which comes in last.
So their equity has to first be contributed, and then as the bank gives, we give.
Yes.
So it will already be under construction before we give any money.
And that's typically the way we like to, have our money to go into projects.
Is this the site where that convenience store is located?
Absolutely.
So when are you going to close that? You've been telling me for 2 years you're ready to close that.
As soon as we get under construction.
Not before construction?
It will. It'll be close before then.
You've been saying that for 2 years. It keeps the community from progressing. We need to find ways to improve the community, and that has been an eyesore for for as long as I've lived here. And and not that I'm trying to put the gentleman out of business, but it just has become a magnet for activity that is unacceptable. And we rely upon you to take care of that since you own it now.
Understood.
Right? So no money until that is gone. Okay.
I'm not going that far, but Mr. Jones. Mr. Jones.
Come on, you got to be firm.
Unfortunately, we haven't had an opportunity to speak. Timing just has not allowed. I look forward to speaking with you regarding the project that's being proposed. I had mentioned to Mr. Woods about the history that's connected to that actual convenience store. And I'm not sure if you're aware of it, but at one point, Ms. Eula Johnson, who was the NAACP president, her family owned that property for the gas station for the community. So I want whatever we're doing to make sure that we give homage and that history lives with that. It's a very amazing story that we need to keep alive, and I want to make sure that we do that in that conversation. Because you're in District 2, but we're budding, and we want to make sure that that story remains alive and that we can keep the history moving forward. Okay?
Okay, any further comments or questions?
Just to say thank you for the additional affordable units. Thank you, Sean.
I echo that.
And by the way, are we memorializing that somehow or codifying it?
Oh
in
yeah,
writing?
absolutely. It'll be in the development agreement. And Mr. Mayor, we won't give any money until it's flattened.
Thank you.
Thank you, Sean. Yep, appreciate it.
Thank you, Mr. Jones.
So for
anyone else wish to speak on this item? There being none, the resolution's been introduced.
So, Mayor, if I can.
Wait, did you sign up? No, just kidding.
For the record, can we restate those changes that were proffered by the applicant?
The applicant,
in terms of the changes.
Sean, can you come back up? Was it 5 units?
It's 5 additional units that will be affordable. Under the present arrangement, it was 14 affordable units. So the total now will be 19 affordable units.
Okay.
The additional 5 will be rented to persons at or below 120% adjustable median income.
Okay. Thank you. So there's no amendment to the resolution. It's an amendment to the, I guess, Clarence, this is memorialized in the DIP agreement? Okay.
That was a yes for the record. Okay, thank you. The resolution has been introduced. Please call the roll.
A resolution of the Board of Commissioners of the Fort Lauderdale Community Redevelopment Agency approving a forgivable loan of $6 million to SJC Sistrunk LLC under the Development Incentive Program for the multi-use project located at 801 Northwest 6th Street, authorizing the Executive Director to execute any and all documents related to this transaction, delegating authority to the Executive Director to take certain actions, providing for an effective date. Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst?
Yes.
Vice Chair Glassman?
Yes.
Chair Trentalis?
Yes, and R2 is now approved. R3, a resolution approving an early loan forgiveness to the YMCA for the forgivable loan of $10 million as of December 31st, 2024, and authorizing the Executive Director to negotiate and execute any and all documents or instruments necessary or incidental to consummate the transaction. Someone would like to introduce the resolution?
Introduced.
We have a couple people who signed up to speak, but just for questions, right? Cheryl? Yeah. And Mark? Yep. Okay. Anyone else wish to speak on this item? Okay, the resolution. Anyone want to make any comments? There being none, please call the roll.
A resolution of the Board of Commissioners of the Fort Lauderdale Community Redevelopment Agency approving a forgiveness of a $10 million loan to Young Men's Christian Association of South Florida, Inc. under the Development Incentive Program, authorizing cancellation of the promissory note and satisfaction of the mortgage, authorizing the Executive Director to execute any and all documents related to this resolution and providing for an effective date. Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst?
Yes.
Vice Chair Glassman?
Yes.
Chair Trentalis?
Yes, and R3 is now approved. And I just want to say something regarding the YMCA and Cheryl Woods. You know, that facility has become such a success, and I just want to thank you and your board for the amazing improvement and opportunities that YMCA has given to the entire city. And our hats off to you for making it such a success. And we thank you for everything you've done to bring it to that point. So thank you, Cheryl.
And Cheryl, if I might also add thank you to that as well, and also so happy that we're able to do this evening, which will free you up to even move quicker on the next YMCA in Holiday Park. So thank you.
Okay, is there any further business of the CRA? There being none, the meeting of the Community Redevelopment Agency Board is now concluded, which brings us to the City Commission regular meeting. Do I have? So, good evening, everyone. Welcome to the City Commission meeting this February 18th, 2025. I want to thank you all for being here tonight. And if this is the first time you've attended our meetings, I'd like to thank you and let you know that we begin our meetings with the Pledge of Allegiance and followed by a moment of silence. We have any agenda items that need to be addressed before we vote on the agenda in the minutes. And then we have presentations. What are presentations? Presentations are where we recognize individuals, organizations, or events here in our city, and they're presented by one of the members of this commission. And tonight we have 3 such presentations. So why don't we get started? And I'd like to invite Caitlin Johnson from Oswald Play After School Program, Gateway Christian Academy, to please join me at the podium. If you could all please rise and join us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, and liberty with justice for all.
Great. Thank you so much. She'll be appearing next week on America's Got Talent. Please stay tuned. Please join me in a moment of silence. Thank you. Mr. Clerk, please call the roll.
Commissioner Herbst. Present. Vice Mayor Glassman.
Here.
Commissioner Beasley Pittman.
Here.
Commissioner Sorensen.
Here.
Mayor Trentalis.
Here. And there are no further agenda announcements, but there are some agenda item revisions. R5, the January 13th, 2025 draft minutes for the General Employees Retirement System Board of Trustees were added as additional information. PH4, Exhibit 7, the city surveyor schematic was added. It was not available at the time of publishing. And Exhibit 8, a resolution for approval, was revised to replace 36.4 feet with 34.4 feet in the header and on page 2. All right.
Mayor.
Yeah, who asked that?
Sorry, Ben.
Yes.
The PH2, the property owner is asking if that could be deferred, PH2, if that's possible, Mayor?
No.
You want to do it?
Unfortunate.
I'm sorry, PH2?
Yeah, unfortunately, there's not a provision for the property owner to request a deferral on that one. That the applicant being the historic, the applicant is not the property owner.
So the Historic Preservation Board would have to ask for a deferral?
It's not the Historic Preservation
It's the
Board.
Broward Trust for Historic Preservation.
Oh, they're
the applicant.
Is there anyone here from the Broward Trust? Hello. Oh, there you are. Oh, hi. Do you have a problem with it being deferred? You do. Can a member of the commission ask for it to be deferred?
Our code does not provide a process for that. For some reason, it's written to provide, for the benefit of the applicant, that you hear it within 180 days of the application being deemed complete.
So the commission can't vote to defer an item? I think it can.
So what our code provides, what you run the risk of is not complying with your procedural due process. And
are you going to throw those fancy terms out?
What I'm saying is that the process that our code has outlined certain rights for the applicant that they can raise in future. And now that the applicant has stated on the record that they do not agree to the deferral, you would be hard pressed. I'm not saying that you can't, but there isn't anything within our code that provides you with the ability to unilaterally defer this application.
So the applicant has rights, but the property owner doesn't. Right. I think we need to change that.
Well, I need some clarification. I read the minutes of HPB, and I'm not sure exactly that that's the case in terms of the property owner. This is a split property. I mean, I don't know if do we want to get into this right now? And we can, because I think people need to understand everything, or we just go along with what you're saying and not get ourselves into trouble. When did this go to HPB? And was this issue of ownership of the property decided at HPB? I mean, can someone speak to us from HPB?
Why don't you come on? Do you mind coming up to the podium?
Or is someone here from staff that could talk to us about process at HPB? Great. I just don't want to get ourselves into any kind of legal issue here. I really don't. But I just want to make sure we're doing the right thing. But I also want to make sure that everyone's voice is heard. Thank you.
So, I'm sorry, could you repeat the question?
Well, when did this appear before HPB?
On January 6, 2025.
January 6th. Okay, and can you explain, this is an interesting case because of the split property.
Mm-hmm.
So, only in front of us this evening is the Frank Croissant house, right?
Correct.
That part of the property.
That is correct.
And when I read the minutes of the meeting, it looks like the owner of that property supports the designation. If I'm wrong, please help me.
That is correct. So the owner is here, and this case was represented by Broward Trust for Historic Preservation. Michaela Konka, she's also here, and she's here as well. So the owner provided legal description of the property, and when this case was brought to the HPB meeting 2 years ago, it was one property, and now we have legal description for the separate part, which includes the Frank Croissant house. So they are applying for this specific property to be designated, not the entire lot, not
Mayor,
the entire parcel.
If I may, so I know this is scheduled for a public hearing later, and it kind of sounds like we're eliciting testimony for a public hearing.
So why don't we address it at the time it comes up on the agenda?
Yes, I agree.
I think what the Commissioner Sorensen was trying to do was to prevent, if we were going to defer, to prevent these folks to have to sit through the meeting.
I understand.
But at the same time, I don't want people to perhaps be misinformed thinking that we're doing something against the wishes of the property owner when I'm being told that the property owner is in support of the application.
I think there are two property owners, though.
You represent the property owner.
There's separate property
You represent
owners.
the property owner. Okay. All right. So why don't we just wait?
There's a lot to clear up here. Is all I'm saying. There's a lot going on here. That's all.
All right. We'll get there. We'll get there.
So we can go back.
We're going to get to it when we get to it.
You charge by the hour, so you'll be happy.
Thank you. It's a lot to get to here.
Okay. Okay. So, with those two agenda amendments, would someone like to move to approve the agenda?
Moved. Second.
As amended. Okay. It's been moved and seconded. Please call the roll.
Commissioner Beasley Pittman,
Yes.
Commissioner Sorensen,
Yes.
Commissioner Herbst, yes. Vice Mayor Glassman,
Yes.
Mayor Trentalis.
Yes, and the agenda is now approved as amended. So first presentation tonight, I'd like to invite Commissioner Beasley Pittman to present a proclamation regarding Sistrunk Parade and Festival Day here in the city of Fort Lauderdale. And I'd like to invite Henrietta Davis from the Sistrunk Historical Committee to please step forward. Is she here?
Yes, and her board.
And her board. Okay. Come on up, board.
Good evening, everyone. Good evening. Good evening. I am truly honored tonight to be able to present this proclamation from the Office of the Mayor, the City of Fort Lauderdale, proclamation in recognition of the Six Trump Parade and Festival, requested by Commissioner Pam Beasley Pittman. Whereas the Six Trunk Historical Festival Incorporated was created as a vision of hope and progress by the City of Fort Lauderdale and the Northwest Business Association to foster economic development and cultural enrichment in a historically underserved community. And whereas the foundation for this celebration was laid by the former Assistant City Manager James Hill, who played a key role in planning the first parade and festival to mark the opening of the city's multi-purpose building, which replaced the Provident Hospital, Broward County's first black hospital. And whereas Provident Hospital was co-founded in 1938 by Dr. James Franklin Sixtrunk, a pioneering black physician who provided medical care for the black community during segregation. And whereas in recognition of Dr. Sixtrunk's significant contributions to health care and the community, the Sixtrunk Parade and Festival was named in his honor, ensuring his legacy continues to inspire future generations. Today, Six Trunk Boulevard stands as a cultural and economic lifeline, bridging past, present, and future through its thriving arts, music, and historical landmarks. And whereas the Six Trunk Parade and Festival is more than just a single-day event, which draws thousands of attendees each year, it is a year-round movement that nurtures and educates cultural expression and community engagement. Whereas the City of Fort Lauderdale is proud to launch the I Am Six Trunk campaign in this year's Six Trunk Parade and Festival, reinforcing unity, empowerment, and economic growth in the Six Trunk corridor. With its bold and dynamic identity, inspired by the area's murals and landmarks, and this campaign will serve as a symbol of pride, enhancing public spaces, attracting investments, and strengthening community connections through broadening initiatives and artistic collaborations and grant-supported programs. Whereas, for over a century, the historic Six Trunk has been the heart of the soul of black culture in Fort Lauderdale, a home to trailblazing entrepreneurs, faith-based institutions, families who have shaped the city's history. It remains a beacon of resilience, progress, and community pride, reflecting the spirit of those who came before and those who continue to build a brighter future. Now, therefore, we ask the City Commission of the City of Fort Lauderdale, Florida, do proclaim February 22nd, 2025 as the 45th anniversary of the Six Trunk Parade and Festival here in the City of Fort Lauderdale, dated this date, the 18th day of February 2025, signed by Mayor Dean J. Trentalis. you would like to say something, you may.
Good evening, everyone. On behalf of Six Strong Historical Organization and now 9 board members, I am honored to accept this proclamation on this evening. Thank you very much.
We're going to get a photo.
Congratulations, and it's Saturday. We have Saturday's the parade.
Early.
At what time?
That's for the 5K run.
We will see you there. Next, I would like to invite Vice Mayor Glassman to present a proclamation regarding the Surrounded Islands Day in the city of Fort Lauderdale. I'm going to announce several people's names, so please bear with me. I'd like to please call up Bonnie Clearwater, who's the director of the NSU Museum Art, Fort Lauderdale. Dr. Harry K. Moon. Dr. Moon, are you here? I didn't see. It's okay. Terry Malarkey, Vice President for Advancement and Community Relations, Chief of Staff, and the Board of Directors and Community Supporters, who are as follows. The Board of Governors are Kathy Donnelly, Andrew Heller, Whitney Lane, Sherilyn Muir, Lisa Smith, Stephanie Toothaker, and Reggie Zachariah. If you'd please like to join the Vice Mayor at the podium, as well as the community supporters, Alyssa Mogilevsky, Mignon Marshall, Roxanne Zinn, Lori Frankie, Dion Abshir, Nancy and Jerry Bryant, Teresa Christie, Christine McCready, Maria Kerp, Carol Horning, and Stephen Smith. You're in good company, Vice Mayor.
Thank you. You know, I'd like to invite everybody up here. All right, come on, Chris, come on up.
I think I just did.
Okay, come on up, everybody. Come on. If your name wasn't called, please feel free. Come on up here. Come on up. Join the NSU Museum of Art Board of Directors. This is great. Nice. Come on down. Ladies, any gentlemen up here?
Yes, well, Stephen.
Ladies and gentlemen, okay. All right, thank you, everybody. What a pleasure to be here to present this proclamation from the Office of the Mayor, City of Fort Lauderdale, in recognition of Surrounded Islands Day, NSU Art Museum, Fort Lauderdale. Whereas the acclaimed artists Christo and Jean-Claude created an iconic public artwork in Miami's Biscayne Bay by surrounding 11 man-made islands with 6.5 million square feet of floating pink fabric, blending with the island's lush tropical vegetation and the shimmering colors of the shallow waters. You don't like Christo?
She doesn't like you.
Okay. Whereas this groundbreaking installation titled Surrounded Islands, Biscayne Bay, Greater Miami, Florida, 1980 to 1983, illuminated the unique interplay between land and water that defined South Florida's landscape and way of life. And whereas Surrounded Islands captured global attention, positioning South Florida as a dynamic international hub for art and culture, while demonstrating the power of public art to inspire, engage, and connect communities. And whereas although Surrounded Islands was a temporary installation, meticulously removed after 2 weeks with all materials responsibly recycled, its impact and legacy continue to resonate more than 40 years later. And whereas Christo and Jean-Claude curated an extensive documentation exhibition of Surrounded Islands, featuring more than 40 original artworks, photographs, murals, sections of the pink fabric, and historical documents that chronicle the creation and enduring significance of the project. And whereas in 2024, the Christo and Jean-Claude Foundation honoring the legacy of these visionary artists by bequeathing the Surrounded Islands documentation exhibition to NSU Art Museum, Fort Lauderdale, recognizing the museum's dedication to exploring themes that deeply connect with the South Florida community. And whereas NSU Art Museum, Fort Lauderdale, will debut the inaugural exhibition of Surrounded Islands on Sunday, February 23rd, 2025, celebrating the lasting influence of Christo and Jean-Claude's artistic vision. Now, therefore, we, as City Commissioners of the City of Fort Lauderdale, Florida, do hereby proclaim February 23, 2025 as Christo and Jean-Claude Surrounded Islands Day at NSU Art Museum, Fort Lauderdale, in the City of Fort Lauderdale, and dated this, the 18th day of February, 2025, and signed by the Mayor, the Honorable Dean J. Trentalis. Bonnie, please say a few words.
Thank you so much, Vice Mayor and Commissioners and Mayor. And the thing about Christo and Jean-Claude, these amazing artists, is they brought community together. And that's what the purpose of this exhibition is. And we brought a good deal of the community with us tonight. Lucky Fort Lauderdale residents, the opening day of Surrounded Islands at NSU Art Museum falls on Free Fort Lauderdale Neighbor Day. So you get to be at the exhibition first and free. So we look forward to seeing you and enjoy, and thank you for this proclamation.
Absolutely.
And thank you all for
Go to the middle and get a photo. Come to the middle.
Come up here. Hi, how are you? Smile pretty. Bonnie, I think you should wrap the museum in those pink tents that some of these termite exterminating companies they have. Oh, you're over there.
But we do have a surprise that's
Okay. All right. Well, just something an homage to Christo and Jean-Claude. Okay. Our final presentation. I'd like to invite Jordan Wingate from Neighborhood Support, who's the administrative supervisor. And this is an opportunity for us to recognize the 13th graduating class of the Neighbor Leadership Academy. Jordan. Well, I guess you should all come up and join him at the podium. I don't have all your names. It's all yours.
Good evening, Mayor, Vice Mayor, Commissioners, staff, and neighbors. I'm Jordan Wingate on behalf of Neighbor Support, here to congratulate the 13th graduating class of the Neighbor Leadership Academy. The Neighbor Leadership Academy lets neighbors experience a 5-week curriculum where they learn about the city's budget, community enhancement practice, interact with commissioners, and gain an overall insight into the world of local government. After the 5-week curriculum, participants volunteer their time in ways to improve their communities. As Fort Lauderdale is the Venice of America, Class 13 focused their project on cleaning our beautiful waterways. Working with the Coastal Conservation Association, Class 13 created vertical oyster gardens, or oyster ropes, that can be deployed along docks and seawalls throughout the city to improve water quality. This project is about keeping our waterways clean and beautiful so that everyone today and in the future can enjoy them. The Neighbor Leadership Academy began in 2017, and as of today, we'll have had 247 total graduates. This was possible because of support from the Council of Fort Lauderdale Civic Associations, the City Commission, city staff, and our neighbors for volunteering their time to learn more about our great city and become more civically engaged. Class 13, I look forward to seeing you become future community leaders. With that, congratulations, Neighbor Leadership Academy Class 13. Yeah.
My name is Joel Slotnick. I'm one of the members of this class. First, I have to say a big thank you to Jordan and Jania for your leadership and guidance during this and all your efforts. To the Commission and Mayor, thank you for taking time out of your schedules to come and do a little presentation with us. And of course, to our class for making some very robust comments and your dedication to our community. I highly recommend, it's taken me 13 years to clear my schedule to be on this. I highly recommend, if you haven't been through this, it is a great way to learn about your community and also give back, because every class has to do a project, and it was a great experience. So thank you, everybody, for the opportunity.
Thank you.
Very squeezing.
Thank you.
Oh, squeeze in, baby. You can squeeze here.
I'll give these pictures back to everybody.
Thank you, Mayor. Okay, at this point, we now move on to what's called the consent agenda. Consent agenda items are voted on collectively unless a member of the commission asks that one or more of the items is removed in order to discuss and vote on separately. So I'll ask the members of the commission separately if they have any item they would like to remove. Otherwise, we'll vote on all these consent agenda items together. So I see Commissioner Herbst is not here. Commissioner Beasley Pittman?
None.
Vice Mayor?
None.
Commissioner Sorensen?
None.
None. So there are no consent agenda items that are going to be removed. No one has asked to speak on any of them, so we're good there. So do I hear a motion to approve all the consent agenda items?
Second.
Been moved and seconded. Please call the roll.
Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst? It's not present. Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes, and all the consent agenda items have now been approved. If you are here on any of those items, your item has been approved, but you're welcome to stay for the rest of the meeting.
Please stay.
Okay, moving on to motions. M1. This is a motion approving the Second Amendment to the Comprehensive Agreement for the Prospect Lake Clean Water Center to amend Annex B1 and Annex B2 for the city infrastructure obligations, water, sewer, and communications projects. Do I hear a motion to approve?
Moved.
Second.
Moved and seconded. Any questions with regard to this item? There being none, please call the roll.
Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst? Is not present. Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes. And that motion is now approved. Moving on to M2, this is a motion approving change order number 9 for the Prospect Lake Clean Water Center, Prospect Lake Water LP. Do I hear a motion to approve?
Moved.
Second.
Been moved and seconded. Please call the roll.
Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst? Not present. Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes, and M2 is now approved. Moving on to resolutions, it's an appointment of board and committee members. Mr. Clerk, would you please read the names into the minutes?
Yes. For the March 4th resolution, Central City Redevelopment Advisory Board, Antoinette Wright, nominated by Vice Mayor Glassman, and Bobby Tinoco, nominated by Vice Mayor Glassman. And for tonight, Community Service Boards, Gary Hensley, nominated by Vice Mayor Glassman. Education Advisory Board, Carrie Tabora, nominated by Vice Mayor Glassman. Housing Authority of the City of Fort Lauderdale Board of Commissioners, Jeff Lowe, nominated by Mayor Trentalis. Parks, Recreation, and Beaches Board, Anna Vratsinas, nominated by Mayor Trentalis. Sunrise Key Neighborhood Improvement District, Cliff Berry, nominated by Commissioner Glassman. And we received one additional name after publishing for Central City Redevelopment Advisory Board, Christopher Casey, and that's nominated by Vice Mayor Glassman, and that rounds it out.
Okay, are there any additions or modifications to the names being read into the minutes? There being none, would someone like to introduce the resolution?
Introduced.
Resolution's been introduced.
And that's as amended?
As amended.
Thank you.
Please call the roll.
A resolution of the City Commission of the City of Fort Lauderdale, Florida, appointing or nominating, if applicable, board and committee members as set forth in the exhibit attached here to and made a part hereof. Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Hurt? Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes, and R1 is now approved. R2, aha, City Clerk Annual Performance Review. Please enter the soundproof booth. So we have several people who signed up to speak. Mark, you didn't want to speak, or you do? Okay. Mark Dickerman, followed by Arthur Marcus. The only two people who signed up to speak.
Mayor, Vice Mayor, Commissioners, I promised David that I would come up here and speak against him, but I just don't have the heart. The city clerk's office, under the realm of David, has been incredible. Emails are returned within an hour, 2 hours. Calling the office gets you great and correct information. As a board member, as a member of many boards over the last few years, I've noticed since David has come over, the ability to check on your status, to get information forwarded to the city commission has been flawless. So I would suggest 100% raise, but I know you're not going to do that. But whatever percentage you give him, it is well deserved. So thank you, David, for all the work you've done for the city.
Thank you. Arthur Marcus. Okay. All right. Does anyone else wish to speak on this item? Any member of the commission?
Yeah.
All right. We'll start with Commissioner Herbst.
Sure. David, I just want to say it's been a pleasure working with you. You've been very, very professional, very responsive. You've been great to the residents. You've been great to my staff and enormously helpful to me. So I'm fully very supportive of everything you've done and everything I expect you to continue doing.
Thank you, Commissioner.
Commissioner Beasley Pittman.
Yes, David, I want to thank you also for all that you've done. I'm impressed with all that you do, but most of all, how you read these resolutions flawlessly. Okay?
I practice every night.
But thank you, and I support moving forward with giving you a raise if this is the time to say it, but I'm in support, and I'm sure we'll discuss that more. Yes.
Thank you.
Vice Mayor?
Yes, thank you, Mayor. So, David, I want to thank you very much for accepting all of my corrections to the minutes. I really do appreciate that. Thank you. And in all seriousness, you and your team do an amazing job. I'm very grateful for the work. It's very professional. It's always very timely. And I want to say thank you. And I don't know when we should have this discussion, but I have looked at what other city clerks make throughout Broward County, other municipalities, and considering that we are the largest city in Broward County, and I looked at what our city clerk makes as a salary, and also in comparison to our other charter officers, I think we should actually look at that and have that discussion as well. Thank you, Mayor.
So this is the time to have that discussion. So what are you suggesting?
Well, I just think that he should be getting a significant increase, not just the 3%. And I think that it should be more in line with the top cities in the county, and also the fact that our city clerk has a lot more responsibilities than many of the other city clerks throughout the county. I'd like to hear from how basically my colleagues feel about this. But I'm looking to see him get a lot. If you look at the charter officers, and you see where the city clerk falls, it's just there's a big gap there. And I think it should be much more in the range of much closer to 200 than as the other charter officers are.
Susan, what is the current salary of the clerk?
I'll ask David to tell us that. I don't have it off the top of my head, but I'm sure he has that information.
I should have that right in front of me. But my current salary is $162,300.
162,300.
Mm-hmm.
Okay, that's base salary though, correct?
Yes.
Okay, so what are you recommending, Vice Mayor?
Well, I'm going to put this on the city clerk, and I'm going to ask the city clerk, knowing exactly what he does and what his staff does.
That's not fair to
it's not fair?
It's not fair.
To self-evaluate?
It's not fair.
Okay.
Can I weigh in?
You can weigh in. I'm going to.
Thank you.
I'll start the bidding at 200 and see where it goes. And I'll see where it goes. So you take it away, folks.
So I've had 1, 2, 3, I think 4 city clerks during my time here. The city clerk's office has traditionally been significantly underpaid relative to the other charter officers, and it's something we've tried to correct on several occasions. I think when you look, and I've had this conversation with David, I think the city clerk's office is a little bit different from some of the other ones in terms of, if you look at perhaps the city attorney, it requires a law degree and so forth. There's also span of control. I think the city clerk's office is probably commensurate with our department heads. I think if I were looking for, I wouldn't be looking outside the city to what other cities are doing. I think we need to evaluate David internally against our department heads, because I look at him really as a department head. City clerk's office once upon a time actually used to be a department until it got split off, I think, during the Noggle administration and made a charter officer. So I think that's a really good basis for comparison. And when you look at our department heads, they make anywhere from a low of $175,000 for an acting department head up to $140,000 for our police and fire chiefs. Again, large span of controls, hundreds of people that they're responsible for, tens of millions of dollars in a budget. 240. I'm sorry, isn't that what I said? I apologize.
No.
I'm sorry, I misspoke. 240. My apologies.
I was right in the ball.
So I think we need to bring David in somewhere that is commensurate with some of our other department heads, and I think the vice mayor is spot on when he says 200. I think that is kind of in the middle of the pack. David has a lot of responsibility for what he has to do in terms of keeping our records clear, responding to public records requests, the minutes of all of our, 41 plus boards and committees and everything else that we do. So there's a lot that we put on David's plate. At the same time, he doesn't have, 500 sworn officers and a $150 million budget under his purview. So I think we need to find a salary that reflects what he does, the contributions that he has, the responsibilities that he absorbs, and I think 200 is reasonable for that level of performance and responsibility.
Okay, Commissioner Sorensen.
Yeah, thank you, David. great job up and down the line. Not only your own responsiveness and leadership, but also building a team around you that's excellent. Customer first, I think is fantastic. I think the department head discussion is a good one. Susan, give me the range goes from 240,000 to 175,000.
Well, the 240 would be similar to an assistant city manager, or as Commissioner Herbst said, the police chief or fire chief. So that would be that. A department head is closer to. I just asked Jerome for the top department head, but I think it's really close to the 200,000.
200,000. Okay. So I think that's a fair analysis. The one of the differences, though, that I see between a department head and a charter officer is a charter officer serves at the will of the city commission, and as a result, in my view, takes on a little bit more risk, and it's just a little bit tougher dealing, at least with me, can be a little bit tougher than maybe other folks. So it can just be added layers of challenge. So I think
of anxiety,
challenge, frustration, all those things. So I think around the 200 range is right. What's the next highest charter officer in terms of if David's at 162, who's next above that? Is that Pat? Are you?
Probably going to be Pat.
I think so.
Pat, and what are you at?
We'll all declare our salaries.
Yeah.
Like 269.
269, a city auditor. Yeah, so I'm just going to say a little bit more than 200, just because, again, charter officer is a little bit unique in my view. So I think around 215.
Yep.
Are you outbidding me by
I'm
15?
outbidding you.
Oh.
Yeah.
Shouldn't we have those cards?
By a little bit.
And HR just confirmed that top of a department head salary is 228,693.
228 for non-assistant city manager department, right? Jerome. Sorry, thanks.
Jerome, what do you make?
Yeah.
We'll all declare our salaries.
Right.
Yeah.
Good evening, Jerome Post, Director of Human Resources. Yes, that would be for Department Director level.
Department Director, okay.
But not police chief or fire chief.
Correct.
Because they're at the same level as assistant city manager.
Correct.
So why don't we say 230, round it off to 230?
230?
230.
Okay.
230 would be just above the max rate of 228. 693, right?
Yeah. And I think he's worth $2 more.
Okay. Yeah, I'm good with that, Mayor.
Okay. All right. So would you like to introduce a resolution to that effect?
Sure. Introduce resolution. It's going to be as we're amending it. Let me just look at the resolution.
So you look at the resolution.
Yep.
It's to approve
annual base salary. Yes, to be increased by whatever that.
Well, just say not. So it will be increased
30,
to $230,000
to $230,000
on an annual basis, effective January 23rd. Oh, you get a retroactive.
Yep. Effective January 23rd, 2025. That's what I'm introducing, Mayor.
Okay. All right. Does anyone have any comments or questions? All right. There being none, please call the roll.
Just before I do, I want to thank you all for your support, and this very humbled by this. I feel a little strange reading my own resolution, but thank you so much. And I want to just thank my staff. They are the best clerk's office around, and I wouldn't be here at this moment without them. So thank you, and thank you all the other staff that I work with.
Can they stand up, the city, just so people can see them? Who's
Cassandra
with the
Brown?
city clerk's
Cassandra Brown,
office?
can you
Just
stand up, please? And I know there's a couple out front.
But by the way, before you read that, there's a rule: whenever a charter officer gets a raise, they buy. So you all know.
Exactly. And actually, before you do, Dwayne, any issue with him reading a resolution about himself getting a pay raise? Is there,
No issue there.
We're good. Okay, great. Go ahead.
You don't know abstain.
All right.
All right. A resolution of the City Commission of the City of Fort Lauderdale, Florida, providing for a merit salary increase to $230,000 for City Clerk David R. Solomon and providing for an effective date of January 23rd, 2025. Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst? Yes. Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes, and congratulations. Thank you.
Thank you. Thank you.
Well deserved.
Thank you.
Well deserved.
Okay, moving on to R3, resolution adopting the Himmershey Historic District Architectural Resource Survey. This was the one that that Commissioner Sorensen, you wanted us to defer?
No.
It
Which
was a later one.
Oh, it's a later one?
Mayor. Yeah.
Oh, okay. All right. Survey dated September 2024, including the assignment of contributing or non-contributing status to properties within the Himmershey Historic District. Anyone have any questions with regard to this item?
I just have a comment, actually. And maybe Trish can answer this for me. In reading the CAM, and by the way, I'm so thrilled that we're finally going back and looking at neighborhood by neighborhood by neighborhood. I want to thank the Historic Preservation Board for all of its work, and Chair Arthur Marcus, who's here this evening as well. Tricia, I was reading back, and we are a certified local government, so for those who don't know what that is, we have a certain responsibility when it comes to historic preservation. And I just was wondering why is it just a matter of resources and personnel that we don't seem to do these updated architectural resource surveys more often? Because it looks like we're almost obligated to do it at least every 10 years, but this one has been such a long time.
Well, I've only been here 8 years. Good evening, Mayor and Commissioners. It is the intent to regularly resurvey historic neighborhoods and that are designated, but also areas that aren't yet designated, just to record the history of each of those areas and let everyone know what the historic context of those neighborhoods are and identify properties that could be eligible for designation in the future. I'm not sure why this wasn't resurveyed in the past, but never any time like the present.
That's a great answer. Okay, so that makes sense to me. But are we going to try and do these as the CLG requirement states about every 10 years, or?
So we will try to do them as often as we can. At this moment, we did Sailboat Bend a few years ago and adopted that resurvey in 2021. And then we worked on the Himmershey resurvey. We've also been conducting surveys throughout the city to do a citywide survey initiative, many of the neighborhoods that had never been surveyed before. So it is a huge undertaking, and we're doing it in part with grant funds, but in this case, staff did prepare this resurvey report.
No, and it's an excellent report. I did have just one technical question. Maybe you can help me with that. But when I'm looking at I guess this is Exhibit 2, page 2. And actually, in the report itself, it in several places talks about 14 contributing properties, 5 non-contributing properties, and then just that one parking lot. But when I look at the list on page 34 of 75, which I guess is page 2 of 2 on the exhibit, I'm only counting 13 contributing properties, not 14, and I'm counting 7 non-contributing properties, not 6. What am I missing here?
On one of the parcels, there's multiple structures, so it might be that it just didn't get listed. But I'm looking for the page. I would have to take a closer look.
Okay, no problem. I'm just saying if you go and look at the status column of contributing and non-contributing, you can add it up yourself. You'll see that it totals 13, not 14, as listed in the document. And it says 7 non-contributing, where the document keeps talking about 5 plus the lot. So I guess that would be 6.
Yeah.
Okay. I was trying to figure that out, and I couldn't. Okay. I guess the mayor's not here, so I guess are there any other questions from the board?
I have a question that I'd like to ask. So, Tricia, I was reading in the minutes, you had made a comment that there's really no difference between contributing and non-contributing. But I know in the FAQs to the letter that went out to the residents, it talks about the fact that a non-contributing is treated more leniently when they come to HPB. So that seems to be kind of a difference of, it doesn't matter versus it matters a lot. So could you clarify that?
I believe the comment was from a board member, not from me.
Okay, because as I read the minutes, it looks like it was from you saying there's really no difference. It doesn't really matter. It's just nomenclature. Maybe I.
Yeah, I believe it was a board member that said it, but
Okay.
When it comes to the regulations for contributing and non-contributing stay the same at the moment. This is additional information that's provided to the Historic Preservation Board when a property owner applies for a certificate of appropriateness for any undertaking at their property. So if they're applying for major alterations or new construction or demolition, all property owners are able to apply for those requests, and this information is provided to the board at that time. This would be the same if we didn't have this information. Staff would have to, one by one, do the research to provide to the board as part of that type of application.
So what's the leniency that's described in the FAQ?
So the leniency
for non-contributing
would be the fact that we have information that already describes what has been done on that building in the past. Some of the structures within the Himmershey Historic District are newer and outside of the period of significance. So there is more leniency there where they aren't contributing historically or architecturally to the neighborhood that's designated.
So for example, if I have a non-contributing structure and I've got casement windows and I want to swap them out and put in storm windows, I can do that. But if I have a contributing structure and I have casement windows, I now have to replace it with something that is casement in style in order for it to maintain its architectural consistency with the historic period.
So
is that like an example of what we might be talking about?
Correct. But in either case, if there's a change or modification to the structure's appearance, it does have to go through the Historic Preservation Board. For a contributing property, if they are replacing their windows, which we do allow impact-rated windows as a replacement, but they will have the same appearance and functionality as the original or the existing,
right.
We do that administratively as part of the building permit. And it doesn't go through the board.
But the non-contributing would not have to go through that.
They still have to go to the board.
Okay, so if I have a house that was built in like 1970, I'd still have to worry about going to HPB to get my changes and upgrades and renovations approved, just like I would if I had a contributing one.
Yes, it is the way the ordinance is currently written.
All right, because I know I've sat here through the years and I've heard a lot of discussion about whether something is contributing when property owners have come in and asked the commission to approve something or to overturn something that HPB has done. And we always get into these really, really long, lengthy, detailed conversations about whether a property is contributing. So it's always struck me that that actually means something in terms of our code and how we approve things.
Well, it is informational in this case where it does provide a level of context for the decision maker. In the past, we did not have these identifications and statuses on the properties, which I think did create more confusion. But when you do have a report that's comprehensive and lays out which properties are contributing versus non-contributing, that gives the information to the current owner and a future owner and decision makers, as well as staff, to be able to explain what is significant, what we're looking to preserve on that particular structure.
So I get the part where we communicate to future owners. Tell me what happens when I have an existing property owner and then we come along and we designate them as contributing when they were never contributing before. How does that work?
In this case, there's most of the properties, they fall under the same regulations. Well, they all fall under the same regulations today. They will, if this is adopted, they would still fall under the same regulations. So I don't think that there's, lost my train of thought. What was the
Well, no, you said,
point?
so your point was that a future purchaser would know that it's a contributing property and they know that when they buy it.
Right.
But I'm saying, so what happens if we have an existing property owner who does not have a contributing property, and now we redesignate it because we've taken another look at it? Maybe 10 years has gone by, and now it falls within that time frame. It's older than it was at the time we last evaluated. Whatever that may be, we have a different perspective of it. Now we consider it contributing, whereas we may not have considered it contributing before, but now we do.
Yeah, in this case, since we didn't start with contributing or non-contributing, that doesn't really change. But
Okay.
I also, the way that this was originally designated, the properties that are identified as contributing in this report are consistent with what was identified as significant in the original designation.
So
it just
what's
didn't go to the
significant? I'm
extent.
sorry, let me back you up. You just threw a new term at me. So what's significant? So we have contributing, non-contributing, and significant. What is significant now?
So significant is just a description of overall the area and why it's designated. So within the report, it describes a period of significance for which you're designating this area. It's also describing the significance overall, so a statement of significance saying why it's important. So this is an early development within the city of Fort Lauderdale. It represents a lot of the pioneers of the community. It represents commercial development within the downtown area, and it's the only section of the older Fort Lauderdale that is preserved. So the period of significance in this case is described as 1899 to 1939.
Okay, so it describes an area and a time, but not a property. So a property is not significant, an area is significant, or a time period is significant.
The properties within the geographic boundary that is identified are part of that significance and represent that. And so typically within a historic district, you do identify which properties are considered to be contributing to that time period, that architecture, the history of the area that physically and visually represents what it is. And there are properties that are non-contributing, and that's typical, where you would have infill architecture that was built at a later date, or architecture that may have been modified to such an extent that it's no longer recognizable as what it was when it was first constructed, or when it gained significance.
So hang on, let me back you up then. So I think if I heard you properly, then you said that we did not have contributing and non-contributing nomenclature for the Himmershey district up until this report. Is that what you said?
Yeah, it
so
was
this is
not.
the first time we're labeling things as contributing and non-contributing
Correct.
in the Himmershey district. We've never done that before. So something
Correct.
didn't go from non-contributing to contributing. We're looking at everything and we're making a decision at this point in time as to whether it's contributing or non-contributing.
Correct. There's also an additional reason why to identify properties as contributing or non-contributing. A contributing property does then become eligible for incentives for historic preservation. So they can take advantage of financial incentives like our TDR program. As a commercial property, they do qualify for a 50% reduction in their base tax rate, both at the county and the city. And that is just a simple application that's provided to BCPA with a resolution saying that it's now a contributing property. And they don't have that ability to do that today. They can also do a tax exemption if they do modifications or improvements to their structure. And we have several other incentives that are available.
Aren't there also federal commercial grant availabilities for a contributing structure?
If it were designated on the National Register.
Only if it's on the National Register. But this would be a step needed to get there.
Yeah, this is a baseline that's being established.
So what happens if a property owner wants to object to the contributing status determination? Is there a process for that?
So prior to taking it to the Historic Preservation Board, a couple months before, we sent out letters to all of the property owners letting them know that the report is available, it's on our website, to contact me, provided them that list of frequently asked questions that you referred to, and offered to meet. And we did not receive any responses at that time. Another notice was sent out.
By the way, I clicked on some of the links in your letter. They don't work. Just letting you know.
Okay.
Right, the ones that are like all the definitions, the two attachments.
Okay.
Yeah. So
We'll take a look.
just letting you know, the links don't work. It takes you to a page that doesn't exist.
Okay.
So, but leaving that aside, go ahead. I'm sorry.
Just that we did reach out to the property owners again 30 days in advance of the Historic Preservation Board meeting, and we also posted signs in front of.
Right. But what can they do if they object to the determination?
So as part of that.
So who makes the determination, and what is the appeal process, if you will?
So as part of that process, it was an opportunity for property owners to come to our office, share information, and discuss what was being shown. We did not hear from anyone asking for the change in status from staff. Then the next opportunity is at the Historic Preservation Board public hearing to make a request and provide documentation and show or demonstrate why it should not be a contributing structure. And then the next opportunity would be here at the City Commission meeting.
So let me see if I understand it. They have to demonstrate why it's not a contributing structure. So in other words, the conclusion that it's a contributing structure is made, and then they've got to argue you back from that position. Is that accurate?
So in the process for the Sailboat Bend Historic District, when we took forward the request to change that area to contributing and non-contributing statuses, we did provide those property owners the same opportunity to come to staff, provide more information. We did have a handful of property owners that did bring forward additional information that we did not have access to. We didn't have it available, and that did change that in the report.
But that's additional information. As what I'm talking about is, it's my property. I bought it. I don't want it redesignated. I mean, it's a property rights issue to me. So it's not about whether I'm bringing forward some exculpatory information, evidence that I've got to present to you to overturn your conclusion. It's that this is my property and I don't want it declared historic, so I don't.
In this case, all of the properties are already in a historic district.
Okay.
They're already designated.
We're forgetting that this is a historic district that was created in 1975. Anyone who's purchased a property there.
Vice Mayor, what my concern is not just about this one. So as Tricia said, we're doing surveys of the entire city. So they're going to do a survey of Imperial Point, where all the houses have a very, very similar architectural style, where Ronald Reagan was the salesman, so he's going to meet all that criteria that you have in there. It's associated with a very important person in our history. It has a similar architectural style. It was developed by General Electric to sell GE appliances. So I'm going to have this happen in my district in a neighborhood that is not now currently designated historic, but it might be, and they don't want it to be. And I want to understand what the process is and what defenses my residents have against something that they don't want. So this is not just about him or she. This is about our process. It's about what we are doing and about respecting the individual property rights of folks. This is an important concept.
It is important, but what you're talking about is not applicable to the agenda item in front of us.
Yes, it is, because I'm trying to understand the process by which these determinations are made, how people can object to the determination, and what rights people have to not have their property designated against their will. That's very important to me.
And that process will happen when we get to that. For instance, the commission, I don't remember, you can help me what year, we used to have in our ordinance, and by the way, the Historic Preservation Ordinance has done a nice job of moving with the times. We've made it a lot less onerous on owners of historic properties in terms of what can be done administratively versus having to go in front of the Historic Preservation Board. We've created a lot of incentives. This is a living, breathing ordinance in that it's changed significantly over the last 7 years since I've sat here. And I will say that what makes this different is years ago, correct me if I'm wrong, anyone in the city of Fort Lauderdale could file a historic designation application on any property in the city of Fort Lauderdale. And we said, that's not really the way we want to go. We changed that so that now the city can move forward on a designation, the owner of a property can move forward on a designation, and also an agency, an organization that has, I guess, historic preservation in its mission. But I think when we do these kinds of surveys in, like what you're saying, your neighborhood of Imperial Point, it's not going to be with the intent to necessarily create a district or designate properties in that district. It's a good resource for us. We have to look at this agenda item in front of us. We're talking about the city's primary historic district. The city's primary historic district, and we're down to 14 contributing structures. Think of what we've lost. And if this commission wants to go down the road of losing all of our historic properties, so be it. I do not want to go down that road. We have to maintain some semblance, some physical manifestation of our history for future generations. It's as simple as that. And the agenda item in front of us tonight is actually helping property owners in the Himeshi Village H1 district, because it's, as Tricia said, creating incentives for them, giving them more opportunities to take advantage of being a contributing structure. But again, I want to go back to the point. This is a district that was created 50 years ago. How many owners in this district have owned their property for 50 years?
Potentially some of the city-owned properties.
Potentially some of the city-owned property. Correct me if I'm wrong, but I think the commission also in the last 7 years has worked with the property appraisers office. Don't we identify on a properties folio that this is either a historically designated property or sitting in a historic district?
Yes.
Yes. Did you hear that? Yes.
Yes, and I also heard how we are now adding an additional layer of designation to that for contributing and non-contributing.
It's not an additional layer. It's not an additional layer.
Vice Mayor, I'm not talking to you. I have the floor, and I'm
sorry.
talking to
Go
Tricia.
ahead.
Thank
Take
you
the
very
floor.
much. Appreciate
Take the
that.
floor. But I just don't want so much
I really
misinformation.
don't care what you think, Vice Mayor.
Oh, that's very rude, but okay, go ahead.
So, thank you, Tricia. If we would just get back to where I
Very
was before.
rude.
I really don't care.
I know you don't.
All right. Come on. Well,
so again,
let's
I want to
summarize.
go back to where I was. What is the process by which a property owner can object to the designation? That's all.
It's not a designation.
Vice Mayor, do I have the floor or not?
You do.
Thank you. Please shut up.
Oh, my God.
Whoa. Mayor, would you exercise your gavel, please?
Well, let me ask you a question.
On Commissioner Hurd.
I'm just trying to ask a question and get a straight answer.
Okay, so we're talking just about the Himeshi Historical District, right? That's correct.
That is the agenda item.
That's what the item's about, correct?
Correct.
Okay.
And my question is about the Himeshi Historical District. If somebody wants to object, what is the process by which they can do that?
The process is either come to staff, go to the Historic Preservation Board meeting, or come to the City Commission.
Thank you very much.
Okay. Any further questions?
Yeah, I have questions and
Go
comments, but I think we have some public that want to
Yeah, we
speak,
do.
Mayor.
Well,
So
I'll
I'm
get
going
to them.
to speak after them.
Okay.
And ask questions
We have
after
three
them.
people who
Thank
signed
you.
up to speak. Is Robert Lockery here? Robert Lockery, followed by Richard Mercedes, followed by Larry Melee. First, Robert Lockery. Oh, I said Robert Lockery, followed by Richard Mercedes, followed by Larry Melee.
Good evening, Mayor, Vice Mayor, Commissioners. Robert Lockery. Thank you for your time and interest in this matter. I'm here representing a property owner next to a property that's designated as contributing, so not specifically affected by this. It is within the district, Mayor. And that's why we're here. I know that's why Richard was getting up. We're here to support our neighbor at Emily's Garden at 327 Southwest 2nd, which is listed as contributing. I think the one thing that we all can recognize is going on right now is there's a lot of discussions about Himeshi and about 2nd Street and what the future of 2nd Street is going to look like. The city's gone out of its way to begin that process of working with different stakeholders and property owners, including the Performing Arts Center that we're sitting in, Museum of Discovery and Science, and I believe History Fort Lauderdale as well. what I would ask the commission to do, again, in support of our neighbors, but generally as we look at the district, is to look at this holistically. And the concern that we're sympathetic to is that by moving forward with this item tonight and identifying specific properties, it could become a cumbersome additional barrier as we look at how the area will be redeveloped. So again, we would encourage you, and in support of our neighbors who I know are going to speak, to take a pause on this tonight, to take a step back. I know, as the Vice Mayor has indicated, it's been in 8 years, but I think when you've gone 8 years, we can make sure we get it right. And so that's our request.
Well, what is your objection to it? I'm not quite sure I understand it.
Again, our objection is not specifically as the way it affects our property. The objection is not the objection to the principle, and we understand it's a report that's been done. That's part of it.
Tell me what it's not.
What we are here is to support our neighbors who are concerned about the effect it will have on their property and their ability to have future investment in their property.
Okay. Thank you.
Yes, thank you.
Richard Mercedes.
Mayor,
Yes.
Commission, thank you for your time. I just wanted to make a point that I was at the last historic meeting in reference to this contributing or non-contributing situation. I got up and I said I was very confused about it. And I specifically asked the question if there's any difference, and I was told there is no difference. And Commissioner Herbst actually said that he saw that in a minute meeting or something. He saw it in writing. But there is a difference, and we just asked if we can have time because we didn't know that there is a difference in that contributing or not contributing. And if we could get maybe, like Mr. Lockery said, if we can extend this so that we can have more time to understand it, because we really don't understand the difference. Thank you. Oh, I'm sorry.
Thanks for being here. When did you get notice about that this was going to be coming up for discussion, or is going to be coming in front of the historical board?
There was a sign in front of our building last month, end of December, early January, and we got a letter.
Yep.
So we came, but this time there was no sign, and there was no letter. Mr. Lockery reached out to me and he said, there's a meeting Tuesday night about this, and I said, about what? He said the contributing thing. I said, well, and so we're a little just caught off guard by it.
Sure. So, if you just hang up here for a second. So, Mayor, I mean, as I think we know, and in the, I'm just looking at the exhibit with the facts from the city, there is a difference between contributing and non-contributing. Okay, it's a higher standard when it's contributing. So, there's differences that a contributing property would have to go through that a non-contributing property would not have to go to in terms of improvements. So I think if we have a property owner that has not gotten a chance to meet with Tricia and to talk through this and to understand it, I think we should give that property owner the right and the time, for their property at least, to spend some time with Tricia, make the case for what they would like, and not make that decision tonight for a property owner that wants to better advocate for their property. Is that what you'd like, Rick?
Yes, absolutely.
You'd like more time to talk with staff, understand, right?
I didn't know I was supposed to speak. I'm sorry. Yes,
No,
absolutely.
Yeah, it's fine. Yeah. Okay. And you're on the
my
map.
first time here. I'm sorry.
And on the map, you're at the map. It's Exhibit 5, map of Himmershey. Your property is listed as 329.
Yes.
Contributing. Yep.
Yes.
Okay. Great. Thanks.
Thank you.
Yep.
Push that.
Yep.
Which is your property, Richard?
329. Mayor, if you look, it's on that list you're looking at. Let me see.
I'm looking at the list.
Yep, go down to, it's the last one.
321 Southwest 2nd Street.
329 Southwest 2nd Street, yep. 19, yep.
Got it.
Yep.
Okay, thank you.
So my name is Larry Mele. I'm a restaurateur that decided 3 years ago to open my first restaurant in Fort Lauderdale, right here. And
Which restaurant?
Pumarola. Thank you.
Very good. We love it.
You should celebrate there tonight.
Yeah, celebrate. Exactly.
Or at Emily's Garden.
Did you
Great
bring
pizza.
samples?
So, we got a lot of support from the city when we opened the restaurant. And by the way, we have 6 restaurants in Miami-Dade. We moved away from Miami-Dade because how hard it has become to open a business there. And we decided to come here with my family and open. I met Richard and opened his property. And then we got a chance to take control of 329, which when we knew it was historical. We didn't knew it would be contributory. So I think with Emily's Garden we did a great job, I think, for the neighbor, and that's what an historical property can be improved if you improve the neighbor, and that's exactly what we did with that restaurant. Now, we were not informed about this meeting tonight. I didn't know about any of this. I called my manager. I said, look, you got to go around. Make sure there is no signs, because Tricia just told us there is signs. We found one sign on 3rd Street, which nobody goes because it's very dangerous, to be honest with you. So we are at the corner, right next to the Science Museum, in front of the park, and there is no sign to be seen about this meeting today. We can get ready to prove a point and to say, look, we don't want it to be contributory, or we want to be contributory. There is no chance for us. The links on the website I try as well. Doesn't work. It just doesn't work. So, I think you should give us more time.
So can I ask you a question?
Yeah, of course.
Are we talking about the building in which your restaurant is located?
Yes.
So what is the issue there?
What is the issue?
There is not really clear what the contributory is.
Well, no. So what is the issue? Are you being asked? Are you being asked to do something? I mean, you were given you have your restaurant that's open. Signage was approved. The use is approved. We're not.
Not yet.
You're not. It's not approved.
Not yet.
The use is not approved.
Well, the use of a restaurant was a restaurant already.
Right. So there's no issue there. Have you been cited for something? Are you?
Not that I know of.
No. So there's no code violation. So I'm not quite sure why you're objecting
Because
to this.
we don't know.
You don't know what?
What contributing is and non-contributing
What
is.
is. I mean, you already have your business open.
Right.
What
No,
is
but I own the property.
I understand that.
I control the property. So
Okay, let me back up. What is the issue that you're concerned about, since you already have your business opened, you're already operating,
Yes.
everything was approved for it?
Yes.
What's the issue?
It may damage the value of the property.
I'm sorry?
It may damage the value of the property.
In what way?
So another restaurant can't go in there again?
No, but if I invest in real estate,
Yeah.
restaurants one part of the business, real
Right.
estate is another.
So you're saying that someday you may retire from that business and you may want to sell the property or redevelop it?
I may sell it tomorrow.
No, I'm just asking these questions. So that's what
No,
you're
no.
saying? Is that what you're saying? That
Yeah, I could sell the property at a different value if it is contributing or not contributing. I can do different things if it is contributing or non-contributing. Sometimes restaurants don't work out. It's just a risk that we're taking. Hopefully it's not the case. We want to have a restaurant. But at the same time, I don't want limitations. Ideally, if this contributing thing limits, if it doesn't limit me, I have no problem. But I don't know now. My problem is this meeting wasn't we were not informed about this meeting.
Okay.
Do you get the city notices of when?
Not about this meeting.
No, but this is a city commission meeting.
Yes.
Are you signed? And I would recommend you do sign up and get notices of our meetings, because we meet the first and third Tuesdays of every month. But you can sign up and get notices of meetings, and you can sign up and get all the information you want. If you actually, your restaurants are located in District 2, we send out a lot of communication. Please let us know your email address. We'll be happy to send you notices of all of these meetings, all of these topics, whenever
I'll
you
sign
want.
up for sure, but there were no signs. You can go now. You don't see any sign.
Okay, I understand that.
That's
And so let's say we defer this,
Yes.
and we have another meeting in which you know about.
Yes.
How is it going to? What issue?
Well, tomorrow I will hire an attorney to represent me because this is not. I'm not familiar with this.
I understand it, but let's just be practical, okay?
Yes.
What is going to change between this meeting and another meeting, whether you have an attorney or don't have an attorney? What is going to change in terms of your property rights?
Yes.
You're having bought in a historic district.
Yes.
Okay. you were aware it was a historic district.
Yes.
So tell me I don't understand what the issue is here.
I would.
So, Mayor, I think one of the things that it could do potentially is limit signage. It could limit outside seating, things like that. So I think that there are potential impacts that could result from this.
But he has signage and he has outside.
Well, one second.
The ability to change signage.
I want to hear Tricia talk to those issues, if that's really true.
I need to reach 120 seats in order for me to have a full liquor license.
I understand.
Now,
that.
if there is a limitation for that, that's a big issue. I can't
Well,
get a
you
liquor
have
license.
a very small footprint. I mean,
12 feet, 12,000.
I mean, you need parking.
No,
And
I
you
don't need parking.
You don't need parking.
No.
You don't need parking.
It's exempt from parking.
I'm sorry?
It's exempt from parking.
It's exempt from parking.
Yes.
So you don't want anybody to park in your restaurant?
Well, I don't have a space. I would love to.
No, I'm just.
He doesn't even have the requirement.
I don't want to dance around here. I just want to be very practical.
Yes.
And maybe Richard, you can help in this conversation. You know what I'm getting at.
I do.
You're running a business. You want to run a business there. Well, you already got a business there. You want to have You want to have seating there. You have to have 125 seats to get a full liquor license,
Yes,
right?
sir.
Okay.
Yes, ma'am.
How many seats do you have there now? About 40?
No, we have almost 125 seats. We have it.
We apply.
We're applying now.
They have
So we're doing
everything.
our.
You have the 125
Yes,
seats.
we do. This has nothing to do with that. We're just concerned that we don't know the difference between contributory or non-contributory, so we're just asking for more time. We're not saying
And when you find out the definition, how is that going to change your operation?
we might be perfectly fine with it. We might be loving the fact that we're going to get a tax break. We might love that, but if you're going to put shackles on us, we might not like that. So we're trying to figure that out, and we couldn't figure it out in time. So that's why I asked if we could just have some time to postpone this. We're not coming here in a negative way. We love what you all are doing. But
When this went to the Historic Preservation Board,
yes, sir.
a month and a half ago, or
About that, yes.
were you there?
I was.
Did you say all of this?
Yes, I said I don't know what it is. They said,
What happened that night?
they said there's no difference.
That's on the minute of the meeting.
It's on the minutes.
They said there's no difference.
Right, and there is difference.
Well, I want Trish to get into that in a little bit, and Trish can also help us with. I'd like to know what that vote was at the HPB.
5-0.
5-0.
They all
in favor.
Well, no, I shouldn't say 5. Everybody voted in favor of it,
Okay.
and I didn't really have a problem with it.
Okay. So, the answers that you came away with that night about the difference between contributing and non-contributing were what? What do you think is the difference between?
There was nothing.
There's no difference.
Right.
No difference.
No difference.
Okay, but now you think there is a difference.
I know there's a difference.
Okay,
There is a difference.
So Trish,
Yes.
help explain why they thought there was no difference, but there is a difference. And what is that difference? And how will this impact their business?
Well, with the I
In
did
30
take,
seconds, yeah.
I did take a look at the minutes, and what it says is there is no change to the ordinance or the review process, which is true. There's no change to the ordinance at this time. There's no change in the review process that someone would need to go through to make a request for a sign or for any exterior changes. We do not take a look at the interior unless it's something that's affecting the exterior. And then in the Himmershey Historic District, there is an exemption for parking requirements. So they do not have to provide parking for any business in Himmershey because it's a historic district.
That's a good thing for a business.
Well,
It can be.
So what is so we now know that there is a difference between a contributing and non-contributing structure. Okay.
Correct.
Okay. But the requirements for making any changes as a contributing structure have not changed.
No changes.
Nothing
Sounds correct.
Right. So when you bought the property, you knew you were in a historic district. Okay, and you knew that in order to make any exterior changes, there might be some process you have to go through.
Sure.
You knew that. I know you knew that, Richard, because you're not a stupid person. You're very smart, and you do your due diligence, and I know you knew what you were getting into.
You know, I have a question for the
Yes.
commission here, and for Trish. Then why do this if there's no difference?
No,
Blue, red?
there is a difference.
No, there is a difference.
Oh, there is a difference. See?
No, the difference is that we are trying to give contributing structures more benefits, more incentives. We're
I
trying
like
to
that.
make it. We're trying to make it better for contributing structures. The 14 that have been identified, we're trying to say, hey, here's an avenue where you can take advantage of incentives that will help you. Tax breaks, other types of incentives, national programs, transfer of development rights. I can go down that list. But what we're basically saying is, due to time, due to changes of some of the original structures, they're no longer contributing. In fact, I would say it's better to be a contributing structure than a non-contributing structure, because it opens up a whole other avenue for you to benefit for your business.
It does. And the truth is that the tax incentives could be very interesting to people who want the tax incentive. We don't really care about the tax incentive.
That's just you.
Correct. So, and so I'm not saying that in an arrogant way. I'm saying it like, I'd rather that tax savings to go to somebody else. We're okay with whatever the tax implication is going to be. But to impose this thing on us, and we don't really understand it, and we had 2 days, and yesterday was a holiday, so we didn't really have any time to get familiar with it. So I don't know what I don't know how you all do this. If you say, listen, come back next month, and then the gamble's going to come down. We're going to make a decision next month. But make it now, we're at a disadvantage because we don't really understand the difference.
Can I ask Trish a question?
Absolutely.
Trish, let's play devil's advocate. Why would you not want to be one of the 14 contributing structures in the Himashi H1 Historic District?
You're asking her.
I mean, it's a difficult.
I need to understand the fear here. I need to understand.
Isn't that a personal question to the property owner?
No, I'm asking Trish.
And I know that you're asking Trish, but my response to you is you would ask the individual property owner if it's for them or not Trish. Trish is giving us a definition, but it doesn't mean what the property owner wants.
I understand, but
okay.
Maybe I was going to ask them that next.
Okay, go ahead.
But
go
okay,
ahead. I
thank
just want
you.
to make sure.
I won't be as rude to you as others have been this evening.
All right, just go ahead.
Thank you. Go ahead. Thank you.
So as a contributing property, obviously, as you stated, you do get to take advantage of the incentives that are offered to the contributing structures and the designated structures as historic landmarks that are designated throughout the city. It does give a level of honor to a property as well to know that they are contributing to the historic district and have a documentation of their history of their building. It gives them more information on what changes have occurred over time and what, a level of expectation of what they could do in the future. Historic preservation isn't necessarily freezing a structure or a property in time. It can be modified through the Historic Preservation Board process and the Historic Preservation Ordinance. You can do additions. On this property, there's one structure. They have an open area that they could do an addition or another, an addition on the structure that would make their existing building slightly larger, and it would come down to requirements of making that structure compatible within the district and to that historic property specifically.
Okay, let me share. So I'm reading Exhibit 7, City of Fort Lauderdale, Exhibit 7, where it talks about frequently asked questions. Okay, so I'm on page 3. And the question, it says in Exhibit 7, is how will assigning a contributing or non-contributing status affect my property? Okay, the last sentence in that section says, properties identified as non-contributing would still be subject to the Historic Preservation Ordinance, but may have more lenience within the review process concerning exterior alterations to existing buildings. So, to put that another way, how I interpret that, and Tricia, please correct me if I'm wrong, is what it's saying is if you're non-contributing, you're going to have more lenience within the review process to make exterior alterations than contributing properties would. Is that correct?
It's correct in the fact that if you have a non-contributing property, you have the ability to, if you have single-hung windows, but you want casement windows now, potentially that's okay because there's not a historical significance to that architecture to have a basis for the requested change. There are overall design guidelines and regulations that affect a historic district where you'd want to maintain consistency. So there are regulations for height in this district. There's
Great.
regulations
So, hold
for
on. Let me just hang right there. So, in other words, for a property owner, it could be disadvantageous to be labeled contributing versus non-contributing because you have a heightened level of review as a contributing property.
Well,
right? Just yes or no?
I mean, I think that in this case, you don't have any differentiation today. So going into
I'm not saying today.
preservation,
I'm saying designated as non-contributing versus contributing. Contributing have a heightened standard of review.
Yes, it does.
It
Is
does.
That's
Thank
a given.
you.
That's a given.
Okay.
But people know that going into the Himmershey district.
No, they don't, Mayor.
They don't?
No, because it has not been designated as contributing or non-contributing yet. It is right now, and correct me if I'm wrong, Tricia, but right now, our properties, if we had to pick non-contributing versus contributing, what are the properties today before anything is passed? Would you say that they are more similar to non-contributing right now today or contributing today as the ordinance stands right now and zoning stands?
I'm not sure if I understand the question.
Sure. So right now, we haven't designated any of these properties as contributing or non-contributing. Is that correct?
Yes, correct.
Okay. So what are they designated as right now?
They are designated as part of the historic district.
Excellent. Part of the historic district. Is that the requirement as being part of the historic district? What levels of review does that require? Is it more similar to non-contributing as it would be, or more similar to contributing? Does that make sense?
So it's the same. It would remain the same, but it's more information when it comes to the actual review. So regardless of whether you put a status on a building, when it comes to the Historic Preservation Board and an application comes before them, staff provides a summary of the significance of that building from the information that we have. So we're going to state when it was built, what alterations have been undertaken, what are significant features of that building that would need to be preserved. But today, that's not necessarily an adopted aspect of this historic district.
Right.
So then coming into the Historic Preservation Board meeting, a property owner wouldn't have that information readily available to go off of in preparing their application. So a building that was built in 1925 and is very significant to the historic district as described in the 1977 report would come before the Historic Preservation Board, and I would give them the information about that building. It was built in 1925. It was designed by Francis Abreu, a very well-known and respected architect. It is this architectural style. It has these architectural features. And they're requesting to modify the windows from single hung to casement. That's an issue. And I could have told them that. They could have known that as the property owner before they prepared their plans. Or, they go to the board and get that information. So regardless, they're still in the historic district. It's information that we can provide upfront and be transparent as part of this historic district. Or it's something that can come later when a property owner is requesting a modification or a change to their building.
Sure. I guess let me give you one other sentence. It says here in the city's facts, it says the same level of review applied to contributing properties to assess potential adverse effects to historical architecture features would not be applied to non-contributing properties. Okay.
Correct, because
Right.
there wouldn't be significant architectural features.
Exactly. So, and then to touch back on one of your earlier points, you said it's really important for property owners to be noticed by the city that this is being considered, right? You said that right, contributing, non-contributing. And he said property owners could, I think he said, come to meet with you, to talk through it, to make their case as to why they want to be one or the other, right? Is that right?
Correct.
Okay, great. So these gentlemen, let's just say it's their own fault. Let's say, hey, they should have known, they should have seen the sign, they should have understood it. got it. They didn't do it. I think it'd be helpful if they could have a chance to meet with you to talk about what they want, why, go through data, all that kind of stuff. Is that fair?
I'm happy to meet with them.
Okay. I think that's, Mayor, I think that's ultimately would be so helpful to follow Tricia's recommended process of being able to meet with her and better understand.
So how does that, so where are we with regard to this item then, this resolution?
What my suggestion would be is to, unless we have is anyone else here to speak on this item, Mayor? I don't think we do.
Is what Michaela wants to speak on this item.
Oh, Michaela wants to speak on this item. Okay, then maybe hear her.
Before Trish goes away, I wanted to ask her one more question. I'm sorry. So Trish, because I don't want anyone to think that all of a sudden we just made up these terms, contributing and non-contributing. This is in our Unified Land Development Regulations, correct, these definitions?
Correct, yeah.
They're also from, I believe, the National Preservation Act, Historic Preservation Act from 1966?
Yes.
So these are not made-up concepts for us right now?
No.
And you didn't make these up?
It's typical in historic preservation ordinances throughout the country.
It's typical. And it's also typical, if you are a certified local government like the city of Fort Lauderdale is, that you follow these processes because you actually, especially in a historic district, you want to know why a structure is either contributing or non-contributing. Even for simple educational purposes, it's important to know that if you're going to have a historic district or if you're going to have historically designated properties, it's important to know, correct?
Correct.
It's part of the research. It's part of the education. It's part of the process. So we're not making anything up, correct?
Yeah, we're not making anything up. This is all consistent with federal regulations and with other cities in the state of Florida and nationwide.
Right. But I also want to make sure that I'm comfortable in knowing that in your interpretation, that it's not harmful to be a contributing structure within a historic district as opposed to being a non-contributing structure in a historic district. Because whether you're one or the other, you're in a historic district. And when you purchase that property, you could see that listed on the property appraiser's website. You could certainly read the Unified Land Development Regulations of the City of Fort Lauderdale and understand the difference between a contributing and non-contributing structure. Or you could read the 1966 Historic Preservation Act and read it, and you can understand and you can be educated about what it means to be in a historic district.
Correct.
Yeah. Correct. Okay, thanks.
But to finish your thought, though, are these? Let's go back to the agenda.
And their criteria.
Wait a minute. Are these particular properties asked to be designated contributing and non-contributing tonight?
So,
are these particular properties that are on the agenda? Let me go back to the item R3. Appendix Exhibit 2, are these properties, are you asking the commission tonight to make a decision as to whether or not they're contributing or non-contributing tonight at tonight's meeting?
Yes, it would assign a status to each of those structures.
Tonight?
Yes, along with adopting the report.
So, but should we not have an opportunity to have each one of these property owners have an opportunity? Can't they argue their case separately instead of doing them en masse like this?
So when you're doing a historic district, it's taking a look at it as a whole within the geographic boundaries.
Right.
So taking a look at how that structure represents the district as a whole, why it is significant as a whole.
And I'm not to interrupt you, but I understand that. So what you're...
So it's not necessarily a case-by-case basis as it is like that structure within the overall
But what you're
context.
doing, so with that process in mind, what you're doing is you're sort of creating a presumption. If we were to pass this tonight, there's creating a presumption that there's a particular property is contributing, for example, and they'd have to come back and rebut that presumption and say, no, it really shouldn't be included in the contributing category. And that puts the burden on the property owner.
I wouldn't say it's a presumption, as these determinations are made utilizing facts and information that is available through our permits And
But you've already made that determination. If we were to approve this as the list of contributing properties.
Yes.
So we've already made that determination. Yes. So in fact, it is a presumption, and if they want to go for a permit to do something, they've got to go through that extra level of review, which a non-contributing property would not have to go through, as the Commissioner Sorensen has pointed out.
They're all going through the same levels of review. It's just that we have additional information to provide to that reviewer.
Well, you can call it what you want, but a contributing property is held under a higher level of scrutiny than a non-contributing one, correct?
Yes.
Right.
Because it meets certain criteria.
Correct.
Right.
I mean, we're not making up the criteria.
The criteria are already there, but the application of the criteria, the property owner should have the opportunity to dispute it before we label it contributing.
Exactly. I agree, Mayor. And Mayor, I think that sending a letter is a wonderful means of communication, but we've got to do more than that, because it has a significant impact on these properties, their futures. So I think we've really got to, whether it's knock on doors or phone calls.
Well, they should be able to do it on a case-by-case basis.
To make sure that they're being communicated with.
So, Mayor,
yes,
and have the opportunity to rebut.
I agree. Exactly.
So, Mayor, we're hoping not to muddy the waters. I think what Tricia is trying to explain to the Commission is during the review, for example, for a certificate of appropriateness, staff will review each individual property for their contributing nature for different criteria, including their contribution to the historic district. All of the properties within the district are subject to this review process. And during this review process, the items that they've identified in this survey that makes the assignment of contributing appropriate for this property will be raised by her in the staff report at that time when they seek their certificate of appropriateness. By labeling them as contributing at this time, it gives the property owners notice ahead of time that these elements exist on their property and will be part of the consideration when they move forward and seek to do certain alterations to their property. So it's
Dwayne, within that, though, it says in the FAQ lenience. Lenience means a lower level of exercise of authority. Lenience means you have a certain level of discretion that when you don't have lenience, you don't have. That's pretty straightforward.
No, I do understand what the FAQ is saying, but what I'm kind of suggesting to the Commission is that it doesn't change how staff will be reviewing these properties in terms of their recommendation for issuance of certificate of appropriateness. The buildings have these elements, and they've identified these elements, and they're just telling you ahead of time that we consider these buildings contributing.
Right, so this is just a heads up, like
essentially.
Okay, as opposed to a designation. I'm against it. Personally, I'm against the designation.
Yeah.
But if it's just a heads up, saying, "Hey, by the way,"
I don't think it's a heads up.
I don't think it's a heads up.
It's not a heads up. But I think the issue is that it's not necessarily a rebuttable presumption. We've done the study. They've identified these elements, and we're saying because of these elements on your building, it's considered as contributing. I mean, you're asking a tough question in terms of once we have or adopted these findings, whether or not they can come back and say that they're not contributing. No, you can't. Once you've rung the bell, you can unring.
Right. That's what I'm concerned about.
If it's a tough question for us, what's it like for the property owners?
Well, no, but it's not. The thing is, once we ring the bell, it's hard to unring it. Correct? That's what you just said. Right. So I don't want to ring the bell yet. I think when it comes to property rights, I think that they now anyone who's listed on this exhibit needs to be aware that the city considers their property to be either contributing or non-contributing, so that when they do go for any permit and to try to get a permit approved, they're now given a heads up. We don't have to approve this list, but it's now a public record, and people are given a heads up as to what they can expect when they want to go apply for a building permit.
That's where you're in that kind of weird. You're a certified local government, and you kind of should do it.
Yes.
But I do understand the position that the commission has taken with regards to this.
I just have a hesitancy. I want to see the integrity of the Himmershey Historic District be maintained.
So what I am hearing from the property owners is that they want to be educated a little bit more on the process, and I don't know if delaying it and providing, doing an education campaign would help in this instance to get us to where we need to go on that. I think that might be a good step.
What might be a good step?
Just deferring the item and educating the property owners on what it means to be contributing versus non-contributing and the impact. I think the most concern is with regards to the improvements that they're able to make in their property and how that assignment of contributing affects their property. What we're kind of suggesting here is that, the same elements that we're giving you notice of by attaching the contributing assignment to your property are the same things that today, even without the designation, staff will review and make those recommendations to the Historic Preservation Board when you come before them for a certificate.
Exactly.
Nonetheless, correct.
But, and I think that's the fairest way of doing it. I still think there's a rebuttable presumption that's going on here if we were to pass this as is. But if we can ask staff to engage in an educational process where people are given a heads up as to what they can expect, because we're looking at look at some of these places. I mean, these are historic district historic buildings. The King Cromartie House.
Mm-hmm.
I mean, hello, the New River Inn. All these, Shippey House. I mean, I think Shippey House was already designated historic. So the point is that people should know as they're going into the approval process the kind of the headwinds that they can anticipate, but that are not already assumed, because we've made that property contributing. So I think that's kind of what we want to do here, and if that's a consensus of why don't we defer? Hold on a second. I'm just going to recommend that we defer this, but we still have one more person who wants to speak.
Could I ask Dwayne a question to follow up on what he said? So Dwayne, how do we then, obviously, if some people don't want to be a contributing structure, how do we satisfy those that might want to be a contributing structure to take advantage of the incentives that we have for historic preservation? How do we, if we never pass something like this and codify what the Historic Preservation Board has recommended, how do we then assist the properties in the historic district that want to be contributing so they're able to take advantage of those incentives?
Your commission definitely has to take some action to identify and recognize contributing properties so that they can take advantage of some of the tax incentives and some of the other incentives that we have in our code for properties that contribute to the historic district. So there will have to be some kind of action to recognize those properties.
Can't they just apply to be historically designated
No,
like every other?
They're in a historic district already.
I know, but to be historically designated.
Well, here's a suggestion. It comes back to communication. So, Susan, I think it'd be really helpful if we, and I don't know if we've talked to all these property owners in this district, but I think it'd be great to get them on the phone, knock on their door, and if they want to be contributing, then let's at the next commission meeting have a list of all the properties within this district that want to be contributing, and we pass those immediately. The ones that are challenging their status or would like to think differently of it, then we'll work on those as they come. But
good idea,
right?
Good idea.
Fair.
Okay.
But that includes that awareness and educational.
That's
Absolutely.
what he said. That's what he said.
Absolutely.
All right. So do I hear a motion to defer R3?
Moved.
So move.
Second.
All right. Been moved and seconded.
Are we
There's
deferring
no date
it
certain.
to no date?
McKellar didn't
So I
talk.
think
She declined.
Oh.
Please call the roll. Do we have to have a date certain? I don't. Dwayne, we don't have to have a date certain. No. Okay. No.
Okay. Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst?
Yes.
Vice Mayor Glassman?
I'm voting no, but I wanted to thank the Historic Preservation Board for its work. I thought it was very thorough, and I really think that kicking the can down the road is not going to actually ever get to the question of, if we're going to have a historic district, a contributing structure is defined by the federal government and our own ordinances. It's not like we're making up anything. So it's really not a matter of whether we're not really addressing the issue of what is a contributing structure, not a contributing structure. We're only saying whether someone wants to be a contributing structure and not be a contributing
Correct.
structure.
That's exactly correct.
Right, but we're not addressing the meat and potatoes of what it means to be a historic district or what it is to be a contributing structure. But it's okay. I understand.
Isn't
I'm
that
just going to
part
vote.
of the education?
Yeah.
That
Yes.
will be defined
Yes.
through the education and awareness campaign.
Yes. No, and I'm happy that we're doing that. It actually has been continuing over the last 7 years. But I'm just going to vote no, if that's okay.
Yeah, it's okay.
Thank
you can
you.
vote no.
I think that we should follow. I've never seen a unanimous vote at the Historic Preservation Board. I've been reading their minutes for years. They actually voted unanimously on this, and that to me is already a signal. So that's okay. We'll do what we all want to do.
We'll do it in baby steps.
We'll do baby steps.
We'll
I'm going
get
to
there.
vote no. Thank
We'll
you.
get there.
And Mayor Trentelis.
Yes, and let me also add that with that vote, we request the staff to communicate with each individual property owner to discuss what the impact is or the the benefits or disadvantages of the designation, and if any one of these property owners want to be considered, we can bring that list back to be voted on and let them have that benefit to be able to apply for those advantages that you spoke about, Vice Mayor. Okay, moving on. R4, resolution authorizing the state historical marker at the entrance to the Jimmy Everett Tennis Center in Holiday Park to honor Christine Marie Chris Everett.
Have we asked Chrissy Everett if she wants to be designated?
She's not historic.
Okay.
Would someone like to introduce the resolution?
Introduced.
Any questions or comments? There being none, please call the roll.
A resolution of the City Commission of the City of Fort Lauderdale, Florida, authorizing proper city officials to submit an application to Florida's Division of Historical Resources to place a state historic marker in the City of Fort Lauderdale at the Jimmy Everett Tennis Center entrance to honor Christine Marie Chris Everett and providing for an effective date. Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst?
Yes.
Vice Mayor Glassman?
Yes.
Mayor Trentelis?
Yes, and R4 is now approved. R5, a resolution waiving the general employees retirement system early retirement reduction factor regarding our former employee Jerry Pryor. Jerry's the only one who signed up to speak, but just to answer questions. Does someone like to introduce the resolution?
Introduced.
All right, anyone have any comments? Anyone like to speak with regard to the resolution? Okay. All right. No comments or requests. Can I ask a couple questions? Okay. What impact does this have on the reduction of the reduction factor? What is that actually giving to Jerry?
It translates to $339 a month.
So what would be her retirement pay now?
So I just did some back of the napkin calculations, but with the reduction, it would be about $6,700 a month. Without the reduction, I think $7,062.
So she'd be getting $6,700 a month now, if we take no action.
With the reduction and with the waiver of the reduction, $7,062.
Okay, and the basis for the reduction is what?
So there's a provision in the city ordinance that if someone's assignment changes, which Jerry's assignment did change, she was transferred to the city manager's office with a 60-day window to apply for other jobs. And at the end of that, there would be termination. So given that, She fell into a category that would allow her to request the waiver, and then it's subject to the pension board making a recommendation to the city commission, which they have, and then we brought that to the commission for your consideration.
So she did not find, did she not find other employment within the city?
Not within the city, but she did find employment.
Okay. And is that other employment allow her to tack her employment history with this city onto her new job? Is she also working for a government agency?
She is, but the plan that she was in, GERS, was specific to the city of Fort Lauderdale. So it's not like an FRS that would transfer. to.
We have what's referred to as a local law plan. So it's specific only to the city of Fort Lauderdale.
Okay. And so she's currently employed?
Yes.
Okay. And is she eligible for a pension in her new employment?
That I would not be able to answer, but I believe so.
Jerry, are you eligible for employment in your for retirement in your new job?
I'm contributing to another pension plan. However, I'm not eligible until I'm 5 years vested.
5 years. So after 5 years, you will get a pension from the new job?
Yes.
Okay. Now, I understand that this came as a recommendation of the board, but you also are on that board. Tell us what happened there.
Sure. So after Ms. Grant, and first off, thank you. Thank you for having the consideration to allow me to move forward in this process. So I presented to the board of the pension board, explained the circumstance just like Ms. Grant had advised, and then I recused myself and I left the room. And then the board deliberated, and then when they were finished with their vote, they came and got me and then advised that the motion had passed and that they would forward the memo to the city manager.
Did you participate in any of the discussion regarding your requests?
Absolutely not.
Okay. All right. Does anyone have any questions of Jerry?
I have a question for Susan. Susan, has this happened before where the city commission has waived an early retirement reduction?
Yeah, the last one that we had was in 2022.
When you say the last one, so how many have we had?
I know that there was that one previously when I was here. I don't know that number off the top of my head, but the provision has been in the plan for quite some time. So I think when I asked, I think that it had been in the plan document since the 70s.
Do you know, so would David know maybe how many times this has happened in the past where the commission has granted a waiver?
I was requested to look at it the last 10 years, and I found one.
So one in the last 10 years. And do we know what the circumstances were for that one in the last 10 years?
It was actually a little bit different circumstance, and it was a longer period of time. I think it might have been a couple years that they were waiving it if it was someone who is in bad health.
Bad health? Okay, thank you.
The window for the retirement is how many months? It's 11 months?
For me, yes,
For you,
correct,
for you,
correct,
exactly.
correct.
So
but
we're only
in the
talking
provision
about...
of the ordinance, it's 4 years.
Mm-hmm.
Correct.
Okay. All right, thank you. So we're only talking about 11 months?
A few months,
A few
correct.
months, okay.
Okay. Anyone else have any questions? There being none, the resolution has been introduced. Please call the roll.
A resolution of the City Commission of the City of Fort Lauderdale, Florida, waiving the early retirement reduction factor for Jerry Pryor and providing for an effective date. Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
No.
Commissioner Herbst?
Yes.
Vice Mayor Glassman?
No.
Mayor Trentalis?
No. Thing is, Jerry's got another job. She's eligible for another pension.
I'm sorry, Mayor, that was not defined in the ordinance. So I appreciate your comments, but however, it's not defined and the language does not provide for that. My retirement is my retirement after 25 years. So
And you're
I
getting a
appreciate the
retirement.
consideration.
You are getting a retirement.
Doesn't matter, sir. It's not in the ordinance that I can't work, which, by the way, I got a job because I applied for 2 positions in the city, which they did not consider me for. One was in the HR department, which I qualified and was eligible. They refused to interview me. So for me to have to leave the city is exactly what I did. So
Okay.
thank you.
Thank you. PH1, public hearing, quasi-judicial resolution approving the historic designation of the property commonly known as Castro Convertibles. I believe there's a request to defer that. Are we moving forward with this? We're moving forward.
I'm so sorry, Mayor. I couldn't hear you.
We're moving forward with this, right? There's no request
Yes.
to defer
Yes,
this.
we have
Okay.
a presentation. Yes.
Castro, located at 2860 North Federal Highway as a historic landmark. Historic Preservation Board case number UDPHPD 21003. Anyone wishing to speak must be sworn in. The Commission will announce any site visits, communications, or expert opinions received, and make them a part of the record. Commissioner Herbst, do you have any disclosures?
Yes, I had a conversation with Stephanie Toothaker regarding the property and her client.
Okay. Commissioner Beasley-Pittman?
Stephanie Toothaker and her client.
Yes, I spoke with Ms. Toothaker and her client, Vice Mayor.
Yes, and I'll just give some dates because there was several times, so I want to be fully transparent on this. I did meet with Stephanie Toothaker and her clients July 5th, 2022, September 1st, 2022, October 12th, 2023, April 20th, 2023, and February 12th, 2025.
We have a lot of meetings, Vice Mayor.
Well, it's been deferred for about 8 years now, right? I think, well, how many? A little
We'd
joke.
love to defer it again.
Just a little joke. We love the deferrals when it comes to historic preservation. It's okay.
Okay, Commissioner Sorensen.
Spoke with Stephanie Toothaker.
Okay. The item before us is regarding Castro Convertibles and the sign and the position of the sign. Is there no one other than, well, Mr. Marcus? He signed up to speak, as did Abby Laughlin. Abby, are you here? So before we get you to speak, we'll ask Ms. Toothaker to make a presentation.
Okay, so thank you so much. Stephanie Toothaker on behalf of the property owner, which is June 36, 18 Management. I know you're all familiar with the property. This is the property. It's on North Federal Highway, 2860 North Federal Highway to be exact. This is the Ferguson's building. And if you've bought an appliance for your house, you probably bought it from this building. It's well known in the construction industry in particular and by homeowners. So this is just a survey of the existing property. And again, it's got a very limited parking field out front, and there is a very large warehouse with a showroom. So this is an image of the building. I'm sure you've passed it 100 million times if you live in Fort Lauderdale. And as you can see, there's a very large warehouse component, and then there's a showroom component that is to the south. So this came before the Historic Preservation Board at the request of the Historic Preservation Board. My clients were not there. They did not have notice, and they do object to the designation of this property. So I wanted to pull out a couple of quotes that I thought were really important from when this went to the Historic Preservation Board. I don't really name any of the specific board members, but they are direct quotes out of the minutes. So the Historic Preservation Board in 2021 motioned under the good of the city discussion to schedule an item to consider initiating a historic landmark designation of the property without the owner or ownership representation present and no legal notice required by code. The HPB also in 2021 motioned to initiate a historic landmark designation application, again without the owner or ownership representation present. One board member at that time expressed that they would feel much better about initiating the application if there was a response from the owner and suggested that the city should give additional notice. Mr. Chavone asserted that he was having a difficult time understanding how it was not a conflict of interest for the board to serve as the applicant on this property, which they were, and the judge in the matter. That motion passed 7-0. Then in 2022, the HPB motioned for, they heard the item, again with no representation present. I was not there. I was not aware that this was happening. My client was not there. They were not aware that this was happening. And the HPB motioned for a recommendation of historic landmark designation, again, with nobody present. 2 board members expressed concern and acknowledged that while the city technically complied with notice requirements under the law, they should do additional reach out to the owner, and the owner should have been made aware, as they found it difficult, that the ownership would not be present, considering that they had just acquired the property for $7 million. And 2 of the board members voted against that. It did pass 5-2. One board member said, to put forth an application for designation without hearing from the owner, I struggle with that idea. If the applicant was here and part of this discussion, it would be more of a collaboration to think the ways that we can implement the existing structure with ways that I would presume would be development actions in the future. And then another board member says, I find it almost illogical that someone who purchased the property a year ago for $7 million would not appear before such a significant hearing. I don't find any logic in that. I don't think it's done in protest or ignorance or otherwise. I think they just don't know. That's my thought. That's where I feel short on feeling good about this. I'm not discounting anything has been done correctly. So they went on to the city's historic landmark designation report that was presented to the board, supports the application, and makes reference to a 2018 University of Florida study titled Florida's Mid-Century Modern Architecture, partially funded by the Division of Historical Resources by the Florida Department of State, and identified 50 flagship structures designed by McKiernan, who is the architect here. And guess what? This building is not even listed. So, what are we proposing this evening?
So what's your point?
Here's my point. I'm getting to my point. I think the background is really important, particularly given the discussion that we just listened to. So this is the structure that's there today. If you look at the structure, there is a massive warehouse. I think we can all agree there is nothing historic about that warehouse. And then you have a small storefront. That storefront was actually modified in 2007. In 2007, all of the original windows were replaced, and the owner at the time, which people sometimes call this the Castro building because it was originally developed by Mr. Castro, he sold it, didn't care, wasn't looking to designate it, just wanted to make money as a real estate investor ultimately. So in 2007, massive modifications were made to this building. The only thing that's original to this building is the sign, the pylon sign that actually goes through the building.
Well, the front of the building's historic too.
Well, the front of the building was modified.
No, there's like a...
That was modified in 2007 when they replaced the windows.
Oh, really? Okay.
So we looked at the sign and we said, what can we do here that kind of splits the baby? Preserve something that, you know, we think the sign is really neat too. We think that that's something that we could do, respectful to the original structure. So what we'd like to do, but if you look at the sign and the location of the sign, it sits in the middle of the property, which means that if you designate the entire piece of property or even just the building, which is what the HPB asked for, you're stuck. You're never doing anything else with this property. I will tell you that Ferguson's did renew their lease, so that's the good news, but the lease only goes for just shy of 4 more years. So in the future, you don't know what you're doing to a piece of property if you designate the whole thing. So what we're asking for, what we're proposing is that we would voluntarily designate the pylon sign. We did request a survey for the pylon sign. That is, I expect to have that survey in the next couple of days. Designate the sign, but with the right to move it in the event of a future redevelopment of the site. If Ferguson's goes away, this property can't be used. There's very little parking on it. It wouldn't basically work for any other retail and certainly wouldn't work for redevelopment. So we've done a couple of studies to show you what that would look like. So we would suggest the ability to move that closer to the street so that it could be enjoyed. Here's what that would look like if the site was a redevelopment site with the sign moved, protected and moved. And again, the resolution that's attached to your agenda asks that the entire property be designated. The entire property is not historic. We are asking that the sign be designated. We would work with Tricia on actually designating that and recording an easement over the sign, a historic easement over the sign, but with the right to move it. And we developed some scenarios so that you could see what that might look like in the future. So these, by the way, these are not real. These are just concepts. There is no redevelopment proposed at this time. It is a Ferguson's with an existing lease, but this is what that could potentially look like if the sign were moved all the way out, all the way west to the property line. And there's an image of what that could look like, a very nice, preservation of that sign. And another one would be to incorporate it into a structure. So that's another way of possibly doing it. Again, these are just concepts. This is not a plan. There is no site plan for this property. We're just asking for the ability to not designate the property, not designate what has changed, but just to designate the sign and protect that sign. And that's my entire presentation. And again, the property owners, just to state again for the record, they were not at any of those hearings. They were not aware that this was happening. I actually saw it on an agenda, and I called them. I knew them, and I called them and I said, "Are you aware that the city, the HPB, is trying to designate your property historic?" They had just purchased it for $7 million, and to say that they were unhappy is a mild understatement.
Okay. Thank you. Arthur Marcus, you want to speak on this?
Good evening, Mayor and Commissioners. Arthur Marcus. I'm Chair of the Historic Preservation Board, and I'm also an architect. I would prefer to have Tricia address the idea, the ideas of notice for the meeting, because we were told that the client was noticed a number of times, many times, since 2021. Nobody ever showed up at the board. We had numerous discussions, as has been mentioned, but this was not something that was meant to be done in secret. It's just we never heard anything from any representative of the owner.
Can I ask you a question?
Yes.
So let's take a look at the building. Where's the slide that shows it from the entrance? Do you have the slide that shows it from the entrance?
You mean the actual image of the property?
Yeah.
That's all I have.
That's all you have?
Yeah, that's all I have.
Okay. Well, you said the windows were replaced and the facade above the windows, the parapet, was that replaced too?
No.
The parapet was repaired when they tore out the original windows were in a different configuration.
Right.
When they tore those windows out, they had to repair it, so it's not original.
It's not original, but it's a replica of the original?
It's parts of it it was repaired, so it was patched and repaired and modified.
If I can elaborate a little bit on that.
Yeah.
When it was, the front windows were repaired, they were originally slanted to match the slant of the signboard.
Right.
And apparently, when there were hurricane issues, that owner decided to straighten out the facade. There may have been some changes to the roof line, but I find it incredulous that you can take
Whoops, sorry. Go ahead.
one element of a historic building and try and preserve it and knock down everything else.
Well,
that's like taking my arm, saving the arm, and getting rid of the rest of the body.
Well, the problem that I'm seeing here is that are we a little too late here? Because we apparently, to me, the three most significant parts about the historic aspect of this building are, number one, the sign, right? I've been passing by that sign forever, right? We all have. The slant of the windows is gone. So we didn't preserve that. And the parapet is also not really original, because I remember the parapet being a little bit different in design than it is today.
You're talking about the curving parapet?
The curving, yeah. It's a little bit different than the original design.
In what way?
It was curvier.
I don't think so.
Well,
not from historic photos.
But in any case, I'm not quite sure. See, I love historic preservation, but when we've gone so far as to dissect the original design of the building, we saw this in many places around the city where we have we've so dismantled the historic nature of a building that what are we actually preserving? Because we're not going to require them to slant the windows, and we. Okay, thank you. It's an interesting ring. That's my only concern about, in addition to the notice and all that. But I'm just saying, what are we actually preserving? The property owner wants to at least preserve the sign, and it would be great if we could see a structure like the concept drawing would be, because it maintains a certain look of that mid-century design. But okay, I just wanted to ask you, what exactly we're preserving.
Mayor, before he answers, could I just, because I was going through the Tricia's report, and what's kind of interesting on this, on page 10, there's McCarahan's original rendering.
Which exhibit are you on?
I'm on
2.
Oh gosh, hang on.
The HPB staff report.
Exhibit 4, historic designation report.
Okay, and which page?
So I'm on page 10 of 19, and what's interesting actually is McCarahan's original rendering actually has straight windows. If you look at the original design for the building, it had straight windows when it was built early on, and then there's early photo next to it is where you're seeing the slanted windows over there. So somewhere between McCarahan actually doing the design for it and it being constructed, there was apparently an early change. But it looks like the straight windows were the initial conceptual drawing.
Commissioner?
But the early photo, I see the early photo shows. The early photo shows a slanted window. So, on one hand, you can say that when they went with straight windows, they were actually restoring it to the architect's original vision.
Commissioner.
You're confusing me.
I apologize.
I think one of the things we've learned in historic preservation is that old photographs certainly tell the right story.
Right.
Original renderings from an architect are just that. They're probably iterations of different ideas, and they weren't the final as-built plan. So that doesn't mean anything.
No, but everything changes during construction. I understand. I was just pointing it out because I think it's interesting that in 2007 we went back to the architect's original concept. I find that amusing. That's all.
Well, and also I wanted to say that one of the misconceptions of historic preservation is that if renovations need to be made to a building to bring it back to being historic, let's say, for instance, we had an owner who wanted to put the slant back in the front. You can do that. I mean, it's not impossible to do things like this, but it's not an impediment for historic preservation. It's a challenge, but it's certainly not something that's going to stop historic preservation. The other point I wanted to make is that there was the original building, which is the glass fronted showroom and the signboard, and the rest of it is warehouse, which was not the original building. We would suggest that the client save and preserve the original building, do what they want with the rest of the site. Knock it down, build it up, do whatever. But the signboard cannot, if you're looking at historic preservation, it looks like a contractor took an axe to the project and just said, well, let's just save that funny form and get rid of everything else. The knee bone is connected to everything else. Everything bears relationship in architecture, so it doesn't exist solely by itself. I think one has to look at the entire composition, the entire intent of the architect, the original architect, and what their plans were for the building.
Okay. Thank you. Thank you. Abby Laughlin.
Hello, good evening, Commissioner, Vice Mayor, Commissioner, Mayor, Vice Mayor, and Commissioners. Thank you for allowing me to speak. It's certainly, I've This was originally designated November 2021. So in terms of waiting to speak, I've waited since July 5th, 2022. Then I waited till September 6th, 2022. Then October 18th, 2022. April 18th, 2023. December 5th, 2023. April 12th, 2024. December 3rd, 2024. So I have waited to speak on this property. A lot of very good comments here before, especially in regard to the Hemeshee district. It was said before that, Castro sold the building because he just wanted to make money, or, he didn't really care about the building at the time. But I would assume that a developer or someone buying this property for $7 million also just wants to make money as well with their project. I want to kind of address each of you separately because I kind of know how you feel about historic preservation and sort of appeal to your own ideas on whether this property should be preserved or not. But Ben, I know you're on you're a member of the History Center and care very much about historic preservation. Steve, you've said over the years, let's just pick 10 buildings. Can't we just pick 10 buildings and let them, represent our historic designation? Well, certainly, if this should be one of those 10 buildings. Am I at the end of my time already?
Go on. You are, but keep going.
Okay, Dean, as you just said, you love historic preservation. Pam, you know what's going on right now on Sistrunk Boulevard and how you're trying very hard to preserve your cultural legacy. This is part of the cultural legacy of mid-century modern. And finally, John, who's the numbers guy, I like, this is the perfect project for a TDR, for a transfer of development rights. I look at that rendering that they drew of, a property that's 7 or 8 stories tall. That's not what someone who built paid $7 million for this property wants to do. So I would suggest, take away whatever the calculated volume is for that sign in the showroom. Give them those additional property rights. Give them that when they go to develop. It even says in the memo today that the ULDR states that unless otherwise specified by the approving body, each designation of a landmark shall automatically include the designation of the site. So unless otherwise specified, tonight is the night to specify. Tonight is the night to make the compromises that we talked about. And in terms of their idea of just preserving the sign, I sent this up, for you. I guess you don't have the machine. This sign, this is the start of demolition by neglect right here. If they care so much about this sign, about the historic intrinsic value, they should take the time to do this repair before they come back to us and say, oh, well, it's the sign is deteriorating. So I encourage you to, this has been delayed way too long. And I encourage you to make a decision tonight. I encourage you to please preserve the legacy of Charles McCarahan, our culture, and designate the original building, not the warehouse. You have to make that distinction tonight, I think, and perhaps talk about some TDRs in the future when they need them.
Okay, thank you.
Abby, can I ask you a question?
Yes.
So, it's interesting. I'm reading through Tricia's report. Thank you, Tricia. It's very, very comprehensive. And it talks about how Mr. Castro selected McCarahan to design this and then also to design his personal residence at the same time, which I thought was kind of interesting. And I'm going to ask you to speculate here because Ms. Toothaker mentioned the 50 properties of McCarahan that we should all be paying attention to. And it talks about that 50 properties in Tricia's report. Any thought on why this one isn't in there? Can you speculate at all on that? Do
Overlooked? Maybe that it's commercial and not not a residential or a condo building. I think this is the only example of a commercial McCarahan that we have that still exists.
Okay, thank you.
But I'm all for giving them all the property rights we can, compromising and letting this property exist. Thank you.
Thank you.
Thank you. Mark Dickerman. Anyone else wish to speak on this item? Okay, Mark.
First, let me apologize for my phone, but that's a medical device that I
No
wear.
problem.
That gives me
Keep going.
warnings. So anyway, Commissioner, Mayor, Vice Mayor, Stephanie, I'm on your side on this one. I believe in historic preservation. I've done that for years. I did my studies when I saw this was coming up, and it's not historic. The building itself, because they changed it, is not historic anymore. The minute they changed the windows and changed the parapet, that changed the whole look of the building. The sign, though, I agree, should stay. It is a landmark. I also have been passing it by for 30 years. I love it. So I wanted to quote something. Bernadette Castro, which was the daughter of the owner, she was the youngest national spokesperson. And if you remember the tagline, it was so easy to open, even a child can do it. So that was great.
What can do it?
A child can do it.
A child can do it.
But
I used to have a child
and 3 degrees of separation. My mother went to school with Bernadette Castro when she was a child. So, but yeah, I'd like to see them save the big sign, the pillar. And Stephanie, you're absolutely right on this. That's one of the few times we agree. Thank you.
Okay, thank you. All right, does someone like to move to close public hearing?
Actually, I still have some questions. Stephanie,
You can have questions, but I want to close public hearing.
All right.
Someone move to close public hearing?
So moved.
Second.
Moved and seconded. Please call the roll.
Commissioner Beasley Pittman? Yes. Commissioner Sorensen?
Yes.
Commissioner Herbst?
Yes.
Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes, and public hearing is now closed. Commissioner Herbst.
Sure. Stephanie, so in the report, it talks about the original structure in 1958 and a 1959 addition to the showroom. What is that, and how does that relate to the warehouse behind it?
That is the warehouse.
That is the warehouse.
Mm-hmm.
So the warehouse. So then, if I'm reading the report right, so the warehouse was added basically the next year.
Yes, but it's been modified multiple times.
How so? Help me understand.
So
So what's been done to the warehouse?
So when it went, first of all, when it became a Ferguson's over time,
Mhm.
they've added exterior doors so that you can drop appliances on and
Right.
out. So none of that is original.
So all of what we're seeing over there on that northern corner on the left is all later addition.
There was a warehouse that was there,
Right.
but it's been modified over time with all kinds of changes to it. But predominantly where it's been broken open to allow for appliances to be delivered and removed.
Okay. So when I met with you, we talked about a couple of options for the sign, one of which you presented here tonight, which was moving it closer to the street. One of the concerns that I shared with you is we're not really looking to put monument signs along the street on Federal Highway. Let's talk a little bit about that.
That's why we again, there is no plan now.
Right.
There is
Understood.
no proposal.
Right.
But what we had suggested, if you go to the back, we looked at 2 different options.
Right.
The second one, so this was one, to pull it out so that if people want to see it driving by, but the
Mhm.
other one was to incorporate it into the structure.
So when we look at that one, so if we have that one, that looks very similar to the showroom that we have right now, where, like you said, the sign is incorporated into it. Could you maintain the existing showroom and build behind it?
No.
Kind of as you're doing? Okay, so help me understand.
No, because the showroom is in the middle of the property.
Okay. So if you were to, using Abby's example, do a TDR with this, if we were to go vertical on the back and give you more development rights back there, would that make the property viable?
No.
Okay.
No, we studied it. That's one of the reasons we asked for deferrals. We're on our 3rd architect, by the way. We did a number of studies.
Can we get a 4th one?
Yeah, right. We did a number of studies with different architects to see what if you designate the showroom in the center of the property, can the property be redeveloped? And the short answer is no, it cannot.
If you just designate the small showroom in the front,
It's not in the front. It's in the center of the property.
It's in the
That's
center
the
of the
problem.
property, right? But not the
Yeah.
rest of the property. So okay.
So it's smack dab in the middle of the property, which is what creates the problem.
I see. And so in that other rendering, you had that showroom-like structure is moved to the front of the parcel.
It's basically, it's not the same structure, but it pays
Right.
homage to the design.
Right.
Which is why we thought, so it's not the same.
Right.
It's a recreation of something that we thought would pay homage to the structure. We spent a lot of time, a lot of money with architects, settled on one that we felt really embraced the vision. But these are just concepts.
So Tricia, could you come up and just talk about this a little bit?
While she's doing that, can someone talk to us about sign ordinance? Would a sign like this be permitted under today's code to be located along Federal Highway?
No.
No. So that's a consideration. So the the compromise about putting it up to the property line is not really going to happen. Sorry.
Yeah.
Do you have a question
Did you
for
have
her?
a specific question?
You have a question for her?
So in one of those renderings, there's a suggestion of building a similar type structure closer to the roadway and incorporating the sign into the building, somewhat as it looks right now. So basically a replica of the existing building. Do you think that meets the intent
No.
of preserving? Okay, so
No.
talk to me a little bit about that.
I mean, it doesn't meet the intent for historic preservation. You want to retain the original structure, but the original structure in and of itself can be rehabilitated over time. Something that we follow regularly is the Secretary of the Interior Standards for Rehabilitation, which allows the replacement of materials, modifications in kind, slight modifications, but still retaining the overall characteristics of the original intent of the architecture. And I think the original intent of the architecture is still evident in the showroom portion of this structure. The rendering that was shown is not necessarily feasible for building on the site either, because of neighborhood compatibility requirements and inter-district corridor requirements.
Okay. Do you have any thoughts on why this might not have wound up in that top 50 of McCarahan?
I'm not entirely sure, but it's a group of students that put it together that are in Gainesville, and so they may not be highly familiar with the area or the resources that we have.
It was a grad school project?
I believe so.
Okay.
From the
It
school.
was a senior class project. This is what they had to do to graduate. All right, got it. Okay.
Community service.
And a short time frame in which to develop.
Okay. All right. Thank you.
Okay, thank you. Any other questions? Any other
I do have a
comments?
question actually of Stephanie and Tricia also at the same time perhaps. So I really just am curious because we've done this before with historic structures. We've actually moved structures. Has there been any thought about not just the signage but also at least the cantilevered front and then anything else moving closer to Federal Highway,
So we
just so
did-
that we get a little bit more sense of
We did
building?
some structural surveys on it, and it's not in good shape. And they did not think that it could be moved.
Okay. No part of it could be moved.
They didn't think it would survive. The sign they felt was structurally sound and could be protected and picked up and moved, but they did not feel that they felt the lip. I mean, we can try, but I don't want to designate it because then if you've ever been to HPB, you're not winning the argument of, I want a certificate of appropriateness. You're not winning that argument. So I don't think from a redevelopment perspective, and again, the designs that we showed were just designs. They were concepts to show what could be done, and they actually did follow the land development code. So you still have to deal with neighborhood compatibility, of course, but from a ULDR perspective, those comply with the ULDR. But moving it, I think, would be very difficult from what I'm told.
So what would be your suggestion in terms of, we're hearing now that all of a sudden maybe the sign coming closer to Federal Highway,
We would just ask that so similar to what we did with Pier 66. So Pier 66, the interiors and the base of Pier 66 are not original. So what we did is we requested a very specific survey that protected the exterior shell of Pier 66. After we made the renovations, if you recall, because there were significant renovations that needed to be done as a result of a storm. After we made the renovations, we designated the shell of Pier 66 historic. We did that. We applied for that application, and we took it to the commission, and the commission approved it. We are saying here we would like to do this, not the same thing, but something very similar, which is that I sent surveyors out, so I've already requested a survey. I'm sorry, I am so cold I can barely speak. I requested surveyors to go out, and they are taking a physical, actual, in-place survey of the sign with the structure going all the way to the ground. And the concept is that would be completely designated historic, voluntarily, not involuntarily, way this has gone forward, and if we would commit to doing that, we bring it back, or we could just agree to do it tonight with the survey as a follow-up, but with the ability to move it because it's in the center of the site.
So again, because we're used to deferrals on this issue and other issues that come before us all the time with regards to historic preservation, I'm not totally satisfied with just that sign, and then hearing that might be an issue moving that sign all the way to Federal Highway from what Trish said in terms of neighborhood compatibility and other uses. I'm actually going to say that I think we have to defer this because I really would love to see you and
Vice
staff.
Mayor, I don't mean to interrupt. I'm sorry.
No problem.
Go ahead.
Go ahead.
We're never going to be okay with designating the lip. Ever. I can tell you every study that we did with the 3 architects we had, it doesn't work. It's in the dead center of the site. And what we were trying to do is find a happy medium. I've been told by the people that have studied the sign that it can be moved. The neighborhood compatibility that Trish was referring to is only, she was just saying, I don't like your concept of a building. We don't even have a proposal. I was trying to show some concepts that would pay homage to something, but those again, they're just mock-ups. They're not actual plans.
So again, so you think there's nothing that we can still gain by further discussion in terms of what might be just a little bit more in terms of what we would be designated? And I'm only asking this, by the way, Mayor, you mentioned some things that are significant, but also the fact that the site was cash flow convertible. That is also, the site itself, there's a significance there. And also, obviously, McKirahan. But so you don't think there's anything to gain by further discussions or what we could possibly do or on this site what we could develop? And I want to be very sensitive to the redevelopment issue. I know your clients paid a lot of money for this. I think we have to be sensitive to the redevelopment possibilities of what can happen on this site. But I just am trying to think we need to have a little bit more. I'm just thinking, is there anything that we could still do to get a little bit more out of this in terms of what we're going to designate or what we're going to do?
I think the issue is the location on the site. So I'm happy to defer it. I'm happy to come back if that's what you're asking. But I want you to know that we did spend a lot of time and a lot of money studying it. And the problem is that the roof line that you're looking at is in the dead center of the site, and it's also been altered. Where it is in location, you could not redevelop the site if you designate that roof line.
Honestly, the only cool part to this is the sign.
Well, actually, no, Mayor, the roof line.
Mayor, I still have the floor.
I know.
Mayor,
I'm interrupting you.
Well, everyone's interrupting. It seems to be okay when other people do it. But thank you. So, Stephanie, what exactly are you suggesting that we designate?
The sign.
Just the sign.
Just the sign.
Just the sign. Okay.
With all of the original structures that come with the sign, it's all the way to the top and it comes all the way
to the ground.
And it would not be permitted under the sign code, but we wouldn't have to use it as a sign. It could be an architectural features, which is what we showed in which is why we're showing where it sits. I mean, I guess we could leave it where it is, but then it's lost inside a future building. That's really the issue. I think we were saying if we want to designate it and make it special, like we did with the rain tree, why don't we move it out where people can actually enjoy it? If they care so much about it, we're willing to do that. It's not an inexpensive venture to do that, but we thought that would be something positive, not a negative. We could designate it in place and just try to build around it, but it would get lost in a development. Again, if Ferguson's goes away, which is a possibility. It's got 4 years left on the lease.
4 years left. Okay, well,
Yeah.
thank you. Thank you, Mayor. I'm good. Thanks.
With that designation, is there an opportunity to put a marker?
Absolutely.
So
yes,
it's an opportunity to also move it and then put an actual marker.
That's a fantastic idea. Absolutely, yes.
All right. Well, public hearing has been closed. Would someone like to?
Actually, no. I'm still not done, Mayor.
Oh, I'm sorry. Go ahead.
No, that's okay. I was actually going to say something before I was going to agree with the vice mayor, but now I might have to reconsider my position because he cut me off. I don't know. But no, going back, Stephanie. So when we look at that, to your point, it's in the center of the site.
Right.
It seems to me, and I'm not an architect and I don't play one on TV, that you could design a building that wraps around that and incorporate that showroom in the front as the entryway to whatever structure it is you're going to do. Because one of the things, Mayor, to your point, as I was going to kind of chime in on, is that cantilevered roof is an integral part of the McCarahan design. It's part of what makes it distinctive. And I know I've had this conversation with Stephanie about the roof, and we talked about that with her client. You know, their concern is that it might not be structurally sound. I don't know. But I'm just wondering, as we look at that site, if it's possible to do something that just wraps around the existing showroom portion, keeps that maybe as the entryway into a much larger, more grand structure. We do this all the time.
Well,
right?
we did that on the beach with
Right.
the Lauderdale Beach
I
Hotel.
was just
Yeah.
right. We did that. We did that with the Hilton. So we've done this many times. You see this in New York, all up and down, Fifth Avenue. You see it down in South Beach, where original structures are maintained, the facade is maintained, and then you've got a much larger structure that's built around it. Is that something that could work here, where we could wrap around the existing showroom, keep that structure in place, but yet allow you to build more dense and profitable, hopefully?
I think the problem is that it's in the center of the site. So I think that's such a great idea if it was out on Federal Highway, but it's not. It's smack dab in the middle of the site.
Well, that's why I'm thinking wrap around it completely. So,
But you would never see it. What do you designate?
Well, as the entryway. So you have if you go back,
you would lose all that. You would lose
go
that
back
entire entrance. Look, I just want to show.
Right.
Look how far back it is.
But if it's
So you wouldn't
incorporated
be
as
able to develop the entire front of the site.
But
so
if it's
go back to the overhead rendering, if you would, please. I'm sorry. Where you have all right. So go to your next one where you had your potential building, right?
That's the outline of where the building is permitted.
Go back to your last one. Just go back a slide or two. So all right. So there you go. All right. So if you took everything behind it and then pulled that building more to the front on the left side, in other words, basically make an L-shaped building around that little bitty showroom right in the middle. That doesn't work as an entryway?
It does not. We did a study. We tried that.
Okay.
We did an architectural study, and it did not work. You can't make the parking work because if you were to park, looking at it as a multifamily.
Right, that's what I'm thinking it's going to be. This is not going to be a commercial project.
It will
it's
not
going
be
to be a multifamily.
Right. You can't make the parking work from an engineering standpoint.
I think you need better architects. If they can't make that site work as a multifamily wrapping around that, they're not trying hard enough.
Why don't we defer this? I think I think we need more discussion and perhaps more thinking about this.
This is
Stephanie has even recommended we maybe defer this. So based on, we need to talk about this a little bit more. All right.
So Mayor, this is in my district, and I just want to say I'm really torn on this one because I drive past that all the time.
I know you are,
and I think it's a stunning structure, and I despite some of the things I say, I do like historic preservation, and I think when we can do adaptive reuse, it works. But at the same time, as I've said earlier, and I've said to Stephanie and her client, I'm also a fierce advocate for property rights. So I'm hoping there's a win-win in here somewhere.
We thought we had it.
Well, so the problem, Stephanie, though, is just moving the sign doesn't get us there. You know, I think we can do more than just move the sign. I'd like to hope we can do more than just move the sign.
So why don't you move to defer, and we can study this a little bit further.
I will do that then. Move to defer.
Okay. Do I hear a second?
Second.
Been moved and seconded. Any further questions or comments? Please call the roll.
Is there?
Are we do?
Go ahead, David.
Date certain? Is there a date certain you want to move?
No
to
date
defer?
certain.
Within the year.
Before the end of Ferguson's lease.
Yeah, they have 4 years left on the lease.
We got 4 years to get it done.
So Dwayne, if we don't pick a date certain, we'll just have to re-advertise?
That's correct.
Okay. Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst?
Yes.
Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes, and the item has been deferred to an indefinite time. PH2, this is a public hearing, quasi-judicial resolution approving the historic designation of a historic landmark of the property commonly known as the Frank Coisant House, located at 1313 South Andrews Avenue. Anyone wishing to speak must be sworn in. The commission will announce any site visits, communications, or expert opinions received and make them a part of the record. Commissioner Herbst, do you have any disclosures?
No disclosures other than I don't think we should do 3 historic preservation things on one night. That's all.
Commissioner Beasley Pittman?
No disclosures.
I have none either. Vice Mayor?
I had a conversation with Michaela Conca from the Broward Trust for Historical Preservation.
Okay. And Commissioner Sorensen?
Yes, the applicant. I think that's it. Nice.
Okay. Mayor, before you proceed, during the meeting, I was informed that this application was deemed complete by staff on December 6th of 2024, and so the 180-day time period counts from that time period. So you can defer this item within that 180-day window with unilaterally.
We can still fit within the 180-day window because Commissioner Sorensen, you would ask that this be deferred.
Correct.
So, Ira, you're here on behalf of the property owner? This is Ira Marcus, who signed up to speak on behalf of 1313 South Andrews Avenue. Hello, Ira.
Mayor, Vice Mayor, Commissioners, my name is Ira Marcus. I've been the proud placeholder of this building for the past 20-some-odd years. I would ask you not to defer consideration of what's before you today or tonight, for the reason that there was a hearing before the Historic Preservation Board that was approved and recommended to the Commission to designate this property. Nothing will be gained by deferring this matter.
So you're the property owner and you want it designated historic?
Absolutely.
Okay. Okay.
And I don't know if it's the time for me to substantively speak on it, but this is a no-brainer for this commission. If there's one property in the city, other than perhaps, the Needham Estate or the firehouse or whatever, this is probably the most prominent, iconic historic building in Fort Lauderdale.
Okay.
Ira, let me ask you this. I'm confused because you and I have been working on this, and then I heard today there's another. Is there another property owner? I'm confused. What's
no? So
okay.
It's a little confusing, and Commissioner Glassman, I'd like to address that point. This property was built in 1925, and Francis Abrea designed it. It's had certain iterations, but it's always maintained its historic structure and significance. Some years later, the property to the north was developed by the husband and wife lawyer team that owned the current building at 1313. They developed the building at 1301 South Federal Highway, South Andrews Avenue. When they developed that, they did not have enough parking space on their footprint. So since it was the same owner who developed the property immediately to the north, they decided to create a condominium concept so that they could use both parking lots to satisfy their zoning parking requirements for the building to the north. That's why there is a condominium association. Our building is independent from their building. We could sell it. We could do whatever we want to it right now. They can't, the condominium association can't tell us we can't sell it. They can't tell us what we could do with it or can't do with it. We have as part of this process, we were requested to and had our own survey that shows that the independent boundaries of our parcel. So that's the sort of confusion when you designate or characterize it as a split property. The significance that the Commission needs to recognize is its own historic designation ordinance. And if you look at it and you apply the language, which I respectfully suggest you're compelled to do, and that the only issue before this commission is whether or not it meets the criteria, number one, and a bigger picture is whether or not this city has the desire to maintain some historic value to this community. And if you look at the ULDR applicable ordinance, section 47.24.11 C7, and you read it, and from a legal perspective, Mayor, if you look at an ordinance, you apply the words pursuant to their common usage. There's no commission interpretation. And in order for this building to qualify, it is the value of the significant reminder of a cultural or architectural heritage of the city. Quote, the building, site, structure, or group of buildings has significant architectural or aesthetic significance if it has the following attributes. A, the value of the building is recognized for the quality of its architecture and sufficient elements showing its architectural significance. The staff, the HPB, has given you a report that says that this building has that. The next thing, its distinguishing characteristics of an architectural style refers to the building, not the site. It also talks about utilizing the historic designation application and following instructions from the city's own website outlined to apply for the historic designation of an individual structure. So this building deserves historic designation because otherwise, for sure, it will be knocked down and it will forever be gone. And one of the significance of this building is not the absolutely exquisite architectural detail of Mediterranean revival of Francis Abrea. But it was also Frank Crossan's house, who was a significant developer in the early 20s. And it's because it was Frank Crossan's house, combined with Francis Abrea's exquisite architecture, that it also qualifies for national historic designation. It would be a travesty if this city and this commission turns its back on this iconic gem of this architecture for that period. So I would urge you and beg you to follow the staff's report and recommendations, recognize that this is a no-brainer. If there's one of a handful of buildings in the city that should be preserved, you all should be proud to preserve this. So I would beg you not to defer this, decide tonight, and I would leave that designation and that consideration for your good judgment.
Thank you. Alberto Casaveto.
Thank you, Mayor, Vice Mayor, and Commissioners. My name is Alberto Casaveto. I am here as a resident of Fort Lauderdale. I own many properties in the city. And I'm also here representing Alira LTD, which we also own, which is one of the condo owners of Croissant Place Condo. And I'm asking for a deferral to better understand what exactly the historical designation will mean to the condo association. It's really not that clear to me. I just saw the sign up on the grass, and then I decided to come here. The Historical Preservation Society never reached out to me, so I'm right there in the condo association with Mr. Marcus.
Explain to me the name of the corporation. What is the name of the corporation?
It's Croissant Place Condo Association.
Okay, now my understanding is that the record title owner is 1313 South Andrews Corporation.
Yeah, that's so the property 1313 is in between the property for the condo association, which is the two parking lots, and then there's another 3-story structure, okay, which is where I have a dialysis clinic because I'm a nephrologist. We have that on the corner, and there's another lawyer there. So there's two other condo association members. And I think Mr. Marcus is correct in the sense that the property ownership is individualized, meaning 1313 and the 1301, but all the parking areas are shared, and my concern is on the value of the overall property if there's a historical designation, and I don't understand that part of it, and I haven't spoken to the historical board.
So I just want to understand the ownership here. So 1313 South Andrews Corporation owns the building in question, correct?
Correct.
All right, but it's part of an HOA for businesses that have common elements, including the parking area. In other words, your corporation or the condo association, does the condo association own this corporation?
I do not think so, and I think they can correct that, but I do not think so.
Okay, so the only owner of this building is the corporation 1313 South Andrews Corporation. And you own adjacent properties, which you call it a condo association.
So we're there. The 1313 is in a condo association with Alira LTD and Benson Holdings. And so we have a condo association. We meet regularly. This is where I found out about the historical designation.
But a condo association, I know a little bit about Florida real estate,
Yep.
so let me see if I can understand what you're saying. A condo association is a form of ownership in which a declaration of condominium is created and a legal description is attached to the condo association indicating what the association owns.
Mhm.
Are you saying that this condo association owns 1313 South Andrews Avenue?
I do not think that's correct.
Okay, so it's not a condo association as is normally understood. Mr. Marcus, I think I need you to come up here again, since we speak the same language. Help me out here.
Okay. You're absolutely correct. The two buildings, 1301, which is Dr. Casaretta's building, of which he is a member of the condo association, along with the Benson law firm, who also occupies the 1301 building. They are a member, an individual entity member of the condo association and our corporation. The ownership of the building in question is owned by my company, 1313 South Andrews Corp. We could do what we want with it. We could sell it. Today we could knock it down.
Well, how is a condo association? How does a condo association concept? How does that relate to the ownership of your building?
Doesn't. The only thing that it does or did was for the parking. And as a result of that...
So the parking is a common element of the condo association?
Correct.
Not the building. The building is not part of the condo association?
Correct. Well, no. The building is part of the condo association.
It cannot be. So don't confuse me. It cannot be part of the condo association unless the Declaration of Condominium describes it as part of the common elements of the condo association. You can't own it individually and also have the condo association own it. It's impossible.
No,
you can't have two owners.
I'm not a real estate lawyer.
I am, and I'm telling you, Mr. Dunkel, would you help me out here? I agree with what you're saying, Mayor. Okay. So help me out here.
Trust me.
Because I don't know if you're the party in interest to agree to an historical designation.
That's why the Broward Trust brought the application.
No. You cannot agree to something because you don't have the authority to agree if you're only a unit owner in a condominium association. You have to have the majority of the members of the condominium association to agree to something so that representation can be made that the owner of the building agrees to the historic designation. If you're just one member and there are three members and those other two disagree with you, you can't come here and say that you own it and you represent the owners and you are in agreement that it should be historically designated.
With great respect.
Yes, sir.
As you know for years that I've had for you, Tricia, I will let Tricia speak to that point. Because
Tricia? Yes.
Yes, please. So in April of 24, Mr. Marcus and their ownership came to the condo association meeting and asked us to sign a resolution that would allow their building to be a historic designation. And that resolution did not pass because the other two condo association members voted against that. And then he told me that it didn't matter what I said because the city was going to designate that building no matter what.
Let me ask you something, sir. Can you come back to the microphone?
Yes.
Can you repeat to me what the name of your condo association is?
It's Croissant Place Condominium.
Okay. And within the legal description of the association, does that include 1313 South Andrews Avenue?
Honestly, I'm not sure.
Okay.
I mean, I think he explained that answer better than me.
Okay, Tricia, do you want to add to this conversation? You want to add to this confusion?
Sure. So in the Historic Preservation Ordinance for historic designation, there's several options of who can initiate a designation application. One is the City Commission by motion, Historic Preservation Board by motion. It could be a property owner. If it's the property owner and they're a condo, you're correct. It would need to be a simple majority of the condominium association. And then there's also another option, which would be a nonprofit organization with a vested interest in historic preservation. And in this case, the application was filed by the Broward Trust for Historic Preservation.
But we're trying to determine, and we get that part.
Okay.
That's the easy part. We're trying to find out who owns the property.
So,
and I don't know. Do you know who owns the property?
So it is a condo association that that is formed by the two structures on the site. The structure to the north is a 3-story building and has several unit owners in it. I think there's 5 total, but it's just 2 or 3 separate parties. And then 1313 South Andrews, which is Mr. Marcus's building, is owned separately by a corporation that he has 2 other partners with.
He has 2 other partners with.
Correct.
Okay. And is that part of the condominium association?
I don't believe it's part of the common area of the condominium association, but they are a condo.
That doesn't. What you said just doesn't make any sense.
Well,
you said they're not part of a condominium association, but they're a condo. So what does that mean?
The common area of the
like
condominium.
the driveway and the front lawn and all that. That's part. That's part. It's like, is it like a homeowners association where they agree to share common elements, but they are independently owned?
Yes, I believe so.
Well, I don't want. All right, so
we need facts.
Come on, can you help out here, Dwayne?
I cannot, but I would also request a deferral, not because of the improperness of the application. They've correctly identified that the application has been brought forward by the Historic Trust, but what was indicated by the unit owner was that the application had a specific legal description that identified the building. I don't find that in the packet. What I do find is a legal description in the survey for lots 7 and 8, which I think is the issue here. If I do believe, and I'm seeing in the record, that there is this condo association and that there are individual units, but I do not know what those units are, and I don't think the application is clear as to which unit they're seeking to designate as historic under this application. I believe the building may be one of these units in this condo structure, but I'd like for our real estate attorneys to actually look at it and determine whether or not we are correctly identifying the structure that is seeking designation.
Mayor, could I weigh in for 1 second?
Yeah.
So,
Go ahead.
so what I've heard from almost everybody involved in this conversation so far is, I believe. Okay? So we have I believe, and I believe. And we don't have any facts.
No, I know.
We have a lot of I believe.
I know. If I'm not sure what package you're looking at, but when we submitted, or when the Broward Trust submitted the application, there was, in fact, a separate survey. I could hand it up to you.
I'm looking at that same survey. It says lot 7 and 8.
Also, if you look at
I think that the dwelling, that the house, that the office you converted to is meritorious of historic designation. I don't want anyone to misunderstand my intentions here. I think we've all passed by that building many times. It's gorgeous. You've restored it nicely. Thank you very much for doing that. But I just want to know if the owner is consenting to the historic designation, and we can't know that until we know who the owner is.
I'm the owner. My company is the owner of the building. And by the way,
I'm hearing conflicting evidence on that.
Well, maybe I could give you some of the best evidence.
Okay.
For the past 20 years, my building, not the condo association, not the 1301 building, has been the beneficiary of a tax incentive by the county. We've been paying 50% less taxes. So that, to me, is an official recognition and designation that my building, separate and apart from the condominium association, is worthy of that recognition because it is what it is. So I think that and I understand your concern, but if you think about our due process rights to have the right to alienate our property and the right to preserve it.
Who's our?
My company that owns this property.
But who is it? Who's in your company?
I have two partners that there are three shareholders in our corporation.
Not including these gentlemen.
No. We're a separate entity.
Yeah. Okay.
Okay.
But you're a condominium.
No, we're not a condominium.
Well, wait a minute. I'm getting confused here. I thought he said you're part of a condominium.
Well, my entity,
Is
which
a corporation.
owns this building, the building is part of a condominium structure for the sole purpose of sharing the common parking lots. They don't mow our lawn. They don't preserve our building. We fix our own roof.
Okay, so all right. So now what you're telling me is a little bit different than what I was told earlier. Okay? So now it's like a homeowners association, only for businesses. You have fee simple title to your building, okay, and they have fee simple title to their buildings.
Correct.
And the only thing you share is the expense and the maintenance for the driveway and the pathways.
Absolutely. And
That's
parking.
it. That's it.
Right.
You don't need their permission. You don't need the condo permission to make any changes to the building.
Nope.
You don't need any. There's no. Is there a monthly maintenance charge?
We have a budget for maintaining
The driveway.
the driveway,
And
the parking lots.
Okay, but the condominium. So the corporation is a member of the condominium, but only for the limited purpose of those pathways in the parking lot.
Right.
Okay, that's all. That's what I thought I was asking from the beginning, and I kept getting different answers.
I'm not that smart. What do you
Yes, you are. So if that's the case, do we have a corporate resolution from your corporation agreeing to the designation?
I think we did. I can't remember, but
It's helpful to know that, because that's how we know that the corporation agrees to it.
Sure. When just by way of history, I'm not sure the commission knows this, my entity, 1313 South Andrews Corp., made its initial application. And we did everything. We fulfilled all the requirements, and then we went to the condo association, and Dr. Casaretas was concerned about the value of his property, his building. And so we couldn't get approval for our application because they wouldn't agree. So then we went back to Tricia, who then got involved with Michaela, and they said, okay, fine. So we withdrew our application, and the Broward Trust then made its application that we did not need their approval to proceed to get designation.
So from what you're telling me, I agree with you. You don't need their approval, and I don't see how it impacts them at all if it's designated historic, because it has nothing to do with the adjacent properties. Right. You can dissolve the condominium tomorrow if you wanted to.
Yeah.
And it doesn't impact them one way or the other.
No, it doesn't. And their parking would be preserved. We offered to give them a covenant running with the land for designated parking. None of that bothers them. They're just, the whole thing here is Dr. Casareto says, oh, maybe one day we'll join together and knock down the buildings and build another building. I want to preserve the building.
I understand. Yes, doctor. Yes, doctor.
So I find it interesting that he tried to do an application for historic preservation, and he was not able to because he couldn't get the condo association to agree with him. And so then he found a different way of doing the historic preservation. I don't know much about all this stuff, but I find it interesting that, he's an attorney, so he can find his way around to get things done. Okay, but so I find that quite interesting.
But doctor, I don't think the condo association has any involvement with a building that is not part of the association. The building itself is not part of the association. It's just
And honestly, I'm not aware of that situation. I'm not clear, and that's why I want a deferral. I understand the historical significance of the building, but I don't understand, okay, what the condo association gets affected by this designation. Okay, the Historical Society didn't talk to us. Talking to Marcus, didn't really get any answers. He gets very defensive. And so we are in an impasse. I'm not sure what that means. And so, therefore, I am here to defer this to the next meeting so I can get some answers.
Okay.
Can I just ask a question?
Go ahead. I'm concluding my comments.
If you don't mind. Sure. So what are the questions that you have? I know that you said you need answers, but to what questions?
Well, I think that it's not clear. It is very apparent to me here. It's not clear whether the property is in the condo association or not, and whether you need the owner to agree to the historical designation.
Well, actually, according to our ordinance, you do not need the owner. I can tell you that.
Correct.
According to our ordinance, you just don't. But I just was wondering, are those the only questions that you had?
No, I'm a little concerned if the building, so the envelope of the building, which part of it is historically designated, how does that affect the two parking situations? If the other building were to be developed, what happens to those parking sites with the building that's designated in the middle? So I'm a little concerned about that. What does that mean to the building? I don't know the answer to that.
That's a good question. So are we going to, so Dwayne or Bob or whoever, if we defer this for 2 weeks, what's our next meeting? March 1st? March 3rd? 4th?
4th.
March 4th. So if we defer this to March 4th, are we going to be able to get these legal answers that he needs? And
we should be.
And do they even impact the application?
So technically they don't impact the application, but they impact the actual designation. So there is a legal description. It's a, lot 7 and 8 and portion of lot 9. And I just want to make sure when the commission designates, because it looks like you're looking at designating the building and not necessarily the parking lot, I want to make sure that you designate what you're intending to designate and not a broader
Does the application now include the parking lot for designation or just the structure? So why is Dwayne unclear on whether we're going to be designating the parking lot?
Can I just say something? Not to screw this up anymore, but the legal description on the property appraiser's website shows that the owner of the property is 1313 South Andrews Court. But then it goes. Then the legal description says Croissant Place Office Building Condo Unit A Building.
Yes, we have one portfolio number for tax purposes. Oh, sorry.
I think we need to defer this, and I think Mr. Dunkel needs to help us out on this.
Yeah. But I'm hoping that we can have these answers in 2 weeks.
Yeah, it shouldn't take long. Mr. Dunkel.
This does come down low enough.
Yes.
I agree. I think we really need to take a look at the Declaration of Condominium, pull it apart. There may be elements in the Declaration of Condominium that impact this that we're not even aware of. I feel very uncomfortable with the give and take of the verbal. I like what you just saw. It seems like it is one of the condominium units. Give us a chance to go ahead and look at those.
Can we defer this for 2 weeks? Someone
Moved.
Okay. Do I hear a second? We're going to
Second.
Hold on. No, hang on.
Second.
Okay. We're going to defer this for a couple of weeks. Isn't that what you wanted?
I'm not here in 2 weeks if it's 4.
No.
You guys decide.
What's the pleasure of the moving party?
Are you all right for 4 weeks, or as opposed to 2 weeks?
What's the 4th week?
4th week.
3rd week.
18th of March.
So I'm having surgery in Baltimore.
18th of March. Okay, doctor, where are you the 4th? You're out of town or something?
Is there anyone else from the condo association?
Out of the country.
Okay, can you have someone
Is there
else
anyone from the
represent you?
condo association that could appear on your behalf? Do you have an?
Yes.
Not that's eloquent like me.
All right, I think we got to go with the 4th.
Okay,
Yes.
we'll go with the 4th.
Without the doctor, but
March 4th.
yeah.
Okay. Mr. Clerk, please call the roll.
Commissioner Beasley Pittman.
We're going to defer this for 2 weeks.
If one of the parties is not available, is that really fair to both parties?
Well, we don't know if one of the parties. We don't know who the parties are. The whole idea is to determine who owns this building.
Or you could aim for April 1st, which is the next. I don't know if you both are in town then.
Well,
or available.
you're having surgery. I don't know if you're going to.
No, I'm pushing to April 1st. Are you around then?
I'll be fine.
All right.
Okay.
It's just a lobotomy.
April 1st? All right.
Yes.
I'll amend my.
Please, with the amendment, please.
Ira's good with April 1st. It's April Fool's Day. It's wonderful. It'll be great. All right. So I'm amending my motion, Mr. Clerk, to
April 1st.
defer to April 1st, 2025.
And Vice Mayor, do you accept that as the second?
I just want to make sure that's agreeable for both of these gentlemen.
Yes, for me.
Yes, thank you.
I'm fine with amending it to April 1st.
Thank you.
You didn't sign up to speak, but if you'd like to sign up, if you'd like to speak, come on up here before we vote.
You've been very quiet all evening.
Well, you have to sign up to speak, Michaela.
I honestly didn't think I had to because it was my application.
Everyone who has to speak must sign up because they're sworn in, and so yes.
Thank you all for your time and consideration.
Thank you, Ira. See you in the neighborhood.
Yes, Michaela.
So my only question is, Broward Trust for Historic Preservation made application for this, and it seems like we aren't being questioned, or do we have an opinion about whether or not this is deferred? I'm trying to understand that part of it.
What's your objection to the deferral?
Why we're not being asked?
I'm asking you. We're asking you. What's your objection to the deferral?
I want to understand the process as well, Dean. I want it to be clear that the property, and I did ask the city attorney, I want to understand what it is what you all want to be clear about in terms of the ownership. Are we talking about the dirt, the parking lot, or the structure? That's what I'd like to know.
That is exactly what I'd like to know.
That's exactly what you want to know.
That's exactly what I'd like to know. What are we designating?
So
the building, the dirt, the parking lot. And if it's the building, I need to have the legal description for just the building. What we have is a legal description for some lots that I don't know what is on those lots. And when I look at the Broward County Property Appraiser's folio for the ownership of 1313, it refers to Unit A of Building 1. So that can be like a small office within it. I don't know what that is.
Okay.
So if that's clear, we're deferring so I can actually get a legal description. We're going to have our real estate attorneys take a look at it so that our board has a clear picture of what they're designating.
Okay, I've been to the property, so
I've been to the property
it's there.
Too. We know it exists,
This is the problem.
and we know that the designation has great merit, but we just want to know that since we're designating it, we need to know whether or not the owner approves it. That's all, and we don't know who the owner is.
Okay, I understand that. I think also for future reference, so that Broward Trust doesn't find itself in a position like this again, that deferring it at this point is probably a good idea. So that I understand, should we ever be presented with something like this again, we don't find us in this predicament.
I fully understand, and I appreciate your patience.
So thank
I appreciate
you,
your patience. Thank you.
And thank you, Commissioner.
And thank you for the
Vice Mayor.
application. This is a magnificent structure, so thank you. And thank you, Mr. Marcus, for preserving this building. It's an absolutely stunning building. Thank you.
And that is, it's 2025. The building was built in 1925. It is celebrating its 100 years this year.
Happy birthday.
So is the mayor. Thank you. Thank you.
We share a birthday.
Thank you. Thank you.
Did we vote on this?
No, we haven't voted
not
yet.
voted
And
on it.
I have a concern. I understand that there is ordinances and even state legislation in place regarding this. But what I can't wrap my mind around, when the Broward, I'm sorry, not getting the correct name for your association,
Broward
but that
Trust for Historic
Broward
Preservation.
Trust. When you identify a building that you want to designate, is there a reason why the owner is not being notified?
Well, who's the owner?
Who's the owner? That's what we've been trying to hear all day. Who is the owner?
Thank you.
Go ahead and ask the question again, Commissioner, if you would, please.
What I've been hearing, it doesn't appear that the owners, once you make an application, in that process, is the designated recognized owner notified of your application?
Well, in this case, I worked with who I understood to be the owner of the property. So he was in support of this application.
Okay.
Okay.
All right. Thank you.
And when the trust makes an application for historic designation, we do hope to usually, in most cases, try to have owner's approval.
You said hope?
In most cases, yes, that's the hope, to have owner's approval.
May I, Commissioner?
It's not always, but I do make it my point to try to get the owners involved.
Commissioner, if I may, just for the record, letters went out to both my company and to Dr. Casaretto's company of the Broward of the hearing before the Broward Preservation Board.
Historic Preservation
Board. There was a sign posted on Dr.
I'm sorry, sir. My question was the process when the application begins.
Yeah.
Because my question is, what I'm hearing, even back to the other items that we had, don't wave me off, please. I'm sorry.
No, I was.
Oh, okay. I'm sorry. I've been dismissed all night tonight, and I'm kind of getting disturbed with that.
I apologize.
Okay, all right. But my question is, with this process, understanding that the Broward Trust has that ability to place that application, my question, when you place that application, are you doing all your due diligence to make sure that property owner knows what you're doing? Because my concern, the home that I live in, it can be declared historic. And maybe I don't want that. And I don't want to come up here one day and see on the agenda my home is on the dais for the agenda to discuss being designated. There's a process, and I don't think we need to leave the owners out of it. I respect the process for preserving and having historic buildings designated, but we cannot leave out the homeowner or the property owner.
So I could give you a sense of comfort. When my company first made the application, we went to Dr. Casaretto and the other members of the Condo Association and said, this is what we're doing, and would you agree? They were involved in the process from day one. We are the owner of the, quote, building, end quote, that's being designated.
But if you're the owner, why do you have to ask anyone else?
Because we're part of a condominium association, and there's certain rights and duties and obligations that bind us. Okay. So we went through that process. When they refused to give us the approval, we then withdrew our application, and the Broward Trust then made the application. Okay. Again, it's the building that we're seeking designated, not the parking lot, nothing else.
Point taken. Point taken.
So, Commissioner
Beasley, no. Can I share just a brief story with you?
I'm done.
Go ahead.
Recently, I met with the owner of a building over in Central Beach. It's an iconic building. It's a mid-century modern building. I sat down and had a very long conversation with this gentleman. It's my understanding that he's been in negotiations with a developer, and he chooses to believe the developer is promising him that he will maintain that structure. He's going to renovate it, do whatever he can to keep it. And I tried to help him understand the importance of the historic designation, how that historic designation would save his property that he feels very strongly about. And at the end of our conversations, he made, even after all my rebuttals, even after all my education, every point I tried to make to help him understand that that designation would be to his benefit, he still said to me, I have no interest in designating my property. And I said, fine. I'm not here to try to sell you on something that you clearly do not want. We shook hands and went our separate ways. So it doesn't always go the way the trust would like it to go. You win some, you lose some.
All right. Thank you, Michaela. Okay, so are we on first base, second base? Did we take a vote to defer?
Not yet.
Okay, let's vote to defer.
I have to call roll.
Let's call the roll.
That's deferral for
This
April
is defer
1st.
to April
Till
1st.
April 1st.
Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst? Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes, and the item is deferred to April 1st. So did we defer all the historic designation issues?
3 for 3.
Okay. PH3, this is a public hearing, quasi-judicial resolution approving a waiver of limitations at 1180 North Federal Highway. This is Unit 1410, Slip 16, for the installation of one 16,000-pound and four-post boat lift extending a maximum of 32.7 feet. Anyone wishing to speak must be sworn in, and the Commission will announce any site visits, communications, or expert opinions received and make them a part of the record. Commissioner Herbst, do you have any disclosures? Commissioner Beasley Pittman?
None.
I have none. Vice Mayor?
I believe that I had a conversation with Romney Rogers on this.
No, you did not. This
Was
is
that another one?
This is Riva.
Okay. This is Riva?
Yeah.
None.
Okay.
Thank you.
Commissioner Sorensen?
None.
Okay. We have one person who signed up to speak, Nicholas Diorio. Is Nicholas here? Just for questions? You signed up for PH3. You meant PH4, didn't you? Yeah, okay. Okay. All right, very good. All right. Anyone else wish to speak on PH3 with regard to the boat lift? Okay. There being none, someone please move to close the public hearing.
Moved.
Do I hear a second?
Second.
Moved and seconded. Please call the roll.
Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst? Yes. Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes, and public hearing on PH3 is now closed. Would someone like to introduce the resolution?
Introduced.
So I just have some questions, but yeah.
Go ahead.
Go. Okay, so what is the reason for seeking the waiver? Who can answer that? Is anyone here? Is the applicant here? Or?
I believe it's because you can go no more than 25 feet.
Right. So I want to understand, why do they want to go more than 25 feet?
Because you got a big boat.
Yeah, which is, in my mind, I hear you, is like not a good enough excuse.
We've done lots of these at this building.
Yeah, like.
Good evening, Mr. Mayor, Commissioners.
Yes, sir.
My name is Stephen Garbett with Boat Lifts and Docks. The reason we're asking for the waiver is because it's in a condo, and we have done 7 boat lifts there, and we have gotten permission to go beyond the 25-foot setbacks.
And what's why do you want to go beyond 25-foot setback?
Because of the way the shape of the dock is, it's too close for the boats to get in. So we have to move the boat lift a little further out so that they can park.
So if the waiver is not granted, you can't put any size boat there?
They would have to back in, and there's a lot of current there. And it would be very, very difficult because the slips are very narrow. So that's the reason.
I thought this extends more. So this is increasing the width?
No, going out to the waterway.
But you just said it's very narrow.
Oh, no, the slips are very narrow.
Right.
The slips in the sense of they're very compact.
Right,
So
they're narrow in their width.
Yeah, so if you have to back in, it's very, very difficult with the current.
Right, and so why, if the slip is shorter, does that affect the narrowness?
Because then if you can come in forward, you can handle it. It's a lot easier for you to navigate in. And being as a boat lift, if you're backing in, the water is not very deep.
Yep.
So it's almost impossible.
Okay. So if it's longer, you can go in bow first,
Yes.
is what you're saying?
Yes.
And if it's not longer, you have to go in stern first.
Yes.
Okay, which makes it very difficult.
Very difficult, yes.
Okay. All right. Andrew, is that you're accurate? It's completely useless slip if it's not extended?
It wouldn't be useless, but it would be much more difficult to use.
Okay. So you think this is like, okay.
In that area, it's 300 plus feet wide.
Yep.
And this extra 7 feet does not impact navigation at all.
Cool. Thank you. What's the, I don't know if Dwayne or Bob, what's the legal definition of seeking a rationale for seeking a waiver? In other words, can it be any reason? Can it be I just want a bigger boat? Does it have to meet some criteria? Thanks.
Bob, if you can.
I noticed that the Marine Advisory Board passed this 12-0.
Assistant City Attorney Bob Dunkel. Sorry. Extraordinary circumstances is the standard in the ordinance, but I think that extraordinary circumstances have to be judged in light of what other waivers have been granted in similarly situated properties. Are you looking for me to expand on some of the factors that have been used before? I'm not sure exactly what you're looking for.
What?
And let me add, we're in the process of evaluating changing that standard so that it shows more of a balance between factors that would justify granting a waiver versus factors that might militate against that, such as impediments in navigation, so on and so forth.
Great. So I think that's a good idea because in my mind, the statute's not well crafted right now.
I agree with you 100%.
Okay. So as it stands today, extraordinary circumstances seems to be very broad, general, provide general allowances.
I think one of the things that could give you guidance is the number of a number of waivers that have been granted on this particular condominium. Andrew, you may be able. How many? 7 plus.
Yeah.
On this one condominium.
Yeah.
And it's problematical if you've got a number of those of similarly situated properties, and this one gets denied, and you're not treating them the same as the other similarly situated properties.
It gets problematic for who?
For us as the regulatory agency.
Yes.
Are you saying from a liability standpoint?
No, not liability.
From a what standpoint?
I think that you would probably be giving the applicant standing to contest it in a petition for writ of cert.
Because we're rationing out these waivers on an arbitrary and capricious basis. We have to show consistency in our policy.
Well, yeah. I mean, I hear you, and I think we're too permissive. I really do.
Well,
and I think to change that, we have to start somewhere, and that means going against what we've always done. Possibly.
Well, I don't disagree with you. In fact, Steve Whitten, you want to come up here and talk about this? Because we agree with you on the New River. I think we've made a policy to not grant any more waivers on the New River. But over here on Middle River, Steve, because you voted 12-0 at the Marine Advisory Board, do you want to give us the basis for that?
Sure. Steve Whitten, Marine Advisory Board, and thank you all. I don't want to use terms like no-brainer, but as Bob Dunkel said, et cetera, we have approved a number here in the the criteria we use, and Dean, we've joked about this over the years, where there was previous board that we joked about rubber stamping approvals, etc. The amount of time we spend on every waiver, the amount of time that each of us spend at the property. This is a volunteer organization, but we take it as if we are paid to do this, and we take it quite seriously. This particular one, the Riva condominium, has an extremely, as I think Bob said, has an extremely wide canal. It's over 300 feet wide. So one of the things we take into consideration here is what is the size of the navigable channel, and is this potentially boat going to impede that? And the answer is not. And this particular one, again, we have fully vetted this. And I want to touch on something, if I can, because this has come up every single time, and Bob Dunkel just mentioned this. The term extraordinary circumstances simply does not apply. It doesn't apply to this one and most of the other waivers. So, as Bob said, we are discussing changing the term perhaps to extenuating circumstances, and basically circumstances other than normal operating conditions which exist. I understand Ben's concern. We took that same concern on New River. But this is the boating capital of the world, and with due respect, if somebody wants a boat over 25 feet in that location, we do believe they're entitled as long as they go through the right process. So part of this also is the fact that somebody may want a larger boat, and in that location, we don't have a problem with that.
So then why don't we change the ordinance to say up to 30 feet? Let's just change it.
It is something that we started last year with a moratorium. That word we will never use in our vocabulary again, but it is something that we are working on. And I will tell you, it's something that Bob Dunkel is working on hard, and it's something that we're working on as the board. Obviously, due to sunshine laws, we have restrictions there, but through Bob's guidance, we are hoping to change that.
You're hoping to change it to 30?
We are hoping to make a change subject to what the city commission approves. I don't know what that is yet.
Well, but Ben, to your point, yes, I feel that we've had this hard and fast rule of 25 feet. When the Nina and the Pinta and the Santa Maria was 25 feet.
Correct.
It's like now we need to take into consideration that boats are 80, 90, 100 feet, and we need to do everything. But keeping it at the 25 feet allows us to assess it on a case-by-case basis based on the width of the canal. In this case, the Middle River is 300 feet wide. It's not going to in any way impede. But what's to say the next person doesn't say 60 feet or 80 feet? Okay, but I do think that in order to give the community a heads up as to what they can have when they buy a unit on the water, we should probably extend that minimum from the 25 feet to like 35 feet or something, especially since the Middle River is 300 feet wide. It makes more sense. But when the canal is 70 feet wide,
right,
then we don't want a 35-foot extension, right?
Mm-hmm.
So we want to keep it at 25 feet. That's why by keeping it at 25 feet, we're able to assess it on a case-by-case basis. But we did, I think the commission, I forgot which meeting, I think it was before you returned to the commission, Ben, that the commission had said probably no more dock waivers on the new river because there's just no more room. The river is, despite rising sea levels, the new river is just too narrow and too crowded for, especially as we go further up the river. So, but to your point, you can make that recommendation to the commission. You can make a suggestion to Marine Advisory Board, and they can come back to us with a number, or a different standard by which we assess these. You say extenuating circumstances versus extraordinary circumstances. I do think that maybe we should revisit this. We are the marine capital of the world, and we should try to encourage boat usage.
You bet.
We don't have any more shoreline, so the extent that we can maximize what we do have, I think it behooves us to consider that.
Very much so. And we also realize that we may not be able to apply a uniform standard, obviously, when you have 300 feet of width on the Middle River and some of the canals are 100 feet wide. Obviously, the main thing we're trying to do is to ensure safe navigation. So the 30% rule simply suggests that we're leaving 40% of the canal for safe navigation. That in itself is questionable questionable again because the beam of the boats have gotten wider, etc. So we are taking a look at the whole picture, and through Bob Dunkel's oversight, hopefully we'll have something to report back to you shortly.
Okay, thanks, Steve. So navigability sounds like your main concern.
Yes.
Great. The 30% rule sounds like you like that or feel good with that.
Very much so. I think
Okay.
that, again, though, it's tough to pick a uniform standard because we've got canals, we're looking at waivers over at Hendricks. Over at Hendricks, we may not be able to use that rule, again, because the canals are much tighter. So when I talk about, ensuring safe navigation, we're not just talking about boats going up and down New River. We want to make sure the barges can get up and down our canals to repair seawalls. And obviously the barges haven't gotten any smaller. So we are clearly on the same page. We're just trying to work through this.
Does the 30% rule apply wet face to wet face or property line to property line?
Property line to property line.
And you think that's the right standard?
The confusion is that, and I don't know what the right standard is. I really defer to, it's why I chose not to go to law school many years ago. And
Wise.
I did okay. But I don't know what really applies here and what's accurate. So we're going through, and basically what we did, and again, I'm sorry to bore you, but I appreciate the moment, is we had a joint MIAS-MAB meeting in January. I think you may have been there. Mm-hmm. And we went down a punch list. What's important to you? We want clean water. We want to have the ability for our kids perhaps to go swimming in our canals again. So we're working on these. So we have a full agenda of items that we hope to deal with, and this is at the very top. But as we're all saying, if you live in the boating capital of the world, as long as you're not impeding your neighbor, etc., you should be able to enjoy this. Mm-hmm. Now, from my perspective, that applies to somebody who has a 16-foot whaler and a person who has a 160-foot boat. Mm-hmm. So we're trying to make sure that we can ensure safe navigation and enjoy boating for everybody here, and that's what we're working through.
All right. Thank you, Steve.
Thank you.
Appreciate it.
One moment, please.
Yes, sir.
In regard to extenuating circumstances, let me give you a partial list of some of the things that we're looking at, and we're going to be bringing this back for conference agenda sometime. The 30% rule doesn't always apply. We've had a bathymetric survey along New River. Sometimes the channel goes out around some of the bends, so the 30% rule doesn't always work. But some of the things that we would
there's silt buildup sometimes too.
Exactly.
Right.
Exactly. Yeah. So some of the things that you'd be looking at that would an argument against granting it would be boat accidents, visibility, hazardous traffic congestion, impediment to navigation, protect public infrastructure, impact on neighboring properties, impact on mangroves and other sensitive things. Curves in the waterway, impact on deep water channel, and marine habitat. And
thanks, that helps.
We will be looking at changing the definition of property line to property line to wet face. There's some complications that we've come up with as to whether it should be high water mark, low water mark, how exactly it would be measured. But yes, we're going in that direction.
More to come.
Yes.
All right. Okay. Thank you, Bob.
Thank you.
Thank you.
So,
Appreciate it.
So public hearing has been closed. The resolution has been introduced. Please call the roll.
And Vice Mayor, that's for approval.
Yes.
Thank you. A resolution of the City Commission of the City of Fort Lauderdale, Florida, pursuant to Section 47-19.3 of the City of Fort Lauderdale, Florida Unified Land Development Regulations, granting a waiver of limitations of ULDR Section 47-19.3C to permit Daniel S. Wabi and Carl S. Wabi, husband and wife, installation of one 16,000-pound four-post boat lift extending 32.7 feet plus or minus from the property line into the adjacent waters of Middle River, such property being located at Riva Condominium, 1180 North Federal Highway, unit number 1410, slip 16, Fort Lauderdale, Florida, and more particularly described below, subject to certain terms and conditions, repealing any and all parts of resolutions in conflict herewith and providing for an effective date. Commissioner Beasley Pittman.
That's why he gets the big bucks.
Exactly. You took it out of my mouth. Yes, well deserved. Again, well deserved. Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst? Yes. Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes, and PH3 is now approved. PH4,
It's a public hearing, quasi-judicial resolution approving a waiver of limitations at 1414 Southeast 12th Street, number 2C, slip 11 for one floating vessel platform. Anyone wishing to speak must be sworn in, and the commission will announce any site visits, communications, or expert opinions received and make them a part of the record. Commissioner Herbst, any disclosures?
Yes, I had a conversation with Romney Rogers.
Okay. Commissioner Beasley Pittman?
No disclosures.
Okay. I have spoken with Romney Rogers, and that's it. Commissioner Vice Mayor?
Yes, spoken with Romney Rogers.
And Commissioner Sorensen?
Yes, Romney Rogers and the applicant.
Okay, so we have a number of people who've signed up to speak. I'll call you. Oops, this got mixed up. I'll call you three at a time. If you just be prepared. We start with Ellen Bogdanoff. Ellen, are you still here? There you are. Ellen Bogdanoff, followed by Jim Magruder, followed by Cam Rogers. Cam, are you here on behalf? You're here on behalf of a neighbor, right? You're not. Are you here on behalf of the applicant? Okay. Okay. Ellen.
Oh, thank you, Mayor.
Is the applicant here?
Yes, sir.
Yeah. Why don't we let the applicant speak first?
Okay.
Sir, would you like to come forward? Mr. Diorio, right?
Yes, sir.
Yes. Good evening. Here we are.
Mr. Mayor, Vice Mayor, Commissioners, Nicholas Diorio, applicant. My wife and I own at Hemingway Landings condominium with the sign slip number 11. Few comments that I heard in earlier public hearings. Commissioner Beasley Pittman, I agree with notification of the owner as an important element, and when in fact my condominium called code enforcement, never advised me that code enforcement was coming out until a code enforcement officer stood on my dock and called me at my home in California to tell me that he was issuing a violation. So I find that disturbing. Commissioner Herbst, strong advocate for property rights. I agree 100%. That's entirely what this issue is about, is my property rights at the Hemingway Landings condominium. Mr. Mayor, if I could present a PowerPoint slide presentation with graphics. Go ahead. Thank you. For reference, this is slip 11 from a January 2022 photo taken shortly after installation by the previous owner. I did not purchase or install this. They are plastic cubes, modular plastic cubes of 20 by 20 inches assembled in order for a boat similar to a Boston Whaler, or in this case, the previous owner of the condo had a Zodiac type boat that he is able to bring up and then winch it up on the floating platform and get the boat completely out of the water. Was installed by the previous owner with Hemingway Landings board approval, requested and in writing received. Also received a Broward County environmental license in order to install the floating dock. As per the instructions from the contractor that installed it, there is no City of Fort Lauderdale permit required for floating dock. This floating dock sat peacefully in the water for over 2 years. No violations, no complaints, no other comments, until all of a sudden something happened. Could I see slide 2, please? Slide 2 is a violation that was issued by the city's code enforcement department in May of 2024 to all 21 owners for marina elements extending beyond 25% or 25 feet, whichever is less, from the width of the waterway measured from property line to property line. Violation number 1, which is above the red square, shows numerous dolphin or mooring piles, and violation 2 for a floating dock, that is my dock in slip 11. As the marina is assigned as a common element and not fee simple, all 21 owners were cited for both violations. Everyone, this happens to be a copy of my violation addressed to myself and my wife, but all 21 owners received a similar violation for my floating dock also. In November 2024, City Commission approved a resolution for waiver for the 22 mooring piles beyond 25 feet. Therefore, violation 1 you see on top was settled. The application before you addresses only violation 2 on this citation. This is a continuation of the Hemingway Landing's goal, as you heard in November of 2024, to achieve our common objective to bring the marina into complete and full compliance by meeting city code. Exactly for the piles, had to be a waiver approved in order to meet city code. You approved that waiver. I presented in front of you in December City Commission meeting. You deferred requesting clarifications. On December 17th, your motion to defer requested provide an accurate survey from property line to property line, as again was just confirmed. Based on the above, confirmed floating dock does not encroach beyond 30% for the width of the waterway, and as was added, return to the Marine Advisory Board. I am pleased to report all items are completed in full compliance with your motion. An accurate survey to determine the width of the waterway from property line to property line, or as we discussed, from neighbor to the south of Hemingway to the Hemingway Landings property to the north. Slide 3, please. Included in your commission agenda memo as Exhibit 1 is this memo dated January 23rd, 2025, issued by a Florida licensed surveyor who concluded from the recorded plats and Broward County records the waterway width to be 120 feet from property line to property line. Slide 4, please. That's a continuation of the January 23rd memo. Slide 5, please. This is one of the plats that was studied. I believe this one dates from 1935. And slide 6, please. This is another plat that was studied, and I believe this one dates from 1953. Slide 7, please. Further confirmation is provided with this licensed professional signed exhibit, which is taken from Broward County records, included in our recorded declaration of condo documents. This document, as highlighted in yellow, shows 60 feet from Hemingway Landings property line to center of waterway and 60 feet from center of waterway to the property line on the south. Total, again confirmed by an accurate survey, of 120 feet. Next was the confirmation that the floating dock, which now exists, does not encroach beyond 30% width of the waterway, calculated at 36 feet from property line, or 30% of the 120 feet dimension that we just talked about.
Saying to the commission is that this particular floating dock, which was installed before you by the previous owner, was in compliance with the regulation as based on the 30% rule.
No, sir.
It was not.
Was not.
Okay. Before we go on any further, I need a motion from the commission to extend the meeting past 10 o'clock tonight.
Move to 11.
Okay. Do I hear a second? I need a second to 11. Okay, 10:30. I have a lot of people signed up to speak tonight. Okay, 10:30.
I'll accept that.
Okay. Call the roll, please. 10:30.
Did you?
He agreed to that.
Okay.
I accept it.
And then who seconded it? Oh, okay. Thank you. Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst? Yes. Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes. I'm sorry, sir.
Is that in our code that we have to?
We passed an ordinance that all meetings have to take place before 10 p.m. Otherwise, we need a vote to extend it.
Okay. Thanks.
Yeah.
Could I ask a question? Will the issue be resolved before 10:30 p.m.?
It'll be resolved tonight. Yes.
Thank you.
Eastern time.
So, to answer your question, Mr. Mayor, if you did calculate the 30% of the 120 and come up with 36 feet, the dock, as purchased by the previous owner, did not comply.
Okay.
And actually, I didn't call for this slide yet, but it's up. So, you may recall our previous waiver application noted our floating dock extended 36.4 feet, which would have encroached beyond the 30%. So it actually, answering your question, Mr. Mayor, would have encroached beyond.
By how much?
0.4 of a foot, which I believe I converted to 5.8 inches. So roughly the length of a pen.
6 inches? About. Okay.
Yeah. Taking the suggestion of Mayor Trentalis, quote from the transcript, if you maybe cut off 1.5 feet of your dock in order to be able to accommodate the situation. I shortened the dock by 20 inches. Great suggestion. 20 inches happens to convert to 1.67 feet. Slide 8 is on the screen now. The dock shows cubes marked with an X have been removed from the dock.
Easy fix.
Slide 9. Sketch to the left was the previous extending 36.4 feet from the property line. Cubes in red were removed. The dock was slid closer to the seawall, and a modified version on the right shows 34.73 feet, or taking out the 1.67 feet. Slide 10, please. Slide 10 was taken on January 17th. You will notice the walkway leading to the dock as part of the dock had 4 cubes in the walkway. Slide 11, please. After the work was done, you see there's only 3 cubes. Okay. Exhibit 10 is a confirmation by a Florida licensed surveyor, slide 12, please, and stating that the floating dock is extending only 34.4. I said, from my calculations, and not using Google Measure, but from my calculations, I came up with 34.73. By surveyor, 34.4, which is less than the 30% of the width of the waterway.
So what is the issue here tonight then? If it's your position that you are within the 30%?
Yes, sir.
Okay.
My position is ask for your approval and shut the public hearing off.
Is this from property line to property line, or
Yes,
from
sir.
wet face to wet face?
Property line as the code requires.
Okay. All right. All right.
And the third requirement, return to the Marine Advisory. Slide 13 was just the sketch showing the Florida licensed surveyor with his calculation of 34.4 to the tip of the dock, leaving a gap between the width limit line of 1.8 feet. Converting to inches, that would be about 22 inches.
Okay.
Slide 14, please. After returning to the Marine Advisory Board and going through the entire process again, showing that the dock was reduced, the Marine Advisory Board again approved and recommended your approval, which is included in your Exhibit 4. I would like to note that Chairman Whitten of the Marine Advisory Board asked, and I agreed, although it does not appear in the minutes, that at his request at the MAB hearing to adhere reflective tape on the outside corners of the floating dock as an added safety feature. I did agree to that at the Marine Advisory Board, and if you find this for approval, I would, again, live up to my word and apply the tape to the corners of the dock.
Okay, very good. Thank you so much, sir.
With meeting the requirements of your motion, we respectfully request this waiver be approved as recommended by both your city staff twice now and the Marine Advisory Board twice in order for Slip 11 at Hemingway Landings to enjoy our peaceful existence and be in full compliance by meeting city code. Mr. Mayor, if I could also request the opportunity to again address the Commission after others speak, should I have any clarifications or anything to add to the record?
Absolutely.
Thank you.
Absolutely. Thank you.
Thank you.
Ellen Bogdanoff, are you here representing? Are you here representing a party?
I'm here representing Brian Lilly, who is a resident of the Hemingways.
And is Brian?
And he is opposed to.
Is he adjacent to this?
Yes.
Okay.
But it's a bigger issue because, as you saw with the previous waiver, it's going to set off a series of waivers that are going to be coming before this commission, and they're trying to get back into compliance. And the association, as well as Mr. Lilly, is opposed to any of the waivers that do not meet code. And I applaud the Marine Advisory Board for trying to talk about fixing it, but you can't rewrite code, and that's basically what they've done. Just to kind of clarify a couple of things, it is not property line to property line. If you read the code, it's very specific. It says that you can get a waiver, but it shall the extension shall not exceed 30% of the width of the waterway. It does not say from property line to property line. The code specifically says property line to property line when it talks about the 25% of the width of the waterway or 25 feet, whichever is less, as measured from the property line. And there's another section that talks about you have to have, of course, extraordinary circumstances, which that doesn't exist, but it also talks about mooring or dolphin pilings extend more than 30% of the width of the waterway, or, comma, we know commas matter in legal terms, or 25 feet beyond the property line, whichever is less. They used the word property line in code when they meant property line. The width of the waterway is the width of the waterway, which is why Commissioner Sorensen asked them to specifically go out and measure. But what they did is they took the plats and they did a survey based off of the property lines. That's not what Commissioner Sorensen asked for because that's not what the code requires.
You're saying wet face to wet face as the distance that should be
correct.
Okay.
That's the way the code reads. I believe the chairman basically said we're not 100% sure why, which is why they want to address it and they want to make sure that they fix it. And what you find is when you do a Google search for most of the realtors, they claim that the waterway is 110 feet, and that's to advise people who are looking for boating, to moor their boat, that they only have 110 feet on that waterway. We don't actually have a measurement. That's the only measurement I could find. That's why Commissioner Sorensen had asked him for it. The only other issue is even if you want to argue that you meet the 30%, you have to have extraordinary circumstances. And you might not like the terminology.
And it shall not exceed what percent of the width of the waterway?
It says, in no event shall the extension exceed 30% of the width of the waterway, and no variance may be approved by the Board of Adjustment or any other agency.
and creating a navigational hazard. Well, where does that come from? I mean, how do they come up with that? The second is it creates a positive impact on environmental issues. Well, you know, when you lift the boat out of the water with a lift, it does the same thing. So how is it extraordinary that you have a floating dock? And what does that make it extraordinary circumstances? And that has nothing to do with the length. That's what we're talking about, the length of the floating dock. So that could, if they stayed within the 25 feet, no issue, of course. The third extraordinary circumstances was supposedly that it was installed with reliance and good faith, with no malice intent to violate the city ordinances. I don't think that's unusual, unexpected, or beyond someone's control. And fourth was extraordinary width of the waterway. All right, well, it's either 120 or 118 or 110, but I don't know that that's considered extraordinary. You know, I think that's rather narrow versus 300 feet of Middle River. All right, next slide, please. Sure.
Sorry, go back.
First one.
One more, please. Thanks. Okay, thanks.
Okay. All right, next slide, please. All right, so this is just pointing out exactly where the floating dock is in question there, slip 11, right in the middle of the waterfront where there's 20 slips, or 21 slips. All right, next slide, please. This is showing the green section is beyond the 25 feet, okay? And that picture was taken before the removal of the foot, the 1.5 foot that was removed in order to fall with under the 30%. But see the other blue items on here? Those are the other two matters that are come before this commission. Those are the other two.
Please don't interrupt him. Please don't interrupt him.
Those are the other two matters that have come before the commission, right? And they're lifts, right? So here we've got the same, mooring structures, and you all are going to have to look at this thing again. And I'm sure, as shooting, that if you approve this one, then they're going to come walking in asking for the same thing, right? That's what we're dealing with here. Next slide, please. So the removal takes care of the 1.5 feet, according to the applicant. All right. So I don't even know that we can dispute that per se, but I do know that it's not extraordinary circumstances in order to grant it. So I think that's important. Next slide, please. So I think this will give you an idea that the picture shows the floating vessel there, the floating dock, and there's no vessel on that. There's no boat on the dock, so I'm not sure why we're only talking about this floating mooring, floating dock, that if you put a boat on it. Next slide, please. Yeah, here again, that's another view of it, of course.
So let's stop right there.
Yeah.
So you're saying that that the structure as it now appears is creating an impediment to navigation on that river?
Yeah, it certainly can, especially see how it's black, it's low. What happens at night when somebody wants to get down the river or into the next slip?
Well, if you put a reflector on there, I think that would. But I see other boats that seem to be coming out about the same distance. So I'm just trying to understand if the city needs to be consistent in its policy, how is?
I agree. There's no boat on this one, Dean. All
Right,
that is a dock. So
Right.
Is he going to just keep a dock there? I don't think so.
No, what didn't the previous owner put a boat on top of it?
Well, you had a picture of that, but I think you put another boat on it. Why do you need one that long if you're not going to put a big boat on it? I mean, that only makes sense.
Well, I don't know the answer to that question, but right now we're only trying to determine if we're being consistent in allowing boats to dock along this wall, the seawall, to such an extent that they don't create a navigational hazard down this river. And I'm just trying. Your picture here, I mean, it looks pretty consistent with all the other boats. Are those all in violation too?
No, they're not. The boat can be 36 feet, right? It's the mooring structure that's limited to the 25 feet. So
those pilings are all 25 feet?
Those pilings are a little longer than that because we had to get that waiver, if you remember, right?
I don't remember, but
right.
But those green pilings, those are all past 25 feet?
They're a little past 25 feet. Yeah.
Okay, so those are all but those were all given waivers.
Correct.
And so we're being asked to allow a waiver to allow this floating dock out to 30% of the navigable waterway. And if we grant it, he would not be allowed to have a boat extending beyond the edge of the dock. Your concern is that he would have a boat that would extend beyond the edge of the dock. Is that correct?
The concern would be, obviously, if it encroached into the 30%, that it could be a hazard in navigable water.
I understand that. Okay.
Right.
But just for my own clarification, is it the mooring structure can't be more than 30%, or the boat, any structure? What is it, Bob? Both.
Both. Right.
Okay. Thank you. And is that same for the 25 feet too, Bob, without the exception? Yeah, no, it's all good. Yeah. Without the extraordinary.
Let me go back and answer the first question. The 30% applies to both boats extending beyond 30%, as well as the waiver provision does not allow you to grant a waiver that would extend more than 30% of the width of the canal. And I have to go back. The documents that he put up there showed subsection C, which talked about measured from the property line. If you saw subsection D, it has the same phrase. E makes reference back to C and D. So it's incorporating the same formula in E for the waiver as you have there. And it's also back in 8-91 that says 30% the width of the waterway measured from the property line. And it needs to be changed.
Okay. So before...
Can I just clarify one point?
No, wait. Okay.
If you don't mind.
Go ahead.
So Mr. Magruder, who's property manager, he lives there, right? He told me two things I remembered, one I didn't. But the bottom line is that there's not an equal distance in this. You can see how it curves around. One of the boats, he said he reassigned to another lot. And I think I'm correct on this. The first time that our applicant gave you a picture of the measurements, he drew the property line like this. It wasn't a straight line. So I do think that that's an issue, and I don't think that 1.5 feet, right, is considered extraordinary circumstances in order to stay within the 30%.
Okay. All right. Thank you. Can I get a motion to extend the time of the meeting? It's been moved. Do I hear a second?
Second.
To what time?
Agreed. Second.
Commissioner Beasley Pittman? Commissioner Sorensen?
Yes.
Commissioner Herbst? Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes. Thank you. Mr. Raj, does that conclude your presentation?
I had one more slide I wanted to show you.
Okay.
To emphasize the point, if you don't mind. Could you keep going to the last slide, please? So that's what we're going to get when we get the boat on there. And certainly that exceeds the 30%.
Oh, I see what you're saying. Okay.
Right. All right. And then Mr. Magruder's right here.
Okay. Mr. Magruder.
Jim Magruder. I'm a property owner and the property manager at the same time. I'd just like to make a clarification of a couple of points. The last slide where you saw, if you could put the couple slides back, I'll point out something that's important.
Can you?
That slide there. The boat with the white engines I reassigned down to a slip that is allowed a 36-foot boat.
Okay.
The other point I'd like to make is the canal, as you go west, does this. So we have certain slips that are allowed 36-foot boat and certain slips that are allowed.
So it widens as you go further west?
Yes, sir. Goes just like this and around the corner.
Okay.
So every boat from slip 9 to 1 is allowed, excuse me, is allowed a 36-foot boat.
Okay.
The other thing, I got the Mr. Dunkel's survey this morning, so I did some other homework today. There's actually 3 different seawalls at this property. The property is 320 linear feet. A third of the first third on the east side has a coral seawall. The next third has a new seawall that is actually 5 feet. The first seawall is 1 foot wide. So the distances that I was dealing with since I was assigned to this in March of 23, the first third was 110 feet. That was notated on the document that I got that was the plot in 2009. And then I did a laser measurement of the same thing, and I got 110 feet. But if you go to the middle third, it's got a 5-foot seawall, so the distances are going to be different.
Okay.
And as you get to the last third, that's when the curve, or that's when the expansion of the canal starts. So there's 3 different views of it. And I believe each of the surveys, I did the second survey. My time's up.
Go ahead.
I did the second survey, which was the 118-foot one. Then I got Mr. Dunkel's today, which is 120. Very understandable that they're going to be different because you got 3 different seawalls.
Well, his survey said 118.
Mine said 118.
Yeah, which is wet face to wet face.
I've been operating wet face to wet face until I learned this morning that it was property line to property line.
Well, if it's wet face to wet face, 30% is you're allowed 35.4 feet to extend into the waterway.
Different thirds allow different.
Yeah, I'm just saying 118 feet. I did the calculation. I didn't use AI, but I figured it out in my head. Anyways, 35.4 feet. All right, thank you, sir.
Thank you.
Steve Whitten, do you want to comment on this? What were your extraordinary circumstances?
I signed up to speak, frankly, if you have any questions.
Okay.
I talked about extraordinary circumstances before. I will tell you, just for what it's worth, I had visited the property a number of times, and I was also surprised to see, I'm going to say, a number of boats more, roughly a third of the boats that are protruding way past the mooring piles. And again, you have to we're penalizing the applicant here for something that can be. So I do understand that the applicant can put a boat on there with 2 engines sticking out the back, and that becomes a code enforcement issue, like everything else here. But in every respect, the applicant has done everything we asked of him. Again, the boats are the idea that we're going to put this in compliance, I don't understand. And with great respect to the commission, I feel we are unfairly penalizing an applicant for something that can happen in the future. I thank you for giving me an opportunity.
Okay, thank you.
The one concern I have.
Brian, I'm sorry?
The one concern I have, though, is that the applicant didn't do what we asked them to do. And I've had this conversation with Mr. Dunkel. So we, the commission, directed the applicant to go get a survey, and he didn't. So as I shared with Mr. Dunkel, I don't think it's appropriate for staff to direct the city surveyor to go out and have a survey done when we, the commission, directed the applicant to go out and have a survey done, bring that survey back to the Marine Advisory Board for reconsideration. I understand why Bob did it. We had a conversation about it. We will have to agree to disagree on it. But I understand his rationale. But I think it's very important because we've been talking about precedent all night long. The precedent here is when we, the commission, direct somebody to go do something, I expect compliance. And our direction was, I think, very clear. Go hire a surveyor and then go back to the Marine Advisory Board. And that was not done. And that's very concerning to me, because in everything that we do, when we ask applicants, whether it's for a waiver here or whether it's historic preservation or anything, when we direct people to go and do something, there's an expectation that I have that that direction will be followed before it comes back to us for reconsideration. So I just want to get that out there, because I'm not happy with how this has occurred.
Okay. Mr. Lilly. Coming down out of the sky onto the water.
Blue Angels returning to Fort Lauderdale, May 3rd and 4th. It's good to see you all.
Go Navy. Go Navy.
Go Navy. Normally I'm here representing the air show, and tonight I'm here representing myself as a resident of Hemingway Landings. So, and I put some notes down here because I wanted to make sure to cover all this, so I'm going to kind of read from my iPhone here. But I want to kind of give you a picture of everything that's been going on, because this is just, as a few people have commented, the first part in a line of waiver requests that you're going to get. And after a meeting last night and a comment, I think even the ones that are pending, you'll see more of those. So I stand in opposition to this request. Last night, the applicant asked several of us owners to come for a talk at the pool, where he presented basically what he presented to you without the PowerPoint, because we don't have that down by the pool. And he said, he was asked, what do you want to put? The former president of the association said, what do you want to put on the stock? He said, like a Zodiac or, something like that. And my question is, why you need a 34-foot floating dock for a Zodiac, right? He already has pulled 2 of the cubes off, which he had just said, and if he pulls 5 more off, he'll be down to 25 feet, and he won't even need a waiver. So it's obvious, and I think Mr. Rogers has shown that the intention, or even the potential, whether the intention is there or not, is to put a larger boat on it, and then, of course, the floating dock goes right to the 30%, and then you'll have motors sticking out into the navigable waterway. So I'm just going to go back here. I think it's obvious he has the intention to put a larger boat on there, my personal opinion. So here's what's coming next. So,
all right.
Can I
conclude your remarks?
Okay. Here's what's coming next. So he's got some people that are in support. I know you got some letters. So 2 of the people that are in support of him are the owners of Slip 19 and Slip 21. They both have boats that were in their slips that were not in compliance, and they both got code violated. So Slip 21, they both have boat lifts as well that are not in compliance, that you saw on Mr. Rogers' map. Slip 21's coming for a waiver on the March 18th meeting for a waiver request, and Slip 19 is not far behind him, right? So this is going to be something that propagates itself. Slip 19 has more problems because he actually built his lift 3 feet encroaching into Slip 18, and it has been there for 2 years, and he has refused to remove it, okay? So they both had oversized boats in their slips, which both got code violations. They were both 35-foot boats. They both extended 8 to 10 feet into the navigable waterway, creating a hazard to navigation. It creates a liability for every one of the 21 unit owners, because it's negligence. It can be shown as negligence on the part of an insurance company. So if somebody hit one of these boats that's oversized going into the waterway, and a claim came against us, our insurance company would be in a position to deny it for negligence, because those boats were allowed to be there. And the association's done everything in its power to try and get them to move, but we've had non-compliant property owners in these particular slips. So, these are creating a hazard to navigation. I have some pictures of a barge that went by in early February of boats that these boats that were too long and came within a foot, and I could send you the pictures.
Well,
right?
You're assuming he's going to be non-compliant, which I don't think is fair. I mean, you're assuming the bad actors are going to continue to perform.
But there's the potential. Yeah. Well, the boats were supposed to be moved by the violations by December 20th. The one boat got moved January 30th. The other one got moved February 4th. And it was only after a magistrate hearing got scheduled that they actually moved the boats.
Right.
So it's a matter of, and Mayor, it's a matter of, and this is the final thing I'll say, and then I'll conclude.
Good.
Last night, I know we're all tired. Yeah. Last night, one of the other property owners said, I hope, he said this in front of our whole group, I was sitting there, he said, I hope that you're successful, because if you're successful in getting this waiver, this will set a precedent so more of us in slips 5 through 21 can go apply for waivers. And this is just the first that's going to set off an entire chain. And the association has already incurred $100,000 in legal costs. We've been fighting this. We've not been successful. And if these waivers, this one and others, are approved, it's just going to create a policing issue. It's going to cost our association more money. And it is not going to go to the goal of getting us in compliance.
Okay. All right. Thank you. Anyone else wish to speak on this item? All right. So do I hear a motion to close public hearing? Well, wait. You're okay. You're staff. Do I hear a second?
No, I asked for opportunity to speak.
Oh, okay. All right. Please. Please see if you can make them brief.
Okay. First item I'd like to address is the concern of Commissioner Herbst, and I respect your request. I would like to clarify, and if necessary, I do have a copy of the transcript. There was never a requirement in the transcript and the motion that Commissioner Sorensen made to go get a new survey. You can go through the transcript, and I searched on the word survey. I searched on the word verification.
I had my staff listen to the meeting.
Yeah. Okay.
So
I did too.
Yeah, I had my staff listen to the
you
meeting and
strongly. And there is the term accurate survey, which was requested 3 times in the transcript. Accurate survey, and the recorded plats in the Broward County records that I produced from 1935 and 1953 are accurate surveys signed by a Florida licensed surveyor, and again are valid until a new plat is recorded in Broward County records, which would then supersede the old.
I'm sorry, what are the dates of those?
One is 1935 and one is 1953.
I would assume from 1935 to date that there could be some shifting in the lines of where the water and the shoreline are.
I respect your opinion, but if you discuss that with a Florida licensed surveyor, which I've talked to many because it was during the holidays trying to get, and let me just tell you a quick story. I know it's late.
Wait. Let's. Why don't you we got to conclude this. Okay? We can be on this all night long. I think we kind of got the issues narrowed. I think the commissioner's point was made, and you've responded.
Okay.
Let's just move on quickly. Try to conclude your remarks.
Hold on. I'd like to, Commissioner Herbst. What did you understand I said, or your staff understand?
I understood your directions, and again, I had my staff go back and listen repeatedly to the tape. I understood your direction was to go out and have a new survey performed and bring that to the Marine Advisory Board so that we would have a document in hand that supported the request to the MAB for their reconsideration.
That's what I thought I said.
That's what we thought you said too.
Okay, all right.
And who did the survey instead? We did it, right? So I would trust our surveyor more than I would trust the applicant's surveyor.
Well, but my problem with that, Mayor, is I don't want anybody. To me, this is a very, very important question. I don't want us to be taking on the obligation of applicants, because if we do it now, are we going to do this every time we have a question about something? We're going to send city staff out to do this? We're now arguing against ourselves.
Well,
I just don't think it's appropriate. If we direct people to do something, there's an expectation that it will be done in accordance with our directions. I don't want somebody substituting their judgment for ours.
Well, but I will say this: I do respect an objective point of view more than I respect an advocate's point of view, and it would make more sense for us to go out there and do an objective survey rather than an applicant bringing his own people out who will survey it based on the expectations that the applicant expects from an assignment. So all I can say is I respect what Mr. Dunkel has presented more than I would have respected something the applicant would have presented. We can disagree on that. I'm just saying that's my, that's just. But let's just go forward.
But we should, if that's going to be our posture, then let's then direct staff to go do things like that. I don't want anybody inserting themselves in place of our judgment. If you believe that, and I'm not disagreeing with your conclusion about that, then that should be what we direct people to go do. We can look at Susan Grant, because we can't direct staff. We look at Susan Grant, who we can direct, and we say, Susan, please have the city surveyor go out and do this. I can't tell Bob to go do this. Dwayne can't tell Bob to go get the city surveyor to do it. Bob can't tell the city surveyor to go out and do it. The only person who can tell the city surveyor to go get a survey done is Susan. And last time I checked, I looked at that email, I didn't see Susan's name on it.
Okay.
So no, this is very important, Mayor. Okay. This is very important.
Okay, we get your point. We got to move on. We got to close the meeting in 15 minutes. So.
Yes, Mr. Lilly's comments about talking about other issues unrelated to this is, again, using our time. I would please request focus on the only issue that's on the agenda tonight. There is no boat lifts. There is no view issues. There is nothing else on your agenda tonight but floating dock number slip 11. Please focus on that.
What makes your request extraordinary?
Okay. There were 4 items of extraordinary, and to refute Mr. Rogers, it was interesting. He read the 4 right from my application to you earlier, but I can repeat them if you'd like. And one of them was taken exactly from his.
Could you just tell us what they are instead of this whole story? Just give us the answers. That's all we want.
It's in your exhibit. Exhibit 1. If we could bring up Exhibit 1 on the screen of the Commissioner's application. The package you give to all the commissioners with all the exhibits.
Do you know what they are without having to refer to the document? Do you know off the top of your head?
And they may not be in order. One was that there was no malice by the previous owner. He followed all the requirements of Broward County and the contractor in order to install it. Never knew there was a violation. It lived peacefully for over 2 years until I believe Mr. Lilly was the first one to complain to the condominium association. Another one was the environmental advantage of having the boat out of the water. Marine Advisory Board asked many questions on that about the chemical reactions or whatever. Much better to have it either on a lift or a floating dock. Third,
but why, if it needs to be out of the water, why does it have to be 30% extension?
And if you'd give me an opportunity to present the rest of my slides, I will show that a boat that I might think about will take up that dock without extending beyond, even though someone can contemplate that your boat may extend. That is purely
speculation.
Exactly, and I am not. I can show you.
All right, so you contemplate a 30-foot or less boat.
It's actually 23.5 with the engines up, and today I measured from the winch to the end of the dock, and I have 24 feet. I took a picture of the tape measure that I can show you, so I have 24 feet from the winch to the end of the dock, so I can completely accommodate a, it's called a Boston Whaler 105, I believe, and with the engines up will be accommodated.
All right, what are the other two extraordinary circumstances? They're lost. They don't know what they're doing here. I mean, they're going through every. I mean, so let's just try to do it off the top.
Okay, it's in the
of your head.
narrative coming up. Here we go. Narrative.
Well,
Near
I
the
don't
bottom
want
of the
let's
stage.
Let's not go through the song and the story.
Okay, number
just
one,
tell us what
applicant
it
is not
is.
extending into the waterway to create any navigational hazard as modified. It now extends only 34.73 from the property line. It was within the 30%. So that's justification number one. Has a positive environmental impact is number two.
Number
Keep bottom
three.
paints out of Florida waters. That was listed as part of the regulation for the floating vessel platform at Tallahassee. The floating vessel was originally permitted and installed under Florida exemption, thinking as being applicable and therefore in good faith with no malice or intent to violate any city ordinance. And four, due to the extraordinary width determined by City of Fort Lauderdale surveyor, referencing the recorded plats, that it's 120 feet property line to property line.
It does not. It does not impede navigation. That's your fourth extraordinary circumstance.
Yes, sir.
Okay. Okay. All right.
Ms. Boganoff continues to claim there's no extraordinary circumstances presented. There's documentation, completely falsifies her claim.
Okay.
Realtors, I would go by the documentation I presented by a Florida licensed surveyor versus what you might find online from some realtor talking about the width of the canal. Interesting, Ms. Boganoff's minutes at the Marine Advisory said that Mr. Lilly had no objection if my floating dock met code, meaning the same exact logic let's use for the pilings that you approved. Even though they're over 25 feet, they received the waiver and they now meet code. Ms. Bogdanoff and Mr. Lilly are satisfied. Therefore, my dock with a waiver also meets code, does not extend beyond the 30%, and will also meet code. So therefore, Mr. Lilly, by Ms. Bogdanoff's own testimony, is not objecting. And I can read the quote from Ms. Bogdanoff at the minutes if necessary.
I think we're good, Mayor. I think we're ready to vote. Can
well, we have, all right. Does that? How much more do you have to state to rebut?
We have 9 minutes left.
Yeah, I know. How much more does this gentleman have?
One other thing that I think is very important. Again, if you could bring my slide presentation up, take this one down, and
well, what is it before we get to it?
It was comments that were presented to you for the piling waiver, where at that time, thank you. If you can go to the end, I believe it's around 14. Continue. Next slide, please. Next.
At the end.
Next. Okay, comparison graphics. This next slide. This is interesting. With the waiver approval, you can see we're well short of the line by 1.8 feet. I just took the sketch and did on the right side, should you deny the waiver approval, you're not removing the dock. All you're doing is asking it to be shortened to 25 feet. So should you deny the waiver, you see in black there would be a 25 feet. Let's say I decide, 25 feet of floating dock doesn't solve my purposes. I take the dock out. I also showed in blue, which would be option 2 for a denial, putting a boat in that it comes right to the line, whether that's the outboard or the boat. I just schematically drew a boat. But look at the left and look at the right with the boat, and tell me there's a difference, and one on the left is a claim that it impedes navigation, but yet I can put a boat on the right showing the line of the blue, which doesn't impede navigation, and the objectors have nothing to say about the boat on the right. Just using common sense and logic, it doesn't make any sense that you deny the waiver and then I put a boat as shown in blue. Next slide, please.
Okay, you have to conclude your remarks.
Okay. Next slide. This is going to the length issue that was presented for you in the documents for the waiver.
Right.
Next
You
slide.
already made this presentation. We already heard this. What is it that you want to use to rebut what was said?
The length of the piles from the property line. Because what I did under
But the
Mr.
pilings
Rogers,
are not an issue. The pilings are not an issue. The issue is the dock.
Exactly.
Right.
So what I did is I took a tape measure from, I would assume, sworn testimony of Mr. Rogers of how far the two pilings on each side of my dock extend out, and I took a tape measure beyond to measure to the end of the dock, and using Mr. Rogers' measurement for the piles, I am within the 36 feet.
Okay.
So
We're not measuring from the piles. We're measuring from the property line.
But he measured from the property line to establish the piles. So all I'm doing
But the piles are not the issue, sir.
I know. But
So
I'm
why do you
telling
keep bringing them up?
Because it establishes the distance from the property
No,
line.
it doesn't. What establishes the distance from the property line is when you start you start from the property line and you go into the waterway.
Exactly.
Pilings have
the
nothing
next
to do with
slide,
it. Okay.
I think this will show it.
All right.
Here we go. Piling K and piling L are the two piles. Mr. Rogers certified under oath that those structures from the property line are 26.3 and 26.3. I took a tape measure, which gives me just under 10 feet to the end of my dock. I am well short of that 10 feet from what Mr. Rogers certified under oath that he knew where those piles were.
Okay, so, Mr. Diorio, let me explain something to you. The issue here tonight is whether or not there are extraordinary circumstances to allow you to extend 30% into the waterway. That's the issue.
Yes, sir.
Okay. The pilings and all that other stuff, the measurements can ultimately be made after it's determined whether or not you qualify for the extraordinary circumstances. The measurement can be made after that point. We're not there yet. That's a secondary consideration. If this commission determines that you qualify for the extension, then we can go out with the tape measure and figure out where that lands. Okay, that's the only issue we have to determine tonight. Okay.
I will say again, staff.
I don't want you to say anything else.
Board.
All right. We've taken up all the time tonight. We've been on over an hour onto this. I have to extend the meeting again because we're at 11 o'clock. I appreciate your enthusiasm and your interest, but I got to move on. So may I please ask you to sit down and so let Mr. Dunkel speak so we can conclude this matter.
Yes, sir.
Thank you, Mr. Dior.
I would like to mention that
I don't want you to mention anything else. Come on, we got to be respectful of our time
Yes,
here.
sir.
Thank you. Do I hear a motion to extend the meeting?
Moved.
Do I hear a second?
To 11:30.
Okay. Do I hear a second? Please call the roll.
Mr. Beasley Pittman? Commissioner Sorensen?
Yes.
Commissioner Herbst? Vice Mayor Glassman?
No.
Mayor Trentalis?
Are you leaving now? Okay. Okay. Mr. Dunkel.
David, can you hear that? I feel compelled to respond to some of the issues that Commissioner Herbst has raised because I feel it kind of calls into question my professional integrity in front of this commission. And I think that we need to go back and look at this issue of go out and get a boundary survey. Let's look at that in context. Why were we thinking in terms of getting a boundary survey? Because we were trying to establish what the distances were from the property line. Now, a lot of people are thinking surveyors, tripods, rods in the ground and electronic distance measurements. And that's one way of doing it. But that's old school. There are other ways of doing it. GPS is another way, which is used much more frequently. However, what I've just handed you is I need for you to take a look at the first plat, Section A, Lauderdale Harbors. I think it's been said that it was 1935. In fact, I believe it was 1925. What's interesting about this plat is that where Cordova Road is, it's designated as proposed federal highway. That's where the Coral Ridge is that runs all the way down. Anyway.
You're taking us way back.
Yes, I am. And quite frankly, you and I have examined title chains. And I remember one time finding a difference in a title chain in Rio Vista, and the explanation from the surveyor was, well, they used wagon wheels back then. Okay, so then we go to the next one, which is a re-subdivision of blocks 11 through 14. When you start out with Lauderdale Harbors, you find that on the face of the plat, there's a measurement between block 10 and block 11, the river, and it says 105. And I ran across this, and I went, wait a minute, why does it say 105 when I see other things that say 118? So not because I was trying, as John would say, help the other side and having the city do the survey. I wanted to know for my own sake because I want a proper record in front of you. So I went to Michael Donaldson. I go, I don't get it. It says 105. What's going on here? And he then went in and looked at the re-subdivision of blocks 11 through 14. What they did in that is the original plat had these lots at 125 feet. When they replatted, they reduced the width of the length of those from 125 down to 105, which made up the 15-foot difference between a distance of 105 and 120. And that's how, the other question is, okay, well, things change over time. If somebody is going to add more or take away, we've got subdivision regulations. It might trigger a replat. This is our starting point in real property analysis are the platted property lines. Then the last document in here, you will see something that's part of the recorded declaration condominium declaration. It's page 129 of 132. And this is a document that's been prepared for the benefit of the condominium association. And it shows property line to property line 120. So I'm supposed to exercise my independent professional judgment, and I do in this manner. I think between those two concepts, I am satisfied that there is a property with a property line to property line of 120 feet. That's all I have to say.
Okay, great. All right, so we have closed public hearing, correct?
Hang on, Mayor. I just want to address that. Bob, I want you to know that I would never question your professional integrity. Not now, not ever. I've worked with you for the better part of 20 years, and I have the utmost respect for you.
I just have to call the roll.
Okay, let's call the roll.
Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst? Yes. Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes, and public hearing is now closed on PH4. Would someone like to introduce a resolution?
I'm going to introduce a resolution to deny based on lack of extenuating circumstances and other factors.
Okay.
Do you mean extraordinary?
Extraordinary, thank you. Extraordinary.
It's okay.
Extenuating.
Well, I think it's best to use the language in the ordinance, so extraordinary. Okay.
Yep.
Okay. Anyone have any other comments with regard to this matter? There being none, please call the roll.
A resolution of the City Commission of the City of Fort Lauderdale, Florida, denying the application by Nicholas Joseph DeLorio and Sharon Lynn DeLorio's husband and wife for a waiver of limitations for an existing floating vessel platform extending a maximum distance of 34.4 feet plus or minus measured from the property line into the adjacent waters of the Cerro Gordo River pursuant to Section 47-19E of the City of Fort Lauderdale Unified Land Development Regulations for properties located 1414 Southeast 12th Street, Hemingway Landings, condominium unit number 2C, slip 11, Fort Lauderdale, Florida 33316. Commissioner Beasley Pittman?
Wait, before we vote, can I just ask one question, Mr. DiOrio? Mr. DiOrio, can you come up here? When you purchased this property, were you aware that there was a code violation for the installment of this floating dock?
No, sir, and there was no code violation.
There was no code
No, I
violation?
purchased in April of 2023, and the board called out code enforcement for my dock and for the pilings in May of 2024, after Mr. Lilly complained.
Okay, and was there a permit for the floating dock that you're aware of at the time that
Yes,
you...
sir.
There was a permit for
Yes,
the
sir.
floating dock?
And approval of the board in writing, and an Broward County Environmental General License, which was required by Broward County. Again, no building permit required for floating docks.
Okay, thank you.
Not just in mine, but throughout the city.
Okay, thank you, sir. Please proceed.
Commissioner Beasley Pittman?
No.
So just for clarity, we're voting for denial. So if
Right.
you vote yes, you're voting for denial. If you vote
Understood.
no, you're voting for approval.
Correct.
I just want to be clear. Okay.
Yes. My answer is no.
Thank you. Commissioner Sorensen?
Yes.
Commissioner Herbst? Vice Mayor Glassman?
Yes.
Mayor Trentalis?
No. Okay, so that denial is approved by the commission. OFR 1, first reading, ordinance amending the City of Fort Lauderdale Code of Ordinances regarding the establishments permitting partial nudity, so forth and so on.
What do you mean, so forth and so on?
I'm too tired to read the whole thing.
Oh.
So we have two people sign up to speak. Is Carla Roundtree still here? Yes.
She is.
And then followed by Ellen Bogdanoff.
Good evening. Hello.
Yes, go ahead.
Good evening. Mayor Trentalis, Vice President Glassman, Commissioner Hurst, Commissioner Beasley Pittman, and Sorensen. My name is Carla Roundtree, and I'm a resident in District 2. I'm an advocate for all districts.
Speak in the mic, Carla, just so everyone on TV can hear
Can you hear me? Oh, yeah. Let's talk about the TV. I'm here to give my opinion on OFR 1. I thought about presenting a visual. However, I didn't want to be kicked out of the building. So I'm curious on how, as a woman, there is and will be a difference on how someone views partial nudity and nudity. If a woman follows the guideline of cleavage exposure and covers the lower portion of the breast, the oral size and cup size can vary. So it can be circular or oval. What or how will this be enforced? What would be the description? And could you please have comments on YouTube? And I thank you. I had so much to say, but I am tired.
Okay. All right. Well, this is not a question and answer period, so does that conclude your comments? Okay. Ellen Bogdanoff. I can't hear you? Okay. Well, she had questions. You're not here to prepared to answer those questions? Okay. All right, so there's no closing a public hearing, so anyone else wish to speak on this item? All right, there being none, would anyone from the commission like to comment on this?
I would, Mayor. So one of the conversations I've had with Ms. Bogdanoff and with Mr. Spence is that I want to make sure that in reading the intent of this ordinance, it's designed for people that are practicing nudists or naturalists. This is intended not to be anything that is related to sexual activity. The concern that I have is that this doesn't become a swingers club at some point down the road. We've had experience with that before, and I don't want to see that happen. I saw that happen to a hotel when I lived up in Jacksonville that had a nightclub attached to it, and they would host a swingers party every Friday night. I don't want to see that become part of this. So Ellen and I have talked about that. One of the things that I think we may need to consider, and I think we can look at this between first and second read with Dwayne, is just making sure that there's no advertising of any activity that would ever have anything to do with a sexual nature. Obviously, we can't control what people do behind closed doors, but if there's going to be alcohol involved in the nightclub or the bar, I don't want this being promoted in that way. So that's the one concern I have. And Ellen, if you want to just address that, I'd appreciate it.
You're good. You're good.
It's good. Okay. My client has no problem with the language. I can work with Dwayne to see what language we can put in there so that there won't be any advertisement with respect to any sexual activity. This is just people like to, and it's only at the pool area right now. It's everybody has to be clothed within the hotel. All of the employees have to be clothed. This is just about nudists.
Any other questions? Okay, thank you.
Dwayne, so if we allow this from a legal standpoint, are we allowed to control advertising or tell people what they can promote or advertise, or help me understand what those parameters are if we actually go ahead and approve this change?
So it wouldn't be anything different than what we do in terms of like vacation rentals, and in the sense of saying if you hold yourself out, our code presently prohibits certain sexual conduct or activities associated with alcoholic beverage establishments, but adding a provision that ensures that the establishment doesn't hold themselves out to conduct that we've already prohibited would be permissible.
So obviously it says nudity, sexual conduct prohibited, but are we able to constrain any kind of marketing or advertising that just is advertising the fact that this is allowing that there's a pool with partial nudity and alcohol served? I mean, are we able to get into the weeds like that?
What would be proposed is making it unlawful to advertise, promote, or otherwise suggest to the public that the clothing optional hotel is a place at which sexual conduct or activity in violation of that code section is permissible.
But they would be able to advertise just the mere fact that
they're clothing optional, absolutely.
And alcohol is served at the pool.
That's correct.
Okay, thank you.
Any other questions? Okay. Someone like to introduce the ordinance?
Introduced.
The ordinance has been introduced. Please call the roll.
In ordinance of the City of Fort Lauderdale, Florida, amending subsection 5-28 of the Code of Ordinances of the City of Fort Lauderdale, Florida, entitled Location of Establishments Permitting Partial Nudity, and subsections 5-28.1 entitled Nudity, Sexual Conduct Prohibited, to provide an exception for alcoholic beverage establishments that are accessory or ancillary uses to clothing optional hotels, providing for definitions, providing for severability, providing for conflicts and repeal, and providing for codification and correction of scrivener's errors, and providing for an effective date. Commissioner Beasley Pittman? Not present. Commissioner Sorensen?
Yes.
Commissioner Herbst? Yes. Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes, and that's approved on first reading. OFR 2, ordinance amending the City of Fort Lauderdale Code of Ordinances, Section 25, Streets and Sidewalks, to update sidewalk installation requirements. No one is signed up to speak. Someone like to introduce the ordinance?
Introduced.
Any further questions? There being none, please call the roll.
In ordinance of the City of Fort Lauderdale, Florida, amending the Code of Ordinances of the City of Fort Lauderdale, Florida by amending Chapter 25 entitled Streets and Sidewalks, Article 2 entitled Construction and Repair of Sidewalks, Section 25-45 entitled Definitions, Section 25-57 entitled Specifications, and Section 25-62 entitled Requirements for New Development and Site Alterations to modify the criteria requiring the construction of sidewalks and providing a new procedure for relief from the requirement, providing for severability, repeal of conflicting ordinance provisions, codification and correction of scrivener's errors, and for an effective date. Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst? Yes. Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes, and OFR 2 is now approved on first reading. Finally, OSR 1, second reading, an ordinance amending Section 26-161 of the Code of Ordinances to establish a fee structure for permanent and temporary parking removal for on-street parking. Someone like to introduce the ordinance?
Introduce.
No one's signed up to speak. Please call the roll.
In ordinance of the City of Fort Lauderdale, Florida, amending Section 26-61 of the Code of Ordinances of the City of Fort Lauderdale, Florida, entitled Rates and Hours for On- and Off-Street Parking, revising the Zone 2 boundaries for applicable resident and non-resident parking rates, establishing a parking mitigation fee structure for the temporary or permanent removal of metered on-street parking spaces, and providing for severability, repeal of conflicting ordinance provisions, and an effective date. Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Commissioner Herbst? Vice Mayor Glassman?
Yes.
Mayor Trentalis?
Yes, and OSR 1 is now approved on second reading. Is there any further business of the commission?
Yes, quickly, Mayor, just to touch back on our tunnel conversation, I talked with Mayor Furr in between some of our meetings today.
Yes.
And here's a possibility I just want to share briefly, is the county's very much interested in crafting an LPA, locally preferred alternative. What would help them, they're very understanding that we want a tunnel. What they would like to do is for them to be able to move forward with an LPA that would allow us collectively to explore all funding options and explore the options to move forward. They would write the LPA, and it would basically be connecting the hospital district to the north, the crossing, and then going north. And they are comfortable if we just have a quick discussion here about supporting heading towards that direction, giving the county the flexibility in crafting this LPA, and then us, working together with them around funding options.
Well, I think what he was saying was that when we apply for federal or state funding by stating that we have agreed on a locally preferred alternative, all that means is that we agree to cross the New River without indicating which option.
Exactly.
So I thought that we were going to bring that up at our joint meeting, but we can't vote on anything right now anyway. So my concern is I hope this doesn't take us down a path where we find ourselves committed to one option or the other, especially since the county wants us to move towards a bridge option. But if it's simply to say, well, we want to cross the river somehow,
right?
Because we are, I think, committed we all have agreed that commuter rail is important.
Right.
And so in order to complete the commuter rail line through Broward, it has to go through Fort Lauderdale, and it has to navigate itself under the river.
Right.
So, but I don't know what that looks like, and they haven't presented anything to us in terms of language, so we can't really vote on anything tonight. But I was kind of waiting. I didn't bring that up today because they were going to present language to us to vote on at some future date.
Right, and they completely agree with you, Mayor. And I think just by having us having just a brief discussion right now, saying that, hey, we're open to this possibility, we're open to them crafting an LPA to then bring to us, focused on flexibility, optionality, crossing the New River. I think that will then allow us collectively to work together, and especially for us to really continue to advocate for the tunnel.
Okay, and it's interesting when he proposed that. It was a little contrary to what the folks at US DOT had told me. U.S. Department of Transportation said you must identify a locally preferred alternative. You can't just say, "Oh, we're going to pick something."
Right.
So if they feel that they can move forward with the U.S. Department of Transportation using just that language, then I agree with you. Let's move forward with that.
Agreed.
But every indication, all the last 4 or 5 years that I've been dealing with them, they've always said you have to pick a specific alternative. But
Yep.
we'll just go with it and see how the language can be crafted, and then we can make a decision to vote on it.
That sounds good. Yeah,
So
Commissioner.
understanding that we're basically back to the either or verbiage.
So
that's correct.
For this language, for this LPA,
They are.
They are.
Yeah.
We're still
we're not an or.
we're still driving the tunnel, but this allows the flexibility to pursue funding.
Right. Begin the application.
Begin the application process. Okay, great. Thank you all.
Any further business of the nothing? Is there any closed door session? Okay. Meeting concluded. Shut